Good morning, ladies and gentlemen. I welcome you to the second day of the Big Tech Accountability Summit. You're most welcome. We are a bit late, so we are going to start immediately. Day 2 is going to be, yesterday we were talking about data privacy, data rights. Today we are going to be talking about competition. And we are going to have our first panel discussion. The panelists are already here. And we shall be looking at gatekeeping and abuse of dominance by big tech platforms. I'm going to invite the moderator to come so that we start immediately.
Good morning, everyone. Good morning. Some energy. It's lovely to have all of you here. I hope you are as excited as I am for today because we are covering competition law. And I think that's a market we are all involved in, even though we like it or not. We are all involved in the competition law space as consumers or as producers. So my name is Ganyana Shiba. I am a lawyer at Cavenbridge Advocates, and I'm also the business development manager there. And I will be taking us through a session today where we're talking about gatekeeping and abuse of dominance by big tech platforms. So I'm excited about this panel today because it's quite an interesting one, and we're going to cover a lot of topics, and the people on the panel are also quite knowledgeable on the space of abuse of dominance by big tech platforms. Many of them have been involved in many cases partaking to this. And just to shed light on the topic for today, for those who don't know, because we're going to use a lot of legal jargon, but I want everyone to be able to participate. So before I call upon our keynote speaker and also our panelists, I'll just want to give you guys a brief introduction so that we're all on the same page. Just by show of hands, can I just see, do any of you guys know what digital competition is, or do you have a clue? Yes? No? Okay. Just to run it through, we are going to be talking about gatekeeping and abuse of dominance by big tech platforms, and we'll be focusing on digital competition. Just a simple definition of digital competition is just simply the way businesses compete in the digital and online markets. So it's basically fair competition on the internet, if I could put it that way. So we'll be having our panelists who I am going to call up on stage. Allow me to briefly go through their profiles for the benefit of our audience. We are going to be having retired Honorable Justice Henry Peter Adonyo. Unfortunately, he's unable to join us today, but he has sent a representative who is going to give us his speech. We are also joined by Mr. Jeremy. Oh, yes. Thank you. Yes, so let me just briefly run through justice's profile. Dr. Henry Peter Adonyo is a retired judge of the High Court of Uganda. He concluded his judicial service in 2024 and is widely recognized for delivering several landmark decisions in complex commercial disputes that have shaped the Uganda's jurisprudence. Notably, he became the first judicial officer in Uganda's history to adjudicate in a matter involving competition law principles in the landmark case of Easy Money Uganda Limited versus MTN Uganda Limited. So basically, in this case, he awarded Easy Money over 2.3 billion UGX in damages for anti-competitive conduct. Yes, he has sent through his representative who will be going through his presentation for us. We also have Mr. Jeremy Jordan. He is a partner at Gerardine Partners, and he is highly experienced in competition law and practicing. He has served as a director of competition law and public policy at Skipset. Please pardon my accent because these are French words. Marketplaces partner, White and Case in Brussels, and an official in the European Commission's hearing office. His practice covers antitrust, merger control, and digital regulation, including DMA, DSA, Data Act, and AI Act. Welcome, Jeremy Jordan. He is online, so he'll be joining us online. Yes, the third person I would like to call upon is Mr. Leonard Otunye from Nigeria. He is the principal partner of Lex Economics Advisory. It's a specialized law firm in Nigeria focusing on competition law, consumer protection, and international trade law. He has over 18 years of extensive experience and has advised national governments, regional institutions, and private sector stakeholders in Africa. He is a highly respected authority in these niche areas. Welcome, Mr. Leonard. He will also be joining us online. Some hands, guys, for our speakers. Thank you. Our fourth panelist shall be Mr. Jeremy Andre. He is a founder of Agentic SaaS, a French technology company that developed Simon, an AI-powered personal assistant designed to democratize access to artificial intelligence through messaging platforms, particularly the WhatsApp Business API. He currently serves users across Europe and Africa, including a significant user base within the COMESA region, with virtually all users accessing the service through WhatsApp. He's a CEO of a startup, AI chatbot operating on the WhatsApp ecosystem. He's actively participated in several high-profile competition law investigations. He has contributed as a third-party witness and informant in the European Commission's investigation case involving Meta and allegations of exclusionary practices. So welcome, Mr. Jeremy. He's also online. Oh, sorry. Pardon me, I hadn't seen you. Welcome, Mr. Jeremy. We're glad to have you. And I would also like to invite our keynote speaker who will give us opening remarks. He's a representative from the Ministry of Trade and Cooperatives. We'll welcome Mr. Ezra Mugabe. All right. Thank you. So, Ezra, you can give us your opening remarks, then we'll begin. Sorry, just a correction. Mr. Ezra is going to present the paper for retired Justice Henry Adonyo. So please welcome him on stage.
Yes. Good morning. Ladies and gentlemen, it is my pleasure to be here. My name is Ezra Mugabi. I am a lawyer by profession, a partner at Alba Advocates. I am here in the stead of Dr. Justice Emeritus Henry Peter Adonyo, who is also a consulting partner at the firm. He sends his sincere apologies for not having made it today for the panel, but he is bereaved and he is away because he lost a loved one in the family. His task was simple today. He was tasked to present a paper regarding his role in shaping Uganda's competition jurisprudence and the lessons that he took. I'll quote verbatim a few issues in his paper, which I've already forwarded to Mr. Aziz for circulation. Here we go. I quote verbatim. My role in shaping Uganda's competition jurisprudence. Justice Adonyo was the presiding judge in the Easy Money versus MTN Uganda case of 2013. He says, the Easy Money versus MTN Uganda case occupies a unique place in Uganda's legal history. It was not only the country's first successful abuse of dominance litigation, it was also a moment in which the judiciary confronted the realities of market power in a rapidly evolving digital economy. As the presiding judge, I found myself at the intersection of law, economics, technology, and public interest, a position that demanded both doctrinal clarity and judicial courage. My role in shaping Uganda's competition jurisprudence began with recognizing that the dispute before the court was not a conventional commercial disagreement, but that I was confronted with a case about market access, innovation, and responsibility of dominant firms. MTN's termination of Easy Money's communication lines, refusal to connect its aggregator, and imposition of exclusive dealing arrangements were not isolated acts. They were parts of a pattern of conduct that foreclosed a smaller competitor from participating in the mobile money ecosystem. At that time, Uganda lacked a dedicated competition statute. This absence did not mean that competition harms were beyond judicial scrutiny. Instead, it required a creative and principled application of existing laws. In this case, they used Uganda Communications Act, doctrines of unfair competition, and tortious interference principles to address conduct that clearly distorted market dynamics. In doing so, the court, then Justice Adonyo, affirmed that competition law is not confined to statutory labels, but that it is grounded in the protection of market fairness and economic opportunity. One of the most consequential aspects of the judgment was the treatment of locus standi. In that case, you may recall, MTN argued that Easy Money lacked standing. It could not sue MTN because it was not a licensed communications provider. He, Justice Adonyo, rejected that argument because, in his considered view, competition harms extended beyond licensed operators. Innovators, aggregators, and emerging firms often rely on access to essential facilities controlled by dominant actors. Denying them standing would have insulated dominant firms from accountability and stifled innovation. In other words, it would have been bad law. By affirming broad standing, the judgment aligned Uganda with global best practices and ensured that competition enforcement would remain accessible to all market participants. The case also underscored the importance of economic literacy in judicial economic decision making. This is because competition disputes require an understanding of market definition, requires an understanding in dominance, foreclosure effects, and counterfactual analysis. They also demand a judge who can interpret economic evidence and appreciate the broader implications of exclusionary conduct. Through the Easy Money case, Justice Adonyo came to appreciate that competition law is as much an economic discipline as it is a legal one. The impact of the judgment in the Easy Money case did extend far beyond the parties involved. It influenced the drafting of Uganda's Competition Act of 2023. This is 10 years after the case was instituted. It informed subsequent regulatory actions, as you are all aware, and it became a reference point in academic and policy discussions across the region. It also demonstrated that African courts could as well address digital market abuses, even in the absence of specialized statutes, and that judicial independence is essential in confronting powerful incumbents. Looking back, Justice Adonyo believes that his role in shaping Uganda's competition jurisprudence was not merely for resolution of a dispute. Through the resolution of the Easy Money case, where he awarded the very many billions, three things were achieved: the articulation principles that would guide the country's economic governance for years to come, the affirmation that dominance carries responsibilities, that markets must remain open, and that innovation must be protected at all times and at all costs. The demonstration that the judiciary can play a decisive role in safeguarding the integrity of digital markets. The Easy Money case taught Justice Adonyo, in that case, that competition law is ultimately about fairness. Fairness to innovators, fairness to customers, and fairness to the economy as a whole. It's a lesson that continues to resonate as Africa confronts the challenges of big tech dominance, digital gatekeeping, and the future of economic regulation. Justice Adonyo briefly states that the lessons of the Easy Money versus MTN Uganda case, as he reflects today, are shaped in this case. Briefly, in this case, we already know who the dominant actor was or is and what they were trying to do. Particularly in the matter, we relied on a letter that MTN, sorry for name calling, wrote internally, saying the reasons why they were switching off some of the platforms that Easy Money was using was because Easy Money was a direct competitor of MTN in that space. So that is why Easy Money ran to court, talked about unfairness with the competitor, albeit them being the controllers of the platform. He says, my reflections today are shaped by a case that has become widely recognized as Uganda's first successful abuse of dominance litigation. This, as you may know, was the first case regarding this axis or this sector of the law, especially in competition. And at that time, we didn't have the Competitions Act. When that case came before the High Court of Uganda, the Commercial Division, Uganda didn't have a dedicated competition statute. Then the digital economy was still emerging. Mobile money was slowly transforming financial inclusion. And yet, the dispute presented a question that was both simple and profound. How should the courts respond when a dominant actor uses its market power to foreclose a smaller competitor? From the onset, I caught the good judge. I became well aware that this was a case that demanded more than mechanical application of statutory provisions. Two things were required: an understanding of how dominance works in digital markets, how exclusionary conduct harms innovation, and how essential facilities such as mobile money rails can be weaponized to restrict competition. Judicial courage, judicial activism, doctrinal creativity, and a willingness to confront powerful incumbents whose influence extended far beyond the courtroom. These are his experiences. One of the most important lessons he learned from the experience was that competition litigation was fundamentally about market structure. That the case was not merely a dispute between two parties before him, but a staple subject that indeed affected the entire ecosystem of innovation, consumer welfare, and economic opportunity. In the Easy Money case, the foreclosure of a single competitor had implications for the development of Uganda's fintech sector, the openness of mobile money markets, and the future of digital financial services. We all know how it would have massively negatively affected the markets, should it have gone the other way. Another lesson learned was the importance of broad local standi in competition matters. That dominance harms not only licensed operators, but also aggregators, innovators, and emerging firms that rely on access to essential digital infrastructure. By recognizing that any entity excuse me for that. By recognizing that any entity harmed by anti-competitive conduct had a standing to sue, the High Court then affirmed the principle that it is now widely accepted in modern competition law that is, competition protects markets, not just the regulated entities. The case also proved that sectoral laws could be used to address competition harms in the absence of a dedicated statute. The approach by the High Court has since influenced these other laws that are sprouting out. In conclusion, ladies and gentlemen, the good judge concludes by saying the lessons of the Easy Money case are therefore not historical footnotes. They are guidelines for the future, reminders that African courts can and must rise to the challenge of regulating powerful actors, protecting innovators, and shaping the trajectory of our digital economies. Thank you very much for listening, and thank you very much.
Thank you so much, Ezra. Can we have one last round of applause for him? I think he delivered the speech wonderfully, and I think we can all agree that Justice Adonio's case really was the landmark case for competition law in Uganda now, especially when it comes to digital competition. So many advocates quote it now and use it in their proceedings for the cases that are coming up now. So we thank you again, Ezra, and we also thank retired Justice Adonio for taking time to give us that wonderful presentation. Yes, so let's dive right into our discussion. With that, I would like to pose a question to Mr. Leonard, Councillor Leonard. Is he online?
Yes, I am.
Yes, yes, Leonard. Hi.
Hello.
Yes.
Happy to be with you.
Yes, we're happy to have you as well. So, given the presentation that has just been said, the question we have for you would be, how would you, given your vast experience in the market right now, how would you describe the current landscape of digital competition enforcement across Africa?
exclusionary conduct, and those theories are not is coming up here and there, but I think at the moment enforcement is not the main game in Africa right now. I think the main game is trying to understand the market, and I'm particularly vocal and also active on the ground in terms of market studies. For example, there's the AFCFTA, the market study that is ongoing, design the regulatory framework for digital platforms under the AFCFTA. So it's about understanding the market, it's about mapping the market, mapping the conducts, and see what the impacts are on the ground. So the approach right now is still more of understanding the market, more of mapping the market, more of fine-tuning the laws to adapt to the challenges of the digital markets. But enforcement, yeah, we expect more enforcement actions, or more, at least more complaints and investigations to be opened soon. Thank you.
All right, thank you, Councillor Leonard. If I could just summarize what you're saying that in Africa as a whole right now, it's more important that right now we focus on understanding the market, and then we can move on to, as we also try to enforce, but focus on understanding the market and how we can come up with laws and regulations that will help guide us more in enforcement. If I've understood you correctly, yes?
Yeah.
Oh, yes. That's wonderful. Thank you so much. Can we have an applause for Mr. Leonard, please? Thank you. So I want to move on to our second speaker, Mr. Jeremy Jordan. I don't know if I'm pronouncing that well. Because Jordan. Ah, okay. I'm going to practice. Yes. Is he online with us? Yes. So before I can ask you, I just want to tell our speakers, let's try to keep our answers 5 minutes minimum because we are running behind schedule. But despite the limited time, please try and squeeze in the most important details. So, Mr. Jordan, having served both as a regulator within the European Commission and as counsel in the landmark competition cases involving Meta, Google, Apple, and Broadcom, what insights from your European experience should African competition authorities adopt when they are enforcing against big tech gatekeepers?
Thank you.
Sorry, Jordan, give us a moment. Let's just adjust your audio. Yes, tech team. Give us a moment, please. Okay, say something now.
Can you hear me now?
Yes. Please restart.
looking at quickly the markets move. And this was a case that created enormous harm for price comparison sites and aggregators that were harmed by Google's self-preferencing conduct. Many of them today are seeking compensation for the harm, and hopefully they will be compensated for that. But the harm to the market has been there. Today, Google Shopping, the box on the top of the search page, is the reference price comparison site for many consumers, right? And so the damage to the market was done and was maybe will be compensated financially, but not in a competitive sense. Innovation suffered from it tremendously. So speed is a very important element in those cases. And I think, the recent case against Meta, in which the Commission has used interim measures, is for me, an important case to keep in mind. Action has to be quick, and interim measures is a tool that can be utilized in these circumstances, and is really something that the competition authorities in Europe are not using enough, with some exceptions. I think the French Competition Authority and the Italians have shown willingness to use those tools, but the European Commission was so far reluctant. So I was very pleased in the case I've been working on against Meta that the Commission did choose to impose interim measures. But more generally, I think this is a learning for the authorities also in Africa. This is a tool that needs to be used in order to quickly stop anti-competitive conduct. And, on the back of that, of course, the other important point is remedies. The European competition authorities, in particular the European Commission, have, in my view, failed to remedy properly some of those competition cases they brought against big tech. It's nice to have a decision finding an infringement and it goes in a big fine. That gives you the headline in the newspapers, but it doesn't solve the core competition problem that's at the root of the case. So it is very important for competition authorities to focus on remedies rather than just finding infringement. And I think that applies equally to African competition authorities. Then I'll make a last point, because I know you asked us to be brief, but coordination is also key. And it was very interesting to me to hear the previous speaker, Mr. Lerner, talking about that as well. Competition authority, big tech tends to have practices that cover large geographic areas because those companies are global, and it happens in Europe. And in Europe, it makes little sense to have national competition authorities taking individually cases against big tech. It doesn't really work. It may work in one country, but then it doesn't solve the problem in the other countries. The problems are regional, if not global. So they need to be solved at that level. And so it's very important that the competition authorities in Africa get together, talk about those problems, maybe prioritize the most important ones, because there are many of them. They need to prioritize the ones that harm African society and African businesses the most. And then they need to try to tackle them together, because that's the only way you can actually, in the end, impose remedies on a pan-geographic, on a pan-regional basis, which ends the problem for everyone. Right? So those are very important principles. It is happening in Europe to some extent. It should definitely be something that the African competition authorities learn from. And also giving a credit to Mr. Lerner for the last point he made about market studies, right? Competition authorities must get together as they take place in Africa, right? You need to make sure you tackle not abuses that are tackled by the European Commission, but the ones that are tackled that are important in an African context. Right? And they may not be the same. So draw inspiration from Europe, but make sure you're tackling stuff that matters for Africa.
All right. Thank you so much, Mr. Jordan. You've made some really, really good points. At least if I can summarize for the audience, is what I get from you is it's a learning curve, and the big tech companies that side are very resourceful, so we also have to be vigilant in the way we handle the matters here. And in doing that, we have to look at the changing environment. As you mentioned, that the environment is ever growing, so the laws have to also adapt. I think this is a task for our regulators to adapt with the changing environment and make sure that laws align with that. So we have to change our laws. We also have to focus on the core principles. I think you mentioned fairness, which is something that stood out to me. It's and Leonard also mentioned it. Retired Justice also talked about the principle of fairness. So we have to remember the core principles of the concept as we are tackling cases that bring in abuse of power and dominance. And we also have to come up with remedies that actually fix the problem. I like that you talked about that, because like you said, many times, yes, these cases will like make headlines in the papers and you'll be like, oh yes, we sued Meta, we sued Google, but what are actually the remedies? Have you actually gotten a remedy that, you know, that justifies the crime? Then I also liked that you mentioned we should solve regional problems as a team. As Africa, we should come together, because you know the famous saying, teamwork makes the dream work. Yes. So we should come together as Africa and solve these problems as a region. And I like that you tied up that with the market research, because in as much as we are borrowing from the European states, we have to remember that we are addressing these problems as Africans. So we have to make sure that we address our problems and see what are our issues and how best can we solve them as Africans, not as Europeans. So I like that you tied that up with that, and thank you very much. I hope our audience is enjoying. Are you guys still there? Yes? Ah, yes, lovely. Okay, so let me move to Andre. Have I pronounced it really well? Yes. So, Mr. Andre, you participated in the COMESA Meta AI investigation. Why would you say that that investigation is very significant for startups?
So yeah, I was interviewed by the COMESA as an affected operator on this matter. So there is multiple aspects. The first aspect, as a previous speaker said, is the fact that we cannot fight 21 individual fights. It's absolutely impossible for a company to be able to have users in Africa and make this having this COMESA back. We need to have one fight, because it's very impossible to have so many different fights. And about this, I want to say one more about the market structure of B2B versus B2C. Because, you know, like in our mobile phone, we probably all have basically like the same application, you know, like X and Meta and WhatsApp and stuff. So it's to say that when you are launching a B2C product, usually it's either you go global or you go home, because you cannot just like, okay, having some successful B2C product in one defined zone. So yeah, for me, this aspect to have one fight instead of 21 is the most important, and that's why the COMESA is very important for companies that have users in Africa and that want to defend themselves against gatekeeping from big tech.
All right, thank you so much for that. If I understood what you said properly, it's better because most startups are really small, so it's better if they come together and fight these companies as a unison, because they get better results than if it's small individual companies trying to fight one.
Yeah, exactly. I think this part is very important, because like, for example, in the EU cases, there was Microsoft, OpenAI, the interactive company, many companies that are competitors, but that could understand that they had a common goal, which was to be able to exist, because the objective of big tech was nothing less than, in that case Meta, was nothing less than closing the market to only one operator that was in itself, like I mean the Meta AI. And yeah, so I believe it's very important for startups to come together. And I was discussing with Harrison Godfrey, with an attorney about competition in USA, so on a big tech land. And he told me that for him, the situation is getting really stronger. I mean, like the big tech really want to grasp the whole value chain. So this is something that is really new. And like in the example of WhatsApp has always been a platform, but today it's becoming an editor, because, you know, if you discuss with Meta AI, basically you are using directly a Meta service. And we can do the same observation regarding Google and AI overviews, because Google has always been a platform where you are using to go to another site, but now you can, it's no more a search engine, it's an answer engine. So this dimension of taking the whole value is very scary, because what will happen when there will be no more competitors? So it means that the only remaining big tech can literally do whatever they want. They can increase price, they can continue to rebuke new competitors. And we know that for users, for consumers, the competition is really good. It makes quality improving, it makes price decreasing. So in the end, the consumer is the one that gets the value of this competition and of companies fighting not for a policy, but fighting to make the best product and to deliver the best service at the best cost and the best price.
Okay, thank you so much, Andre. I love what you said there, because you brought back the fact that, because many of you in this room may not know that this competition affects us as consumers. You may not be a producer, but it affects us in the long run. You're the one who will pay the price. If there is a dictator in the market, they can choose to hike the market of products up, and in the end it is you who will spend so much money. But if there's an even playing field for all companies, you get better value for the products you pay for, better prices. So this is a fight that we all have to be engaged in, and we should all take interest in. Thank you so much, Andre, for that. Just to still on you, I know you have a company, a startup, Agentic SaaS, yes? Yes, so Mr. Andre has a startup, and basically they have an AI platform. They developed an AI platform. Mm-hmm. So I'd just like you to tell us how Meta's conduct, how did it affect your startup?
Yeah, so basically from one day to another, Meta decided that it will simply shut down access for all competitors, all generalist AI providers. And the interesting fact, let's say, is that at the exact same time, Meta was investing and promoting its own generalist AI assistant. So it could be just a matter of timing, you know, but it's hard to believe. It's I think the most common thought when we see it is that we can just see that Meta is taking a market for itself. So it's not like they will ban some competitors or some actors because they think it's I don't know, like illegal or something. It's literally a ban that goes straight to their pockets because they shut down the competitors and they can grasp a market that competitors have been creating, because it's a classic tradition at Meta's office to let the competitors let's say like dig the market, show that it's working, And once the competitors have been proving that the market is here, that there is a demand, they just come up and take it all, or at least try to take it all for themselves. What's interesting is that 2 days ago, Mark Zuckerberg was giving an interview, and he wrote an article where he say something. He say, it isn't whether superintelligence will exist, but who will have access to it. So, I mean, they do understand what's happening. They just pretend that they want to do this for such reason, but they know that the accessibility to AI is paramount, and because today, while we could believe in this room that the whole world population is using AI, there is less than 20% of the population that uses AI every day. It's really crazy, and it's up-to-date numbers. So yeah, but just like think about maybe some aunt or some cousin or some, I don't know, like some people you know that they will never use ChatGPT. Like I know that some person of my family, they can use computer, but they will never be interested in downloading ChatGPT, for example. So it means that WhatsApp is their only gateway to access AI. So basically, when Meta is blocking other generalist AI assistants, it's also blocking the access to AI to a large part of the population, with the consequences that we can imagine, because we know that having AI is a superpower today, and being forbidden to use AI by one way or another is something that will impede you in your life.
Hey, thank you so much. You mentioned a very important, something that surprised me. I don't know if the people in the audience heard, but he said, the statistics say that less than 20% of people in the world use AI.
Regionally, yes.
Really? Regionally?
Yeah.
Do people in this room use AI? By show of hands. What? It can't just be a few of you. Thank you. Yes, Teresa will see. Okay, that's quite interesting. Thank you so much, Andre. So I'll just want to take it back to Mr. Ezra. Yes, Ezra is representing retired Justice Henry Adonyo. But I want to ask you this question in your capacity as Ezra, because you showed some vast knowledge on the topic itself. Would you say that should African judges receive specialized competition law training given the circumstances?
Thank you very much. Yes, they should, and for basically two reasons. Conventionally, the judiciary or judges, we used to go to them for the conventional justice, all right, to determine rights. But as time has evolved, you cannot separate the judiciary from economic development, but also general development of all the sectors of life that we're discussing today. So the major aspects in life right now is that we have to equip our judges to be up to the task and help spark innovation, growth, encourage competition, and by and large promote this aspect of helping startups to also catch up with the big fish in the industry. Secondly, through judicial activism, if a judge is well equipped with this knowledge and in training, they will have the understanding of handling such a matter. It's by no means complex. You have to, I'm not aware that there are very many judges that are in Africa that have this knowledge, this specialized knowledge, and without training, you'll obviously not give the justice that is deserved. So yes, and very much so, all the judges require to be trained to serve us better. I thank you.
All right, thank you for that. I think I have nothing else to add on your submission. Just a task I would put on the regulators in the room. I know I see some representatives from some of the regulators. Please train our judges. Please train them. And let them be well equipped to handle these cases, because it is not good, like Mr. Ezra said, if a case comes before them and they have no idea what is going on. So I like that she's lovely. I love that. Can we have a round of applause for that? Thank you, thank you. I'm sure Mr. Samatasa will take us through all the programs soon enough after this panel. I would like to go back to Mr. Leonard. Is he still with us? Yes, Leonard.
Yes, I'm here.
Oh, yes, lovely. Yes, so Leonard, from your perspective as a celebrated digital competition practitioner, what forms of abuse of dominance are becoming most common among big tech platforms operating in African markets?
Okay, thank you. Permit me to leave my video of trying to get into a taxi to the airport. I'm really so sorry about that. So I think the common abusive practices have been highlighted by the panelists. One of them is the exclusionary conduct or denial of access to essential facility, depending on how you look at it. And the classic case is the case of a digital platform that is ordinarily designed as a public or as a public-facing facility for other platforms, then deciding to close off access to other to the businesses that rely on their services to reach the customers. And this is easily done through the restriction of API, so you basically block them access to your to use your interface. The second one is about what you could call exploitative extraction. And that's when the big tech, whether Google, Meta, or whatever, use online publishers' content to either respond to search or, as we see now, happening more now, using them as AI overviews, which makes it even aggravated because in the former cases where they use those contents, at least they direct you to the site of the content owner, the online publisher, and then the online publisher earns through clicks and advertising. But with what is happening with AI overview, you could actually get the entire answer, without going to the website of the content owner. What this means is that the content owner is not able to attract enough traffic and not able to attract enough advertising revenue. So it's like capturing the value of what belongs to another person, basically robbing the owner of the content. In this case, the online publisher, whether video publisher, whether newspapers and all that. Then you also have the cases of
Yes, Leonard, it appears we've lost you there. Hello. Okay, I think we've lost him. Hopefully he'll be able to join us. But as we wait for him, maybe we can hear from Mr. Jordan. Is he still on? Jordan?
Yes, I'm here. I'm here.
Yes.
Yeah.
Oh, lovely. Okay, Jordan. As we wait.
I'm sorry. I'm back. My network went off. Can I go ahead, or you want to pass and go to the next person?
Please go ahead. You can conclude.
Okay. So those are the kind of emerging abusive practices that we are seeing. And if you go back to the Nigerian Meta case, and that's about the exploitative use of data. Now, the role of data in the digital economy is central because it reinforces, like I said in my first intervention, it creates and reinforces market power. So the more user data you have, the more you the more users or the more use you can make of that data. For example, in the case of Facebook, the more people come there, the more data they have, the more they can monetize the data in terms of advertising, targeted advertising. But that's not all. The other part of it is that at the other side of the market, which is where you and I use the services for free, the more people they have on the platform, the more they are able to attract. So that's like the network effect. Now, where you are in a position to hold data because you have a first mover advantage. Now, newcomers into that market. So imagine a new startup, African startup, for example, trying to compete in the social media market. That startup will need to have access to the level of data that Facebook has, or the level of users that are on Facebook to be able to compete against Facebook. Or a new search engine starting up, say, somewhere in Kenya or somewhere in Kampala, trying to come into that market. That new search engine, to make economic sense at all, would have to have access to some search history, some search data that Google has. And this is the kind of thing that the EU DMA, for example, is trying to solve, to create a level playing ground to ensure that the companies that have operated in one market have become dominant do not leverage that dominance to stifle competition in downstream or in adjacent markets. And by that I mean in markets that rely on their services or markets that are closely related to what they are doing. Thank you.
All right, thank you, Leonard. Just before you leave, because I know you're on the move, I just wanted you to give us briefly your top 3 priorities. What would be your top 3 priorities for digital competition enforcement if you are advising African regulators?
Yeah, of course, that's the work I have done for the past few years. And what I've said this earlier, and Jardin, if I got the name correctly, also emphasized on this. And that is the fact that, and also the last speaker, the startup person, I'm sorry, I forgot the name now, also emphasized on it. And that's the fact that there's need for coordination, because digital market is not like the traditional market where effect or where harm can be localized. In digital market, and especially when you're dealing with the digital global platforms, the conducts are usually span across countries. And the harm also spread across countries. So what that means is that it is only logical that they are dealt with in a cross-border manner. So getting African regulators to begin to think in terms of coordination. I know there's a lot of work happening there. And that's where the importance of the AFCFTA competition policy protocol comes into place. Because what that competition policy protocol seeks to do, especially Article 11, that focuses on digital platforms, what it seeks to do is to have a continental approach towards enforcement, where investigations, where remedies are designed at the continental level. This has several advantages. Let me mention some. Number one is that there are certain competition jurisdictions or certain national jurisdictions in Africa that would never have the capacity in the next, say, 10 to 15 years to be able to address harm caused by anti-competitive practices in the digital market. So there's a capacity problem, first of all. There's also a political economy problem, which says that the size of the market is important for digital economy, for digital markets regulation. If your market is too small, for example, for a Meta to care about your market, there's no incentive for Meta to abide by your regulation, because when the WhatsApp case came up in Nigeria, Meta threatened to pull out of Nigeria, So imagine if they could threaten to pull out of Nigeria. So imagine for a country, say, like Gambia, which is less than 2 million people, but when you approach it from a continental perspective, then you have more market power as a continent to be able to not just investigate and enforce, but to also negotiate For example, what the UK did recently after their market inquiry was to extract obligations, commitments that then turned to obligations on Google, especially in cloud services. Now, without adequate market size, you will not be able to do that kind of enforcement. And finally, I would say that capacity building is critical. Capacity building. We need a lot of capacity to study the markets and understand them, capacity to enforce. And most of our competition authorities are under-resourced. So the capacity is a big problem. And well, I know I've said finally, but let me add this to say market studies. I'm an advocate of market studies. We should do market studies that are both continental, regional, and that are also country-specific market studies. And I'm happy the AFCFTA is taking the lead on that. And I happen to be the person conducting that study to understand the market and to design the framework for digital market regulation under the AFCFTA. So those are the my top recommendations. Thank you.
All right, thank you so much, Mr. Leonard. I think you've summed that up really well. And what I have understood from this and what keeps coming back, I don't know if the people in the audience have noticed, is the fact that all the panelists have emphasized coming together in unison to actually come up with these competition rules and fight against these dominant dictators in the markets. So that's an important thing, you know, there is power, there is strength in numbers. So I think that's something I've really seen that keeps on coming up, and also market studies, studying our market and seeing what suits our market and what laws actually suit our market. So thank you, Mr. Leonard. I think we can let you go to the airport, have a safe flight. I would like to bring it back.
Thank you.
Yes. I'd like to bring it back to Mr. Jordan. Yes, can you hear us, Jordan?
Yes, I can hear you.
Yes. So Jordan, you represented one of the complainants in the Meta AI chatbot investigation. And you have also been widely consulted by AdLegal, who were gracious enough to host this event for us. What impact do you believe this investigation will have on digital competition enforcement in Africa? And what key lessons should regulators take as AI-related competition cases continue to emerge in the continent?
Thank you. I will have to keep it short also, because like Mr. Leonard, I also need to catch a taxi quite shortly. So there's a few things here. First of all, I'd like to give some credit to AdLegal for bringing the case that you mentioned, the case against Meta in Africa as well. It's a global case, it's a global issue, and it's one where we've seen regulators in several regions of the world acting, and that was really it's almost a first, I think, to see this kind of coordination. You had Italy, the European Union, which is now handling the case for the whole of EU. You had Brazil, you have Turkey, and you have COMESA, of course, doing the case. So I think this is a fantastic example of how competition authorities, you know, beyond even Africa, globally, should get together and coordinate in order to act against big tech. This kind of practice has the same effect, more or less, around the world. So that's aspect number one. I think it's a very good case for the COMESA to take as well, because, as I think was mentioned before, it's a case that brings in several problematic types of conduct. You have access restriction, you have tying, you have self-preferencing. So it's a case that is really, will potentially help COMESA build its practice and its decision-making practice in several areas. So I think that's a very important case, and I really hope COMESA brings it to the finish line. I think it's also definitely a key case because it's in the area of AI, and we all know that it is very important that at this early age of this area, this sector, that big tech, which essentially monopolized, the digital world that we knew before AI, doesn't do the same now. And they have the means to do that thanks to controlling key infrastructure like WhatsApp, for example, for the use of AI in messaging channels. But also if you think about search, or other infrastructures, right? So this case is very important because it showed that the regulators acted quickly in order to avoid that a distribution channel of AI be monopolized even before the market emerged. There's only a few companies right now that are using WhatsApp for AI, and Jeremy André's company is one of them. My client was another one, but there is a channel that Meta itself recognized as massive potential. And therefore, it's very important that this channel is preserved and that innovation can flourish on this channel. I think that's one of the key learning of this case. And the use of interim measures and quick action is also, I think, a learning for this type of cases. It is really key that the regulators act before damage can be caused, before the companies like Meta can monopolize this type of channel. I'm afraid I'm going to have to run, so I have to leave it there. But if you need to know more about the case, Jeremy André is on the panel with you or in the room after the panel, and he knows everything about this case. So he and I have been battling this case side by side. So you're in safe hands with him. Thank you very much again for the invitation. I will unfortunately have to disconnect very quickly now.
All right. Thank you so much, Mr. Jordan. You have given us such great insights, and thank you for joining us. We wish you a safe ride in the taxi. And thank you so much to our panelists. Mr. Andre, I just want you, just in 1 minute, give us your closing remarks representing the startup community. Just 1 minute.
So for me, I have nothing to add because my other speakers, I've told what is really important. Meaning cooperation and like real-time cooperation to be able to handle the case in multiple jurisdictions. It's very important. And as Jeremy Jordan just said, the interim measures is paramount because otherwise you can have procedures that will last 5, 10, 15 years. So if the time is on the side of the big tech. So what is really, really important is that the legislator takes it in account to have decision that can unblock the situation in less than 6 months. And actually that was the case in EU. And I think it's really, really important because otherwise it's impossible for startup to be able to have visibility or to grow in proper condition. And I think it's very important to startup to be able to grow so that competition will continue and that in the end consumers will be the ones that will benefit from this competition.
Thank you so much, Mr. Andre. I think you've put it wonderfully. We put it on our regulators to come up with the best policies that can resolve these issues in the shortest time possible. And in the end, this will benefit not only the business owners, but also the consumers. So I think that wraps up our panel. It was a lovely discussion. Thank you so much to our panelists. You did so wonderfully. And I think we've all, at least personally, I have learned a lot. I hope our audience members, you've learned a lot. I would have loved to hear questions, but we are running out of time. So any questions, just send them to the AdLegal email. I'm sure the team will respond to you. Yes, thank you so much, everyone. Thank you. Oh, wait, I think we'll have a picture moment. Just 1 second.
A round of applause for our panelists. That was very, very beautiful. So we are going to have a working breakfast. They've started serving breakfast. So you could go and get breakfast, but it will be a working one because we are out of time. We are going to have, this session was supposed to be yesterday, but they missed out. Civil society and public interest. Advocacy as an enforcement trigger how civil society and public interest litigation drive big tech data protection accountability in Africa. I'm inviting this panel to come now so that we begin immediately. The civil society panel.
Good morning, everyone. Okay. Just connected. Okay. Good morning, everyone. My name is Yasmin Ahmed, and I'll be your moderator for today. I would like to introduce my very brilliant panel today. Though we do apologize for moving the panel today. We were around yesterday. Unfortunately, due to time constraints, we were not able to hold this panel yesterday. But on this panel today with me is Raymond Amumpaire, who is a Ugandan lawyer specializing in digital rights, AI governance, data protection, and technology law. He is the team lead at the Center for Artificial Intelligence Ethics and Governance in Africa, also known as CIGAR, and contributes to several regional and global initiatives on AI, privacy, and digital governance. Raymond is a complainant in the landmark privacy case against Google before Uganda's data protection regulator, and is also involved in ongoing digital rights litigations challenging Uganda's 2026 internet shutdown. He has advised governments and international institutions on data governance, cybersecurity, and AI policy, and is widely recognized for his work advancing digital rights and accountability across Africa. Raymond?
Thank you, Yasmin. Glad to be here.
And right next to me is Patricia Inembabazi, who is a policy and advocacy officer at CIPESA, where she leads initiatives focused on digital empowerment, internet and data governance, digital public infrastructure, tech-facilitated gender-based violence, as well as universal periodic reviews. She has commendable experience working in the East African community, SADC regions, and the United States of America in human rights-related work. She is an expert in research and policy advocacy, international human rights law, data governance, and internet governance, particularly within restrictive environments. She holds a Master's of Laws from Middlesex University, UK, and MBA from East and Southern Africa Management Institute, ASAMI, a bachelor's degree in journalism, as well as other disciplines of education and pieces of training.
Thank you, Yasmin.
And finally, on our panel today is Dr. Faith Amarachi Okpara, who is a legal scholar and practitioner specializing in data privacy and protection, intellectual property, and family law. She serves as vice chairman of the Data Privacy Lawyers Association of Nigeria and is a research associate at the Association of Privacy Lawyers in Africa, where she contributes to advancing privacy and digital rights discourse across the continent. A recognized speaker and moderator, Dr. Okpara has led numerous discussions on data protection, regulatory compliance, and digital governance. Her work focuses on the role of civil society, public interest litigation, and regulatory accountability in strengthening data protection enforcement across Africa. She is an alumni of the WIPO Summer School and Harvard University's Patent X program, and was recognized in the 2024 World IP Day Changemakers Gallery as a leading IP professional in Nigeria. Dr. Faith will be joining us online, and I hope she is available right now.
Thank you.
Okay, so welcome everybody to our session today on civil society and public interest litigation and how it is driving big tech data protection, accountability across Africa. So the thing with data protection in Africa is, whilst a lot of African countries have moved forward and rushed towards creating data protection laws, while different African states have moved forward to creating data protection laws and regulatory authorities, we still see there's a lot of gaps, there's a lot of issues when it comes to how these rights are enforced, how big tech is held accountable, and so on and so forth. So I would like to start with Patricia. Yeah? Sorry. So Patricia, as a civil society representative, you know, why has advocacy become such an important trigger for enforcement today, as opposed to, you know, what was envisioned before when data protection was, the data protection laws were passed?
Thank you, Yasmin. Once again, I'm Patricia Inembabazi from CIPESA. Just a quick about CIPESA. It's an acronym. It stands for the Collaboration on International ICT Policies for East and Southern Africa. So we do work across the continent, much as our name only talks about Southern and Eastern Africa. Advocacy has emerged to be one of those good things and well-praised practices across the CSO section. Two things. We do more than what most of you do in the room. We do evidence collecting. We make more noise on what you're doing. And I would like to say it's a full circle. We wouldn't work without the lawyers that do the litigation. While we do the documentation, the trainings that we're talking about with judges and lawyers that are talking about digital rights across the continent, we go further talking about training parliamentarians, working with the African Union, given the different resolutions that they're pushing out when it comes to digital rights across the continent, some sort of popularizing what is being done out there. And as such, we have, as CIPESA still, we have cultivated some sort of good relationship with the big tech companies when it comes to how they work with African people, African countries. By way of hand, I would like to know how many of you have attended our annual conference. We always have an annual conference of CIPESA, at least once, maybe ever? All right, that's a good number for now. I'm sure it will grow. However, it's called FIFA, and it's nothing to do with football or soccer. It is the Forum on Internet Freedoms in Africa. We have this every year, and for this year, we are going to be in Mauritius. Last year, we were in Namibia. The year before, it was Dakar. So we are always in different parts of the continent. Reason why we are more inclusive, we want to reach the different parts of the continent. And some of the conversations that we're always having there is such as this. How is the big tech treating the people in Africa? How is the relationship? Are they understanding the laws of the land? When Google is here, is it respecting Uganda's laws? Is the African Union also looking at what the big tech is doing on the continent? I know for this year, if you do plan to come, this is actually an open invitation. You're welcome to join us from September 28th to the 1st of October in Mauritius. And we do have at least 4 sessions that we'll be talking about. We'll do have a litigation surgery with the usual suspects, media defense, the Pan-African Lawyers Union, and other practitioners. So AdLegal, this is your time to shine. Come join us and bring this expertise we see here. We'll have Google. We always have Google there. We have Meta. We do have Microsoft and the other big tech. Why do these people have an appetite to come and engage with the people that attend FIFA? It's because they actually do respect end users. I know even yesterday and earlier today, I got a feel of the case law that's been in the EU and other regions. For Africa, I like that when I read the first booklet that they sent over, it's actually good that someone is documenting this, and that also gives us like a white flag to always wave around when we're talking about these kinds of practices on the continent. And during those 4 days, when I say we'll have Google there, I'm not saying we're going to be having the top people. They always send the lawyers that are dealing with human rights, policy, product managers, compliance, and in the room, you get to ask questions and you get the answers there and then. From the previous meetings that we've had with members from representatives from the big tech. An example from Meta, there was a complaint where Africans, we are not filing as more complaints as we should be doing. Yeah, so we do have the Meta Oversight Board always, and I believe also this time we'll have them. So if you're there, you have all these questions, you'd like to learn more, it's an invitation, you'll have them in the room, and you'll get all the answers. The other thing that we've done, and I've seen closing out the advocacy loophole, or yes, it's a loophole that we've been having, is training judges. CIPESA is doing this, we are doing this at the East African level. We were in Arusha just this year in April. We met them in their sessions in Kigali. We've trained the ones in SADC, and it's a continuous practice. We call upon other practitioners in here, join us. We have the expertise when it comes to data protection and privacy. The more the merrier in the section to do this. So advocacy is not here to replace regulation or regulators. It's, think of it as a means to end. It's something that we need in the practice when we're talking about upholding digital rights in Africa. Thank you.
Thank you so much for that, Patricia. Actually, as a person who attended the Fifth Africa last year in Namibia and actually sat in with, when the Meta Oversight Board was making its presentations, it was quite an interesting conversation, because for the most times we tend to think they are not listening to us, or they're not, they're just all the way up there and we're all the way down here, and that, our complaints will get nowhere. And it was quite interesting to hear their perspective from the African continent, and how complaints and reports were being made, especially to the Oversight Board, and how they were handling things like that, especially when it comes to, Africa's cultural diversity and, how it applies to the digital space. Speaking of advocacy and how we can use advocacy to ask for accountability, to push big tech to account for its actions, especially here where, we're always worried about, how we affect the bottom line of big tech. That being said, I would like to then direct my question to Raymond. Your decision to challenge, Google being one of the world's biggest tech giants, was definitely significant. But what motivated you to pursue, the complaint? What did you hope to achieve? What was, where were you mentally when you were, going to this case?
Thank you so much, Yasmin. My name is Raymond Amumpire, as has been introduced. I'm a lawyer around town here in Kampala, and it's a pleasure to be at Adligo's event and to adambulate about the meaningful work that we've been doing. So for those who are not well acquainted with the Google decision, 4 Ugandan data activists, Leni Sharon Pamela, Awino Masi, Frank Sekamwa, and I, dragged Google LLC before the PDPO, who is the sector regulator mandated under the Data Protection and Privacy Act, CAP 97, with the mandate of executing the act, with a complaint that was threefold. First, we asserted that Google had not registered with the PDPO, as was required of all data collectors and controllers, as defined in the Data Protection and Privacy Act, CAP 97. We also tackled the issue of cross-border data transfers, which was said a lot yesterday and which has been said a lot on many fora, including the Forum on Internet Freedom in Africa, organized by CIPESA, which I've been privileged to attend in Namibia last year, and something else to do with remedies. So when we came up with the gist of the case the very first time, we were guided by a number of factors. One, we came in knowing that Google is big tech, as the name of the summit says, right? Big Tech Accountability Summit. We know Google makes profits all over the world that equate to the GDP of Uganda many times over in minutes or hours across the world. But really the essence was around pushing for digital sovereignty, and I know this was said a lot yesterday. How do we assert our digital sovereignty as Ugandans? But also, is it okay for us to leave the power that big tech has unchecked? So philosophically speaking, this was a question of power that we've always had, but power this time in a tech realm that moves at a very high speed and can have dire consequences. Speaking about privacy, dignity, and the downsides of all that power, such as surveillance, etc., that could happen. We asked if, because this was brought in the interest of the public, we asked if it was right for Google to go ahead and carry out operations in Uganda, whereas not respecting or complying with the municipal law of the nation. Of course, it was no surprise because big tech is thousands of miles away in Silicon Valley in the United States, headquartered there. Not that it's only present there, but it's very many miles away from Uganda. But we had also seen the tendency of the Trump administration, and I'm not trying to be political, of not being interested in engaging at a multilateral level also play out in this case. So we brought the case for platform accountability purposes, brought the case to test the laws of Uganda. We have the act. Is the act good? Does the act work well? And indeed, we had very many lessons that we learned from there, but also issues to do with institutional accountability. We have the PDPO. We didn't have that many complaints coming to the PDPO on the record. The national director for the PDPO was here yesterday and talked about some of these issues. So we tried to test that. And I'm happy to say that we secured the win. Google appealed the win, but our act is crafted in a weird way. Appeals don't go to the High Court from a quasi-judicial body like the PDPO or the regulator. They go to the Minister of ICT, who at the time was Chris Baryomunsi. So Google appealed, but later withdrew their appeal. So that was how we come to bring the case. Platform accountability, institutional accountability on the part of the Data Protection Office and regulator in Uganda, but also for digital rights issues. Should big tech conduct business and negate aspects of human rights? And CPESA has been very vocal on issues to do with business and human rights in Uganda. So those are some of the tenets that underpinned our case. And before I conclude on that, if you read 1984, the book by George Orwell, who is famed for Animal Farm, but 1984 as well, Orwell cautions us about systems, the panopticon, okay? Systems that have the power to watch without being questioned. Google collects a lot of data. From location data, they moved from my home in Kulambiro to come to Fairway Fast, or they know I made a stopover at CJ's to have a cup of coffee, or maybe a meeting. They have all this data when you move around. Health apps, for the ladies that use Flow and the rest, you will register with your Google account, right? It's easier than putting in an email and a password and you'll forget the password. This time, etc. So you have health data, you have location data, you have the work that we exchange on our emails. All this data is in the trove of Google. And for a tech company to have all this information and run unchecked is something that we saw as not right, hence bringing this case. Happy to share on more aspects as we go forward with the panel. Thank you.
Thank you so much for that, and it's quite interesting to see what advocacy can achieve when done right. But still anew, but very quickly, Raymond, maybe you can tell us some of the challenges you faced while you were undertaking this litigation process. Just very shortly, because we're very short on time.
Yeah, thank you. So, of course, there were a number, before I head to the challenges or whatever, there was a number of strengths that came out of this case. First, we understood that we have a regulator who is a designate body under the law to handle matters such as ours, and that the regulator is active and they actually work. We also got to understand that rights of citizens aren't just in the laws, but are in the way we test the laws for the protection of these rights, because the citizenry has to have confidence in some of these laws as protecting them. If you remember the social contract theory, we cede power to under Article 79 of the Constitution and others, enact laws for the good of the citizenry. We also saw that there is an aspect of the law being argued to actually protect rights. But some of the weaknesses we saw, one was around penalties. If you look at the Data Protection and Privacy Act, for those who are data privacy practitioners, those who may not be but are interested in the area, when you look at the Act, we have very, very small offenses, and I want to say it this way. Small offenses do not threaten big tech. So you have a 2 currency points fine per day for every day a violation goes on under the regulations or act, the law read together. In a year, that would be 365 times 2, which is around 700, 800 currency points. Convert this at the current rate, you have around 5,000 USD. So, if the fines are so small that in a year Google could just pay 5,000 US dollars for non-compliance, then you have a lack of incentive for big tech to comply with some of the laws. Google can make 5,000 US dollars as we see it, be it from ad revenue or whatever, in this room, across the world in seconds. Google will make 5,000 USD. So Google will happily violate, happily not comply, and keep outside the reach of the PDPO because fines are small, such as 5,000 US dollars. And John Austin, for those who did jurisprudence, we remember that John Austin telling us that the law is the command of the sovereign. Law is the command of the sovereign backed by sanction. So if sanction is not good as to incentivize one to follow the law, then you have an issue. The second was around remedies. The Act gives us a number of remedies, but regrettably the Act robs the regulator of the power to actually issue fines. We've had the competition panel that happened in the morning. We also had a number and a series of panels that happened yesterday. We've had a number of things about penalties, We've sued Meta, Baba, Oga Olomide was telling us yesterday, Babalola, that they had millions of US dollars fined in Nigeria. But for Uganda, the PDPO lacks that authority. So the most they can do is decide on the case or decide the case on its merits, and then for remedies, give you a few orders, but orders are to issues of like compensatory orders, compensation, etc. These are outside the reach of the PDPO. So you'd have to go and get remedies from another body by taking your decision and maybe getting a consequential order. For those of us that deal with the civil procedure. I was actually trying to drum this into the minds of the new legislators who will be sitting on our ICT committee yesterday when I talked to members of parliament at the Uganda Internet Governance Forum at Sheraton. We need to amend some of these laws and bring some of these things forward. Then something else we saw was the issue around poor communication. Of course, there was poor communication on the side of the PDPO, which is why again we brought it as an institutional accountability aspect. And lastly, as I conclude, an interesting fact that I did not know before the case, and in all fairness to the regulator, because at a point I think we became unfair to the regulator in the way we were pushing for our decision. One, there is a tendency to misuse the right to a fair hearing. In civil procedure, if I sued Aziz, and Aziz was a defendant, when they receive a summons, they have 15 days within which to respond. If they don't respond, the lawyers in the room, you get a default judgment or an ex parte judgment, as the case may be. In this case, we saw a tendency of the regulator handling big tech with, I don't know if it was FIA or if it was kid clubs, but extending the fair hearing aspect towards the year. You bring a case in October 9th, 2024, Independence Day, because of digital sovereignty, I mean. November 8th, you go to the PDPO and lodge. From November all the way to July 18th, 2025, you have no decision and you've been pushing. Secondly, the issues, the multidisciplinary issues to do with resource allocation, okay? PDPO was not well empowered. PDPO has, under the budgetary vote for last financial year, not sure about this financial year, but I'm sure about last financial year, the budgetary vote for the PDPO is less than $30,000. $30,000 again is money Google can make very, very fast. So they do not have enough money for resources, but also you have 30,000 versus someone that makes 30,000 in seconds. It puts that clawback on the PDPO in Uganda as compared to the ODPC in Kenya or the NDPC in Nigeria, and how they like do their operations. Thank you.
Thank you. Dr. Faith, apologies for making you wait this long. As a person who has worked across Africa in different disciplines, my question to you would be, how would you assess the current state of big tech data protection in Africa and the accountability that is? And are we making meaningful progress, or are there enforcement gaps that we need to, like, take a look at?
Thank you so much. It's an honor to be here. I would say the current state of big tech data protection accountability. Can you hear me?
Yes, we can.
Am I audible?
Yes, we can hear you.
So, okay, thank you very much. The current state of big tech data protection accountability in Africa presents a picture of real measurable progress, but the enforcement gap remains structural wide. And Nigeria illustrates both sides of that reality most clearly. So we have moved from beyond the stage where African data protection laws existed merely as declarations of intent. Regulators, courts, civil societies are increasingly using those laws to demand accountability from the largest technology companies in the world. But the sustainability, consistency, and depth of that enforcement still remain major concerns. Still remain, it's still a matter of a major concern. So on the progress side, Nigeria has recorded one of Africa's most significant big tech accountability outcomes through the joint FCCP/the NDP investigation into Meta Platform Incorporated and WhatsApp LLC. And this took place for over roughly 38 months of investigation. And they actually found the matter to be a case of abuse of dominance and unlawful exploitation of personal data, leading to corrective measures and a $220 million administrative fee. And this particular fine was subsequently upheld by the Competition and Consumer Protection Tribunal, which is the CCPT in FCCPT in April 2025. Also, in a separate NDPC action concerning behavioral advertising on Facebook and Instagram, a $32.8 million was also awarded as a remedial fee, and it was imposed in February 2025. But this was later subject to the November 2025 consent judgment, following negotiations between Meta and NDPC and the adoption of enhanced compliance commitments. So it was later turned to a consent judgment. So these two outcomes of the first a fee, administrative fee awarded of $220 million US dollars, and the one of $32.8 million dollars, shows that African regulators can actually extract real concessions from big tech, but the form that accountability takes, a binding judgment versus a negotiated settlement, materially affects how strong and durable that turns out to be. So this mattered because it demonstrated that African regulators are also capable of investigating them and applying domestic laws and imposing real consequences, challenging the long-standing assumption that big tech is too powerful, too global, or too distant to be effectively regulated in African jurisdictions. So the deeper question is whether these outcomes produce lasting structural change, and that is where civil society becomes essential. From DIPLAN point of view, because I'm the vice chair of DIPLAN, the meta consent judgment revealed continuing weaknesses in the enforcement ecosystem. So the DIPLAN's condition, or the position that we took, was that a regulatory sanction once imposed after a statutory investigation should not become a private bargaining instrument, extinguishable through a confidential settlement. So prior to that, or following that rather, DIPLAN issued a pre-action notice to the NDPC in December 2025 and subsequently commenced proceedings at the Federal High Court Abuja, challenging the legality and the public interest implications of the settlement on 3 grounds. 1, whether a regulator has statutory authority to compromise a finalized penalty already imposed under the NDPA 2023. 2, whether affected Nigerian data subjects and public interest stakeholders were sufficiently represented in a settlement that altered a major enforcement outcome. And also, lastly, I think the confidential settlements, which we talked about with the global tech companies, also set a dangerous precedent by weakening deterrence, allowing serious structural violations to be resolved without meaningful public accountability. So all of this illustrates a broader point, meaning enforcement isn't achieved by fines alone. Accountability requires transparency, institutional independence, judicial oversight, and continuous public scrutiny. So the gap also exists at the institutional level. Strong legislation doesn't automatically produce strong accountability. It requires functioning procedures, clear rules, technical expertise, operational capacity, and DIPLAN's own concern over the delay. This is another point that we also intervened in Nigeria as a civil society, lawyers, civil society group. We talked about, we brought to bear the section 40(c) of our NDPA Act, which was not being activated by our regulator. And our concern over the delayed section 40(c) breach notification regulation illustrates this. Many African jurisdictions have adopted modern law data protection laws, but implementation routine, most times it lags behind technological expansion. So the gap is sharpened further by a recurring observation that multinational tech companies often operate under stronger accountability, especially in jurisdictions like Europe, while African users get weaker protection unless regulators and civil society actively demand compliance, which is precisely why public interest advocacy remains necessary. And that is why we are having this discussion today. So at the same time, Nigeria's ecosystem shows signs of institutional maturity. The NDPC has expanded enforcement beyond the matter with recent actions against major organizations over unlawful data processing and cross-border transfers. A shift from isolated headline cases towards a broader compliance culture. So the pattern recurs elsewhere in Africa. I think in Kenya, there was this WorldCoin controversy that showed the civil society functioning as an enforcement trigger also. So with I think that matter bordered on the Katiba Institute. So the public interest actors challenged the collection of iris and facial biometric data on grounds of consent, impact assessment, and lawful processing. One of the speakers talked about, made reference to this case also yesterday. So converting an emerging privacy concern into a binding judicial determination. So when you look at Nigeria, Kenya, South Africa, Uganda, and all of this, it shows that the African institutions are no longer passive observers. Regulators are investigating, courts are interpreting digital rights. Civil society is challenging weak enforcement, but the enforcement gap remains wide because accountability cannot depend on exceptional cases alone. A $220 million dollar penalty is important. But the real measure of success is whether everyday practices change, whether citizens have effective remedies, and whether regulators retain the institutional strength to maintain oversight after the headlines fade. So the lesson from Nigeria and from Deepland's own intervention, I can say, is that civil society cannot be understood merely as an enforcement trigger. It must also serve as a permanent accountability mechanism, strengthening legitimacy where regulators act, and keeping citizens' rights visible where regulators hesitate. So the future of big tech accountability in Africa depends on the interaction of three actors: the regulators with enforcement authority, courts willing to interpret digital rights within constitutional and statutory frameworks, and civil societies capable of sustained public interest intervention. That combination, not regulation alone, will determine whether Africa moves from having data protection laws on paper to having meaningful accountability practice. Thank you very much.
Thank you so much, Dr. Amarachi. And one of the things I've loved from what you have said is that strong legislation does not always translate to strong accountability, because there is a whole system in place that is required to make sure that big tech is accountable for the actions and the work that it does. Circling back to Patricia very quickly. CIPESA works across different African states, and and has documented various digital rights violations and so on and so forth. And my question to you is: can you tell us what the biggest obstacles of civil society? What obstacles do you encounter, especially when it comes to holding multinational companies accountable in different jurisdictions across Africa?
Thank you. I think Raymond already talked about Google. For the case of Uganda, she has talked about Nigeria. Given the legal research work that we do, documentation of all these things, and the reports that we push out, I'm sure some of you have already interacted with some of our reports. Every year we always have the CIFA report, which is the state of internet freedoms in Africa. We always launch it at every annual conference, and it takes a whole year. Right now we have a team already working on what is going to be pushed out this September. And from the different countries that we always center on, there are different issues that you pick out. However, one common denominator remains jurisdiction, right? Having that fragmentation in the regulations that we have across the continent, it sort of works against us as Africans. And that is why at the African Union level, we have the African Union Data Protection Framework, which as CIPESA, we have been going around different countries with the support of development partners to domesticate and have this AUDPF used as it should be used. However, I mean, it's non-binding, and if you ask me what I think would be the next step, is perhaps having that as something more substantial, more than just non-binding guidelines. For the bigger part of last year and also this year, we've been in different countries across Africa. We've been to Lesotho, we've been to Namibia, obviously, South Africa, Liberia. This year we do have Malawi, Zimbabwe, and also Uganda, still to domesticate the AUDPF. Why is it important? It talks about the cross-border data disputes. And when you're talking about data protection, that is where you start from. The issue with jurisdiction, as talked about yesterday and also alluding to the same today, is the fact that we have all these fragmented regulations. While you may fight Google here in Uganda, they'll face the same in Burundi, and because they maybe have lesser manpower on the same, they'll be left behind. I'll use an example of Europe. She talked about public interest advocacy. Was it 2024 when they decided to ban the several charging cables in Europe? They insisted all companies, big tech, whatever, you have to have a Type-C, which we call the Type-C, right? The USB-C. So whichever gadget you're bringing in the region, you had to use that same. How did it come about? Advocacy, pushed by legislators. I think it was an MP from Malta. So it comes to a region, we can say maybe East Africa, you will not bring products that are not going to be working for such and such a country, and collectively we can see results. And at some point we have to understand that communication is only effective when you get feedback, right? And with advocacy, it's part of a chain. You're only advocating after you've done capacity building, and that's what we've been doing as CEPESA. In Uganda, we did capacity building last year, I think across the road at the Golden Tulip. I'm not sure if some of you were in the room. We were talking about Uganda's digital sphere or data governance. And from that, this year we're working with UNECA as well as the ministry to do ARIA. And then we'll see if Uganda needs a policy as well as the strategy and all that. So we are called upon, obviously, to capacitate, to help, to bring the technical expertise, because we've been doing this for a while. We live and breathe these kinds of things. We wake up to read policies, do the comparisons, advise, learn from others. And one of the things that I find it is maybe encouraging and sort of, it's encouraging for Uganda, is the fact that we do have a new minister for ICT, and yesterday it was my first interaction with her in the new office at the IGF, for those that were at the IGF. She has an appetite, she's willing to learn, and she has a listening ear. Being a politician, she could have been lying to us, but we are going to take that up, you know, we're going to use that and see how long we are and how far we can go with her. Because we've been in some countries where you bring out something and the minister is either tired or is like, you know what, let's do what we can with whatever budget. But when you're in an enabling environment, that alone is very encouraging. Now, one thing that I've also found very different in Africa is that the issue of funding, right? I'll give an example, too far, but the US. They do have a budget for CSOs. Why do they do that? Because they do understand the whole cycle of government, private sector, civil society in building a system. That is why you'll find at least maybe 10 or more organizations, CSOs, in Washington, D.C. They do have lobbyists, which I know is not a word in Africa or in Uganda, who are on a payroll for the Hill, right, which is the parliament or Congress. So you'll find someone on their timesheet, there is money or hours they'll spend at Congress trying to push for a bill. How do you even get that? It's what we were doing yesterday at Sheraton, what he talked about. We do have a new house, parliament, they work in different committees. So we do have the committee for ICT. The ICT committee normally has folks from the legal and parliamentary affairs, as well as human rights, then the ICT. So that cocktail, we need them in the room, do some sort of, maybe a crash course on the new trends in the digital sphere. Tell them this is happening, this is how far the different, the last committee, because they're always dismantled once that house goes away. Then, so you need the likes of Sarah Opendi that have been in the system to also bring that institutional memory, if you want to call it, and bring the other committee members up to speed. And obviously there'll be that one MP that will want to act very clever, to know everything, and will have an example or an answer for everything. But we have to be patient, right? As people in the space for advocacy and, I mean, policy advocacy, you have to be patient with legislators, show them what is being done, what other countries are doing, what Uganda can achieve in the specific time, and doesn't stop there. That's why we still, with development partners, we go ahead again now to talk to judges at the East African Courts of Justice, SADC, and other parts of the continent. In a way, when you have people that know what you're talking about, it makes advocacy easy. Even when you're writing the Universal Periodic Reviews and you're citing this and that, every November you're in Geneva, you have your 5 minutes, you're talking to the permanent missions, ambassadors, you have a track record to have done the capacity building, you're advocating for digital rights at the national level, which is the Uganda IGF, you have the Uganda Parliamentary IGF, that is the Internet Governance Forum, You have done that capacity building. You have had roundtable conversations. Then you have done the East African IGF, where now you're comparing yourselves to your peers in the East African region. And then later, because I know the East African IGF is going to be in DRC,
No, Burundi.
I believe
It will be in Burundi. It was changed because of the Ebola issue.
that's a good thing, because no one would want to go to Congo at this time. Your passport having a stamp from Congo, it works against you at least until the end of 2026. So either way, and then later you'll find yourself in Accra in Ghana for the Africa IGF. And even as I mentioned all these steps, you will still find a representative from the big tech. I know when my colleague here was talking about what Google can do and what they cannot do, and for some reason, I would like to believe that the fact that they have an appetite to show up for our events, to send a staff member from DRC, I mean from Washington, D.C., to come for 4 days, sit in your meetings, workshops, be active. To be honest with you, the difference between you and a representative from Google, from DC, the policy, they always send the policy and human rights officers or program officers. The difference between you and him is the fact, I mean, it's advantage or opportunity. He happens to work for them and you happen to work from the other side of things. And in some meetings, they are very much bombarded with questions. You find the person is sweating through lungs, they are talking, drinking water, and I'm thinking, it shouldn't be like that. Get to know the person, send an email, follow up, because the 4 days cannot be enough for you to get all the answers you need from these guys. And the fact that we've seen Microsoft has gone ahead to help CSOs and even other organizations with like seed funding, grants, and how to use their software. Google has a whole digital clinic, so they do care on what you're doing, but obviously I'm not saying that they're doing all good. That's why we are on the other side to always check, like checks and balances, see what they're doing, keep them in line. But all to say, yes, public interest advocacy helps. We've seen it work in Europe. I know when you're talking to Europeans, they're like, it's not a good example to use, but I was really amazed to see that the whole region could say, do not bring other chargers. So right now, your phone, your laptop, I don't know, Samsung, iPhone can use the same type of charger in Europe as opposed to Africa. Right now, your laptop has a different charger, like the whole house is full of cables, right? And that is something we can stop if you wanted to, and we can do that collectively. So when you ask the pitfalls, the good things, yes, we are doing the work. The pitfalls is about jurisdiction, the fragmentation in the regulations, and maybe the fluctuating appetite in harmonizing the AUDPF, because it talks about those cross-border data disputes, meaning that if you have a network of data protection officers, something can work. Yeah, thank you.
Thank you so much for that, Patricia. And we're coming towards the end of this panel session. Dr. Faith, very, very quickly, very, very briefly, I'm going to give you 2 minutes maximum, but can you tell me, how important regional cooperation among African regulators is when it comes to creating meaningful accountability? But very, very quickly, 1 or 2 minutes, please.
Sorry, please. I didn't get the question.
Oh, okay. So very quickly, how important is regional cooperation among African regulators and different stakeholders, including civil society and lawyers, in creating meaningful accountability?
Okay, thank you so very much. I would say regional cooperation is essential because big tech operations are inherently cross-border. While regulatory enforcement remains largely organized around national jurisdictions, a platform may process from millions of African users across several countries through the same platform, the same infrastructure, yes, algorithms and business models. A purely national approach therefore risks inconsistent outcomes, duplication of efforts, and enforcement gaps. Nigerians' experience demonstrates why connected institutions and networks are important. Deeplan's my association, our nationwide membership base provides an example of how civil society organizations can coordinate can create coordination across different jurisdictions through a national network of privacy lawyers and practitioners. We are able to identify recurring regulatory challenges, share legal strategies, and coordinate public interest interventions across different locations. The lesson is that accountability requires connected actors, not isolated national efforts. So at the regulatory level, Africa still faces challenges arising from fragmented legal frameworks and varying institutional capacities. The African Union Convention on Cybersecurity and Personal Data Protection, commonly referred to as the Malabo Convention, illustrates this challenge. Although it was adopted in 2014, it only entered into force in 2023, which we know after the required ratifications were achieved, and it does not establish a dedicated enforcement mechanism. So as a result, practical enforcement still largely depends on national regulators with different levels of capacity. Recent developments show the importance of regional mechanisms. The COMESA complaints filed by AdLegal International against Meta Platforms Incorporated and Meta Platforms Ireland Limited regarding WhatsApp business terms. They also demonstrate how regional bodies can address conduct with cross-border implications. So following that case, the complaint filed on January 2026, the COMESA Competition and Consumer Commission issued a formal notice of investigation on February 17, 2026, concerning allegations that updated the WhatsApp business terms that it affected third-party artificial intelligence chatbots providers within the COMESA region. So this type of issue extends beyond the single national market and requires regional oversight. So for Africa to achieve meaningful accountability, 3 areas require attention. Number 1, Africa needs a shared reference framework for digital accountability. This does not necessarily require identical laws across all countries immediately, but common principles on issues such as jurisdiction, which we've been harping on even from the time the keynote speaker spoke. We've been talking about the issue of jurisdiction, cross-border data transfer, lawful processing, consent, and regulatory cooperation. This will reduce uncertainty and avoid repeated legal battles over basic questions. Number 2, regulators need stronger information sharing mechanisms. A regulatory finding or investigation in one country should provide useful evidence and guidance for another jurisdiction facing similar conduct. I could remember when the keynote speaker also spoke. He talked about how when Nigeria didn't have any local precedents on some matters they were handling, how he was continually making references to decided matters, precedents from outside Nigeria, to use it to persuade the court towards arriving at the jurisdiction. So, for example, experiences from the FCCP, NDCP, MDPCS, our own regulator investigation involving Meta and WhatsApp. This provides valuable lessons for other African regulators examining similar platform practices. Thirdly, I would suggest the regional cooperation must include civil societies and professional networks, not only regulators. So public interest organizations often identify harms before formal investigations begin. So they collect evidence, they represent affected communities and test legal boundaries through advocacy and litigation. The growing cooperation among African data protection authorities also demonstrates movement in this direction. Then DPC's engagement with counterpart institutions through formal cooperation arrangements, including information sharing and enforcement coordination initiatives, reflects the type of operational relationship required for stronger continental accountability. The future of big tech accountability in Africa will depend on cooperation among 3 groups: regional bodies capable of addressing cross-border conduct, courts and tribunals capable of providing consistent legal interpretation, and civil society networks capable of maintaining public pressure and supplying evidence. So from my association's experience, DPLAN, this demonstrates the importance of the third element. Civil society should not be viewed only as a complainant after harm occurs. It should be recognized as a permanent accountability partner in Africa's digital governance ecosystem. Thank you.
Thank you so much, Doctor. So as we have come to the end of this panel session, I'll give you 1 minute to do your closing remarks. Strictly 1 minute. Please, you can give your closing remarks.
Okay, I would say as my final words, I would say the enforcement gap in Africa data protection will not close on its own. It closes through sustained advocacy, strategic litigation, regulatory accountability, collective action. So civil society has played the role of catalyst, watchdog, and public interest defender. The next step is building systems where regulators, where the courts, the industry, and civil society work together so that protecting African data rights becomes a shared responsibility, not a burden carried by civil society alone. Thank you.
Thank you so much. Let me get parting shots, closing remarks. 1 minute strictly each, starting with Raymond.
Thank you so much. A few things. One, as we push for laws that are reflective of the realities, I like George Orwell's literature. In Animal Farm, George Orwell talks about Sugar Candy Mountain, which is the ideal, right? But we need to realize that we do not live in an ideal society. So let's make our laws more reflective of what the lived aspirations of Ugandans are. 2, lobbying. Lobbying, and lobbying usually from big tech. This month in Geneva at the Geneva Digital Week and the United Nations Global Dialogue on AI, we're discussing some things to do with lobbying. The EU AI Act had provisions that were mandatory moved to an optional category due to lobbying. So lobbying is something else we need to look out for. Thirdly and lastly, public interest litigation alone by AdLegal, by other Ugandans against Google, whoever, is not nearly enough. What the CPESAs and the rest in the space are doing is what we need. More education, more research in the area, just aside from the litigation itself alone. Thank you.
Patricia?
Let's just move this conversation to Mauritius, guys. Let's meet in September. Let's be there just from the 28th of September to the 1st of October. 4 days on the island. Let's talk about technology, digital rights, and how we can help each other as a continent. Thank you. See you there.
Thank you so much to all the panelists for today. And if anything, today's discussion has basically shown that accountability does not lie in legislation alone. Yes, there's a lot of stakeholders at stake. There's a whole system that needs to be buffered, that needs to be, structured to handle accountability, especially when it comes to big tech. As we aim to innovate faster, we also have to remember that accountability is key. So if anything, I'm so glad that I was able to interact with this brilliant panel. And please, let's give a round of applause for the panelists today. And as I close this panel, my name is Yasmin Ahmed, and I'm a co-founder and director of programs for Femtech Law Initiative, an organization at the intersection of law, technology, and human rights. Thank you so much.
We are going to proceed. Our next session is one of the most after topics today, the role of a regional regulator. Ladies and gentlemen, unlike the previous panels, this session is special because we are yet to hear from the engines of enforcement. These handle conduct transactions like mergers, etc. The speakers are going to answer one big simple question. Big tech platforms run all over African continents. Should national regulators hold them accountable, or should regional regulators be the ones to hold them accountable, since they can do the job better? Ladies and gentlemen, allow me invite our next moderator. She's an advocate from ENS Advocates, and she'll be moderating the session. She will introduce herself and call and be the one to introduce our next panelists. You're most welcome.
Good morning once again, everyone in the room. Good morning, everyone online. My name is Renata Nyakairu. I serve as an advocate, an associate at ENS Advocates here in Kampala. ENS is a corporate law firm across Africa. We are based in 7 countries and we have 12 offices. Today, I think before we begin, I'd like to add my voice on those that have gone before me and thank the AdLegal team. Thank you to Aziz, to Luke, and your entire team for hosting this very important summit. It's a pleasure to be in this room and to moderate this next session. Now, as we all know, big tech platforms, we've discussed it at length today already, Google, Meta, Amazon, operate seamlessly across national borders. Yet, competition enforcement in Africa remains largely fragmented along national jurisdictions. The next panel session is titled One Platform, Many Markets, the Case for Regional Competition Enforcement in Africa. The panel seeks to explore how regional economic communities, such as the East African Community, the EAC, the Common Market for Eastern and Southern Africa, commonly known as COMESA, Economic Community of Western African States, ECOWAS, are responding to cross-border digital markets, how they are coordinating investigations, how they are harmonizing competition laws, and shaping a continental approach to regulating dominant digital platforms. It's a privilege to now invite our distinguished panelists to take a seat on the stage, and I hope our virtual panelists are also ready online. I will begin by introducing Ms. Stella Onyancha, who will be joining us online. Ms. Stella Onyancha is the acting registrar of the East African Community Competition Authority, the EACCA. She is also the substantive deputy registrar in charge of the Monopolies and Cartels Directorate, a position which she has held for 4 years. Prior to joining the EACCA, Stella was the Director, Enforcement and Exemptions at the COMESA Competition Commission, where she steered the Commission in promoting fair competition through regulation of the market conduct and in ensuring markets worked well for all participants in the common market. Before joining COMESA, Stella worked for the Competition Authority of Kenya in various positions, her last position being Director for Competition and Consumer Protection. Stella has over 25 years' experience in competition policy and law enforcement. She is also the holder of a Master of Arts in Economic Policy and Management. Welcome, Ms. Stella Onyancha. A round of applause, please.
Thank you, Renata.
Okay. Next, we have Mr. Sam Watasa. Mr. Sam Watasa is the Managing Consultant at Utility Strategies Limited, business management consulting firm. He has provided consulting services for private, public, and international agencies for over 20 years, specializing in trade policy development, infrastructure services, and trade sector regulation. Currently, he is the Commissioner, Board Member, and Vice Chairperson of COMESA Competition and Consumer Commission. He is a member of the East African Standards Committee and International Standards Organization, Consumer Policy Committee. At the national level, Mr. Sam Watasa is the chairperson of the Technical Petroleum Committee, the Ministry of Energy and Mineral Development in Uganda. He is also a member of Private Sector Foundation Uganda Trade and Commerce Board Committee. He is the Executive Director of Uganda Consumer Protection Association, the UCPA, and a member of the National Bureau of Standards Certification Impartiality Committee. Mr. Watasa is a former commissioner, board member of the East African Community Competition Authority, and the founding chair of the COMESA Consumer Protection Committee. He studied an MBA at Makerere University Business School and Chartered Institute of Marketing in the UK. He has done various courses in competition regulation and consumer protection, international trade policy, and infrastructure services reform and regulation. Please welcome Mr. Sam Watasa to the stage. Finally, join me in welcoming Dr. Simeon Kofi, our final panelist, who is joining us online. I can see he has joined. Dr. Simeon Kofi is an economist, statistician, and specialist in regional integration policies with over 20 years of experience supporting economic integration in West Africa. He has recognized experience in competition policy, public policy, market analysis, regional economic governance, and institutional development. Since 2021, he is the Executive Director of the ECOWAS Regional Competition Authority, ERCA, which is a specialized agency of the ECOWAS Commission based in Banjul in the Gambia. In this capacity, he oversees the implementation of the community competition rules and the regional consumer protection mechanisms. He contributed to the development of the ECOWAS Regional Competition Regulatory Framework and to the operationalization of ERCA. Prior to joining ERCA, Dr. Kofi served for nearly 13 years at the ECOWAS Commission in Abuja as head of the Research and Development Division. He also held the position of Deputy Director in charge of Research and Statistics at the Central Bank of West African States. Please welcome Dr. Kofi, and thank you to all our exceptional speakers for being here and online today. I think allow me to get straight into the questions in the interest of time. I know we've run over a bit the other sessions. So we'll begin right here in East Africa with Ms. Stella Onyancha. Ms. Stella, if you can please confirm you can hear me.
Yes, I can hear you, Renata.
Okay.
Can you hear me?
Yes, we can hear you. Thank you.
Thank you.
Ms. Stella, the East African community seeks to create a common market. How important is regional competition enforcement in ensuring that digital markets remain open and competitive?
Thank you very much, Renata. Just to start, I want to thank EDLIGO very much for convening this very important summit. You've already introduced me, so I'll just go straight away to talk about our mandate before I respond to your question quickly. So the East African Community Competition Authority represents 8 partner states and over 300 million people. So the EAC's mandate is to promote and encourage fair competition within the community. By that I mean we regulate the market structure by controlling mergers and acquisitions. We also regulate the market conduct by prohibiting anti-competitive business practices such as abuse of market dominance as well as cartels. We also ensure the welfare of the consumers is enhanced by looking at the conduct in terms of unconscionable conduct or misleading market conduct, among others. Our other role which we play is also advocacy and awareness raising among relevant stakeholders, and I'm glad the previous speakers have emphasized on the role of advocacy also. The main objective of the East African community is to guarantee a level playing field for all market participants in the community, giving equal opportunities for all participants, such as the micro and small enterprises, and thereby creating a conducive environment of investment in the community. So just to go straight away to your question, Renata, enforcement at the regional level, it matters a lot. It's very important, and this one has been emphasized by the various speakers who have gone ahead of us. As a matter of fact, and as it has been emphasized, these big tech firms such as Google, Meta, Amazon, Microsoft, they not only operate, for example, in Kenya, Uganda, Tanzania, they operate across the region and across the globe. They are there, and that's why IACA, as a regional enforcer, is there to regulate such anti-competitive practices, such as abuse of market dominance, that big firms may be entertaining in the community and other African states, also globally. So why enforcement matters at EAC, we have exclusive jurisdiction on cross-border matters. That means any matter affecting having a cross-border dimension, we are best placed to handle. So IACA has a cross-border reach, and that's why we are better placed to handle matters, even including those regulating the big tech. And because what is happening, the behavior by firms, any anti-competitive practices by such firms affects the whole region and not a national, not one country alone. That's why we are, this is very critical for us. And also the fact that we are a one-stop shop. IACA is a one-stop shop. When it comes to mergers, we have that mandate to regulate mergers within the community. So, and the fact that partner states are supposed to support the East African community in the implementation of the law. So once we receive, for example, mergers affecting the big tech, among others, we are there to regulate such mergers even before the conduct is entrenched, because mergers is ex ante, so we have to look at that. And by our intervention, it means we intervene in the market to ensure we work closely with the partner states and to ensure those anti-competitive conduct are addressed before they are entrenched in the market. Also, our previous panel mentions about fragmentation. You know, we have a regional law and we have access to all the partner states. Once a matter is regional in nature, is cross-border in nature, then we are the ones to handle it. So the national laws, us as a regional body, we are best placed to handle such matters instead of being handled at the individual level, at the national level. That is one of the issues which we want to emphasize on that. So ideally, even the other speakers have emphasized on the importance of regional enforcement. I think COMESA is also a good example for us, and I'm happy my former commissioner, Wataza, is also here, who is also now representing COMESA. And this one is trying to tell us that regional enforcement is key. Even we are here with the ECOWAS, our brother from ECOWAS. So what is there is that regional, the message we are trying to pass is that regional enforcement is key. Individual partner states cannot do it alone because these matters are cross-border in nature. They affect the companies, these big tech firms move across the region and they affect these partner states. So IACA is best placed to handle such matters. Even matters, instead of filing at the individual level, they come to us so that we can liaise with the partners to ensure we tackle those matters and we issue consistent outcomes when it comes to that. And also we align our investigations. So regional enforcement, just to emphasize, because it has been mentioned a lot, is very important. Thank you very much.
Thank you very much, Ms. Stella. I think it's very clear from your response that regional competition enforcement is the perfect response to the fragmentation that we see in the region. As you've stressed, RECs, the regional economic communities, are best placed to handle these anti-competitive practices. So if we turn to Mr. Watasa, who will take us to a more regional perspective, the COMESA Competition and Consumer Commission recently opened investigations involving AI and digital platforms. How is digital competition changing the Commission's enforcement priorities, given that the new COMESA Competition and Consumer Protection regulations provide for the regulation of gatekeepers?
Thank you, Renata, and is it an afternoon? Good afternoon, our audience. I don't know whether to start speaking from how the regulations have been shaped by the developments in the market, but we've just repealed the old regulations and have a completely new regulations December 2025. That's when the Council of Ministers passed them. So for those that have had the opportunity to look at them, they have been influenced by developments in the market over the last 20 years, and therefore they go to a very, very wide scope and depth of attention to developments in the market. But of course, the underlying factor is that we have to agree that competition is good for all of us, for consumers, for economies, and for businesses. So the factors underlying competition regulation really are about us encouraging competition and building bigger farms so that the dynamic efficiencies can give us the innovations that we need. So currently we are dealing with situations where, companies are taking advantage of digital platforms, AI, technology, and embedded algorithm to come up with so many new products, especially in the service sector. It's an unfortunate thing sometimes for us, especially as a country, Uganda, that a lot of the laws and policies that come off our processes are usually in nature focused on the domestic market. And I was listening into the previous panel. The Data Protection Act was really focused more on the national scene than on what happens across the region. It would have had provisions that address the size of the market and harm that would come off them. But what the Commission is doing, as a board member, I don't get terribly involved in the nitty-gritty of investigations, and so I can't go into the detail of what's going on, but suffice it to say that this case was filed by Ad Legal, and usually what would happen is then it has to be assessed from various aspects to be sure that it is something that can be carried. So the developments on there are based on how this technology and its utilization and how consumers take advantage of it is driven. That case was filed on 15th October, and it has been talked about variously here, even by the previous panels. So the detail of it is not something that we would want to delve into. But what suffice it to say, the Commission undertook preliminary assessments of that complaint, and there was reasonable cause to suspect, and the Commission at the preliminary stage therefore suspects that Meta holds a dominant position in the market, and therefore the actions that they take may have harm to the market and to consumers. Specifically, the case touches on violation of Regulation 36 of the new regulations for the commercial and consumer protection. And so the matter was officially raised by Meta Ireland 17th of February 2026. This process usually takes a while. I also need to mention that the regulations have changed the way we run business at the Commission, because previously we had what was under the old regulations, a committee on initial declarations that would determine these matters, and then subsequent to the decision being made, that decision, if there was any dissatisfaction by the parties, it would be appealed to another board committee that we called the Appeals Board, and then eventually to the full board. Now, after several consultations and testing the regulations as they were then, we did recognize that there would be conflict of interest if you would say that you have a board committee on initial declarations that is making a decision on either merger, acquisition, or consumer complaint, which would then be referred to a full board, and the committee is also part of the board. So the new regulations have changed that. The board makes decision, the commission will make the decision on a matter, and any appeals arising from the decisions of the board would be put to the COMESA Court of Justice. Now that is probably good governance and best practice. So this case is also going to go through that process. Now that process starts with a complaint. That complaint could be from any member or individual or company or entity from the COMESA region. It could also be outside the COMESA region if the parties affected are not necessarily in the COMESA region. Then we would usually commission investigations. Outcomes of those investigations would then have to lead to what we call a statement of concern. That one would come from now what we call a panel on decisions. And that panel would then have to evaluate the evidence collected through. I've had people who have already been approached to make their submissions. At the end of the investigation and the statement of concern and evaluating evidence about the matter, then the panel will make a decision. That decision which the panel makes as far as the commission is concerned is final. But then the parties have leverage to appeal to the COMESA Court of Justice. That's good. In the meantime, the COMESA Court of Justice is not a full-time court, and therefore it's an ad hoc court. So right now what's going on is that as a commission, we are working with the COMESA Court of Justice and the council to put in place a framework that would facilitate expeditious attention to matters arising from, matters of appeal arising from decisions of the commission. So that's the process it's gonna take, and that framework is still in discussion form. So that case is actually active, and the commission has issued preliminary restraints on it. I suppose we will go into the others later. Thank you.
Thank you very much, Mr. Watasa. It was really great hearing some insights on what COMESA is doing now that the regulations have been implemented. Thank you for also taking us through the process of hearing complaints, investigating, and the determining of decisions at the COMESA Competition and Consumer Commission, and also the appeals process at the COMESA Court of Justice. If we turn now to West Africa, we have Dr. Kofi from ECOWAS joining us online. Dr. Kofi, ECOWAS is continuing to strengthen regional competition enforcement. What opportunities does this present for regulating digital markets across West Africa?
Thank you very much. Can you hear me, Renata?
Yes, we can hear you.
Thank you. I want to acknowledge the established protocol and extend my respectful greetings to all the distinguished participants. Also allow me to thank sincerely my friend Aziz Kitaka and Ad Legal for the invitation extended to the ECOWAS Regional Competition Authority. To respond to your question, the main purpose of establishing the ECOWAS competition framework is to support and complement the effort of member states in enforcing competition law, especially when dealing with competition issues that go beyond national borders. And digital markets clearly shows why competition enforcement can no longer be limited to national boundaries. A digital platform may have no physical presence in several ECOWAS member states, while still serving millions of consumers across the region, and it's the case for all the region in Africa. So, in such cases, national authorities acting alone may not be able to effectively address conduct that has a regional impact. The ECOWAS competition framework already provides an important legal foundation to address many of these challenges, even though it was adopted before the rise of today's digital economy. The first major strength of our framework is the regional scope. It's clearly stated that ECOWAS competition framework addresses cross-border matters. So under our act, ECOWAS has the mandate to address anti-competitive agreements, abuse of dominance, mergers and acquisition, state aid, as also highlighted by my colleagues. So, and all this may have effect on trade within the community market, regardless of national border. These are the same legal tools that can be used to examine the conduct of a major digital platform operating across several ECOWAS countries. So, secondly, the establishing of ECA as the regional institution responsible for implementing these rules empower it to investigate, open proceedings either on its own initiative or following complaint issues of binding decision and adopt appropriate measures to ensure the consistent application of competition rules across our West African community. And in addition to these funding acts, you were able to develop recently many implementing regulations that further strengthen our enforcement capacity. So you have a specific regulation on merger control system that allow ECA to review merger with a regional impact, including transactions involving digital companies and technology firms. There are also regulations that establish common procedures, facilitating cooperation and information sharing and coordinated enforcement between member states. This is critical. You need a coordinated enforcement mechanism. You have also some rules that provide clear guidance on various techniques to conduct the investigation and sanction, and also to providing legal certainty for both businesses and regulators. And these instruments provide important opportunity for addressing many digital competition concerns, even though they are not specifically dedicated to addressing issues in digital markets. Issues such as self-preferences, exclusionary practices, data-related market power, ecosystem advantages, and anti-competitive acquisition can clearly be addressed through the existing competition law of ECOWAS. However, digital market also creates new challenges that traditional competition rules may not always fully address. That's why we are fully agree on that. So recognizing this reality, ECAS has already started preparing for the future. Over the past 2 years, ECAS has carried out a regional study on digital market across ECOWAS member states to provide insight on this specific sector and guidance on further investigation. We have started discussion within what we call the Consultative Competition Committee, made of representatives of the national competition authorities, to provide clear guidance and findings on these studies to ensure that our next action in this area be coordinated. And the current strategy plan of ECA 2024-2028 identified clearly digital market as key strategic priority. So, and finally, we continue to strengthen cooperation with national competition authorities and other regional competition authorities, as clearly stated by my colleague Stella. And the MOU between the REX is clear evidence that you need to work hand in hand to address some of the challenges that we are all facing. This action shows that ECOWAS is moving beyond simply applying existing competition rules to digital markets, because you know that there are limitations in the current laws. You are working toward developing a digital competition approach that reflects the realities of platform-based economies. Looking ahead, there is a room for further modernize our legal instruments, and a future reform could include, for instance, introducing specific rules for digital gatekeepers where significant and lasting market power exists. Also developing clear principles on access to data, interoperability, and portability where these are essential for competition, and strengthening our analytical tools, and all these you have been working on to develop our digital ecosystem. So the objective is not to copy another jurisdiction model, rather it is to develop an African approach that encourages innovation while ensuring that digital market remain open, fair, and competitive. So, distinguished participants, this is the steps that ECOWAS is taking in addressing some of the relevant concerns in this important sector. Thank you very much.
Thank you very much, Dr. Kofi, for those great insights. It was really nice to hear more about ECOWAS ERCA. I think you called it ERCA in short. ERCA clearly has a clear mandate to regulate these cross-border matters, You mentioned that the authority benefits from coordinated enforcement and information sharing. I like that you highlighted the opportunities, but you are also very honest to say that there are new challenges that the digital markets have created, and these are challenges that the law doesn't always protect. I like that you also said ECOWAS is preparing for the future. I think that's very hopeful, and that ECOWAS has been involved in market studies, and the hope is to introduce specific rules for gatekeepers. I specifically like at the end there where you said the aim is not to copy another approach, but to create an African approach. So thank you for those insights. We'll move back to East Africa, back to the East African community. We have Ms. Stella online. Stella, looking ahead over the next 5 years, what should success in regional competition enforcement look like? And what practical steps should African institutions take now to make that vision a reality?
Thank you very much once again for that question. Just to also emphasize once again that the digital economy is exploding, as so is our leverage. East Africa is one of the most fastest growing in terms of digital economy in the continent, and mobile penetration exceeds even 80% in the partner states. Big tech firms, they know about this, and they are not here as our guests. They are here to shape the market. Our opportunity as the East Africans is we are not reacting to the big tech's arrival. What we are doing is we are trying to build the regulatory architecture while they scale. So this means I just want also to emphasize on the point the panelist from ECOWAS, Mr. Kofi, has said. We need to look at the regulatory structure, architecture, to ensure we develop rules that are fit for Africa to be able to address the issues that may be brought about by the big tech firms. As for ESC, the IACA, we have our strategic plan for the next 5 years. And what we want to ensure is that we are trying to establish a credible and authoritative regional competition enforcement record. And what we have done, of course, we have operationalized the merger regime. As I said, we are a one-stop shop now for transactions affecting more than 2 partner states, and it's our game changer. And we can be able to capture those digital platforms that acquire strategically, and we may be able to address the issues before they entrench the anti-competitive behavior, such as abuse of market dominance in terms of exclusionary conduct and self-preferencing, when the way our act is. So the other issue we are looking at is in terms of conducting market inquiry. So what we are doing is implementing systematic enforcement of anti-competitive practices in priority sectors. Currently, as IACA, we are reviewing the e-commerce sector and as one of our priority sectors because of the digital economy and because of the market is growing very fast. So our focus mainly is meant to address the issues first and come up with remedies that will be able to address the harm before it's entrenched. So the other thing we are going to do as IACA, and what we are doing is we are focusing on regional coordination. I can say that we signed a memorandum of understanding with the COMESA, given that out of the 8 partner states, 6 partner states are also members of COMESA. So we have to work with COMESA closely, and this is to ensure we coordinate in terms of conducting investigations information sharing, and mitigating against the issues of duplication. So we are on with COMESA, and we are coming up with a cooperation framework to ensure all these issues are addressed. So we are in touch, and we are coordinating in terms of handling these issues. And regional coordination, as Kofi from ECOWAS, aside from ECA, we also have a REX. We signed a memorandum of understanding as regional economic communities, and this is to enable us also share experiences, because the previous speakers made mention of these big tech firms investigations, which can take several years to complete. So as African states, we need to come together to ensure we coordinate and address these issues in a more amicable way. We share information, we share how to handle investigations. Like that, I like that idea where if one of the RECs received such a complaint, then we should be able to interact, all of us, and ensure, discuss on how best to go about it, because we want to come up with remedies that can be able to address our African context. In terms of the regional economic communities, like what we do as IACA, the Act requires us to cooperate with the partner states in the implementation of the law. So what we have done is we have come up with a cooperation framework. We have bilateral frameworks, but then we have also come up with cooperation framework for all the partner states of the East African community, so that we are able to support one another in terms of implementation of the law. Because we can't work alone. When it comes to information, we have to get it from the partner states. That's why it's very pertinent for us to cooperate, and we have that framework in place, which is almost finalized. The other issue I want to bring on board is in terms of, apart from the regional cooperation and consultation with our peers, we'll also need to cooperate and coordinate with our peers in the competition arena, even from internationally. We can be able to cooperate with the European Union. Those who have handled matters to do with big tech and the digital matters, we need to cooperate with them in as we enforce the law, so that we come up with consistent outcomes, even as we engage the partner states and our other regional economic communities. The other issue where we are heading, how we consider ourselves, is that we have also commenced the process of amending our law, but even as we implement, we need to understand the market. The market is evolving very fast, it's very complex. Even as we enforce the law, we need to understand the market, and even when we come out with proposals for amendment, we need to align them with what fits well for the African context, for the EAC context. So on our side, we have commenced that process of amending the Act. Is a rigorous process. So we'll be engaging our stakeholders, such as the legal fraternity and the civil society, to give an input on the same once the process continues. So those are the key issues we are looking at in the next 5 years to ensure that IACA is successful. And just but to mention, we just want to ensure that we work closely with the other RECs. We need not to duplicate our efforts with the other RECs, but we want to coordinate and work closely so that we ensure we have uniform application of principles when it comes to competition assessment and addressing the anti-competitive practices. So those are the few areas where we want to go to. The other issue, maybe the last one, is that even as we develop and review our regulations, IACA has a website. We have developed regulations on mergers. Mergers is our low-hanging fruit currently. We are handling that. Even as we develop and fine-tune on other regulations, we want also to have those regulations, those sophisticated, those regulations to address sophisticated market intelligence, because the market is evolving. So we need to have those that can be able to address and that can be able to enable us to have the evidence to be able to address the issues which are prevailing in the digital market. So those are the few areas where we are headed to, and in line with our strategic plan, which runs from 2025, 2026 to 2031. So thank you very much.
Thank you very much, Ms. Stella. I think one of the previous speakers said the harm can't be localized. So I like that you stressed that the harm is spread across countries. African regulators need to think in terms of coordination. And like you said, there'll be strength in enforcement and uniformity across the region through that cooperation. Thank you very much. We'll turn to Mr. Watasa, and I'll pose the same question to you. Looking ahead over the next 5 years, what should success in regional competition enforcement look like? And what practical steps should African institutions take now to make that vision a reality?
Thank you. I think that the regulations that we adopted now address a lot of the futuristic anticipation within the competition regulation scope. One is a matter of principle, because now we moved from post ante to ex ante in terms of market conduct regulation, but at the same time, the old regulations imposed a cap on penalties that the Commission would impose where infringement with the competition laws was concerned. Now, the regulations that we have in place have opened up that, so the Commission can penalize a commensurate amount with the infringement that we anticipate. What does that mean? It means that the cost of investigations can be met as a minimum, and then there can be a penalty that compensates for the harm on the market. I'll just give one example. For instance, when we did an investigation of CAF for violation of the COMESA competition regulations, the Commission spent almost double the amount in investigations alone, but the penalty we gave was $300,000, because that was the maximum under the regulations that we would impose, which then talks to the need for regional enforcement, because the cost of investigation of violation of competition law and its provisions is quite high, very, very high. I wouldn't anticipate a single jurisdiction in Africa to be able to meet the cost of investigation like the case that Adligo has filed with the Commission, that you're going to have to conduct investigations, of course, because of our jurisdictional limit, that would be 21 countries, but this is actually, it's a case that the inquiries will definitely have to go beyond the 21 countries. Because at the Commission, what we do is we are not necessarily looking at the impact on the market in the COMESA countries, but we are also looking at the impact on consumers that are dealing with the COMESA countries, because the impact goes beyond the jurisdictional limit of the COMESA region. So it's a very, very expensive exercise, and that drives the need for enforcement at regional level, or at least up to a much higher level. The second one, which Stella has mentioned partially, is that enforcement of infringement on competition law, even if it is municipal law, would require that you have to exchange information with other regional regulators, ECOWAS, SADC region, and wherever. It's a little bit nuanced for a local regulator or a municipal regulator to be able to have the clout to command same level interaction with regional regulators to be able to get effective action taken. And there are so many others. I mean, what is happening in the market? Between January and June, at the Commission, we have approved 53 mergers Now, 53 mergers, why are they merging? They are merging to promote economic efficiency. They are merging to reduce the cost of doing business across borders. They are merging to increase market space. So as they increase market space and maximize economic efficiencies from their mergers and market operations, it therefore means that the tracking of the impact of those businesses or rather the market resulting from the mergers is unlikely going to be national jurisdiction. It's going to be cross-border jurisdiction. So that in itself justifies the need and requirement for us to effectively police the market from the regional perspective. Now, what's happening? The Commission is supporting member countries in refining their laws to expressly recognize the jurisdiction of the COMESA, Competition and Consumer Regulations. We've done that for, I think, Mauritius is under review, Eswatini, and several other countries. The Uganda Act was already, refined along those lines, so it doesn't need to do that. So at the end of the day, that's what's going on, and yeah, we have put in place new instruments to deal with that, and so the consultations that go on must take that nature, and like I said, we made losses on various cases that we investigated before. Right now, of course, we are flagging the big tech ad legal case, but we have several other cases that are under investigation in this area. We are looking at cases of cross-border payment settlement systems, cross-border mobile money payments. There are so many issues in there, and there are cases that are actively under investigation in the DRC, Rwanda, Burundi, around cross-border payments. So it's important that players in the market also test those regulations, much as they are designed in a more dynamic manner. But we need to be testing them and building the necessary capacity, even for investigations. Of course, we have support to countries and some revenue share arrangements. So yeah, we support investigations in countries, but through the relevant, institutions. And so I think the processes for filing complaints are online. We don't do any physical receiving of cases. So online means that from wherever anyone is, it's potentially possible to resolve that. The other area going forward, of course, we are supporting member states in developing instruments and tools for enforcement of these laws. We are developing model consumer protection regulations for aviation industry and all these services that are cross-border. And so it gives both an economic and effective and scope, rather economic and impact advantage to member countries to pursue violation of competition laws and regulations to the regional entities, because at the end of the day anyway, it helps the whole community in COMESA. But then, of course, we have to also be looking at building capacity for and within the member countries, which is why I mentioned earlier there was a request for training the judges. That is, that's a capacity building program that is at the core of our member state support. So far, we've conducted training for judges in about 5 countries. There is another one lined up for the next 3 countries, I think in the next 6 months. And going forward, we will be covering all the 21 countries in the COMESA region. What we are also doing is now we are actively working with universities to introduce formal certified training in competition law and consumer protection. Details when it's ready. Thank you.
Thank you, Mr. Watasa. That's very interesting to hear. My key takeaway from what you've said is that there's a requirement for effective policing at a regional level. And as you said, the COMESA regulations, the 2025 regulations, have effectively provided the roadmap for success in regional competition enforcement. So I think for the next 5 years and beyond, and I think with that, time will be the best judge. In the interest of time, we'll move to the last question. Dr. Kofi, in just 3 minutes, please, if you could answer the final question. Looking ahead over the next 5 years, what should success in regional competition enforcement look like, and what practical steps should African institutions take now to make that vision a reality? Thank you.
Thank you very much, Renata. I think for us, and it's actually what is enshrined in our strategy plan for the next 5 years. So is to ensure that success should be actually, or should mean that businesses can compete across Africa under clear and predictable rules, and that consumers benefit from a more innovation, greater choices, and fairer prices. So I will say that. And some of the main priority that I'm going to provide, and my colleagues, previous speakers, have already mentioned most of them. But the first one for us is to ensure that the regional institution should become a forum for addressing cross-border competition issues, to avoid that overlapping, that issue that is not clearly in a national jurisdiction be handled by national jurisdiction. So you have to work toward that. Because what you notice that many large digital platforms operate across the region rather within individual countries. So I think the best place to handle concern regarding the operation of this platform is within the regional institutions. The second one is you need a greater convergence of competition laws. There is one clear evidence that there are, and previous speaker said it, a clear fragmentation of competition law, procedures. So it's important to work toward the convergence, and it's something that the FCFTA has to clearly tackle, work on. The third one is to invest in technical capacity. You know, sometimes addressing the issue related to the operation of the big tech is not by lack of willingness, it's also lack of capacity. Sometimes you don't know where to start because you don't understand the technicality beyond the operation of these firms. So digital competition requires specialized expertise, including economists, data scientists, digital experts, and lawyers who understand these algorithms and artificial intelligence and data-driven businesses. And that one, you cannot, you need to invest in this technical capacity. The fourth one is cooperation, and it was mentioned that one you can not never oversize on that. Cooperation must become something that is like a routine rather than exceptional. I have to, for any cross-border cases, I have to naturally contact members, Stella, other colleagues of the REX to seek their opinion on these cases. And also, you need to work to conduct market studies to understand the underlying realities underlying of this area. Most of the competition authorities doesn't invest in market inquiries, market studies. You cannot efficiently address concern, conduct investigation without having a clear picture of where you are going and what is the question that you want to address. And finally, competition policy must become more forward-looking. It has been said earlier. Our current jurisdiction is not forward-looking, so appropriate amendments are required to be able to address issues on the specific sector that is of concern today. And for that, what we have planned for the next 5 years in our strategy plan is to deepen cooperation with national and other regional competition authorities to strengthen capacity. If you want to tackle the issues on this sector, you need to build our capacity. And I think something that I can say is that I want to greatly appreciate the strong cooperation among the competition authorities of the RECs, because our collective effort have made a significant contribution to shaping the FCFTA competition regime. So I am sure and I'm confident that this same spirit of cooperation will continue as we move toward the effective implementation of established rules. So it's my hope, and for our good cooperation with my colleagues from the other RECs, I'm confident that this hope will be a reality. Thank you.
Thank you very much, Dr. Kofi. Thank you for highlighting ECOWAS's strategic plan for the next 5 years to tackle these issues. Just to conclude, I think it would be amiss to not make a comment on the new kid on the block. I think, Mr. Watasa, if you could just, in a minute, give us a comment on the African Continental Free Trade Area. I understand that there are plans for an African Continental Competition Commission by 2028. How will this change the landscape for regional competition enforcement on the continent?
That one might best be answered by the people who will be in that commission. But first, I think that we have actually, as the Commercial Competition and Consumer Commission, have MOUs with countries that are not members of COMESA. And so they are literally implementing the regulations already. I think one of those, Libya, there's an, and so we can see that the scope for implementation of the regulations is beyond COMESA. That's one. Number two, this is something that was recognized way back, and so we looked at it from the strategic point of view to say the largest single economic bloc within the region that is going to be affected by the policy for competition law or regulation within the Africa Continental Free Trade Area is going to be COMESA. So what happened is that we actively engaged competition regulators within COMESA, our member states, and financed their discussions right from the beginning when the policy was in draft form. So gladly, what has come off as the policy at the Africa Continental Free Trade Area in terms of competition regulation and policy is what was adopted by the regulators within the 21 member states of COMESA. It's really like the bulk of it. So I know where this question keeps coming up is in how one is going to do enforcement, especially things to do with notifications for mergers. Maybe someone is expecting there will be one here, multiple merger notifications. those are things that will have to be harmonized through subsidiary instruments. And I envisage a situation where the Africa Continental Free Trade Area regulator will be working literally similar to what we do with the member states and other regional regulators. Stella mentioned the MOU between ESC Competition Authority and the COMESA Competition Commission. I was shy to talk about that because I have had participation both ways, so I'm not very qualified to make comments on it. But yeah, that's the way to go, so that this is avoided. But again, I can only speak on behalf of the Commission. We are literally demand driven. If clients are finding problems and they bring them to our attention, we look at them and find the necessary solution. So that MOU is going to address those kind of things, especially with ESC and COMESA. I actually envisage the Africa Continental Free Trade Area competition regulator to work along the same arrangements. The details are usually worked out based on the market dynamics. There will be maybe thresholds of capital, maybe geographical market presence. I mean, if you are a company that is operating in probably 3 countries out of 21, and those countries are in East Africa, it makes no sense for the COMESA Competition Commission to begin taking up such a matter. Or maybe you'll have 2 countries are in SADC, and maybe they have operations in 3 in here, so you get into an arrangement where if it's a notification and for purposes of noting, yes, if we've received some of those cases, even those for investigation for consumer complaints, where we determine that this particular matter is best handled by the national institution, then that one is referred. When it is something that should be referred to the ESC Competition Authority, that's what will happen. So at the end of the day, the nitty-gritties can always be worked, and they create more efficiency. Like I mentioned, the cost of investigations, I mean, it's really damn high there. So yeah, that's something we have worked on actually very, very actively. And we have tasked the Secretariat to make sure they report on this regularly, how far they've gone. But so far, so good. Thank you.
Thank you very much. And thank you to Ms. Stella Onyancha online, Mr. Sam Watasa, and Dr. Simeon Kofi for such an enriching and engaging discussion. What comes through clearly is that regional competition enforcement in Africa is no longer aspirational. It's operational and it's moving. I think the common thread across all of the points that you've brought is that the future of effective competition enforcement will depend on exactly the kind of things you've discussed: the harmonization, coordination, and institutional capacity building. So thank you very much. I think this will end the panel. I understand we are doing badly for time, so we might not have questions. I'll hand over back to the MC. Thank you.
Thank you very much.
Good afternoon. Good afternoon, ladies and gentlemen. I have your lunch coupons. How you respond matters. Good afternoon. Okay. Today we have tried to keep time. Thank you so much for the panel that has been there. The moderator, thank you so much. Mr. Watasa, it's a privilege to associate with you. It's a privilege for you to be here. We appreciate you. Thank you for your encouragement and for your work at COMESA. So briefly, we are going to have an award ceremony after. Please stay after lunch. You please stay. You may have an award and you go. So make sure you stay because we are going to award some of you, but I can't tell you because you'll go. So stay and see if you have an award for best attendee. Then the next session also is very, very important. Please, when you go for lunch, you hurry up so that you come back. We have a very special guest. So we are going to go into the next session, which is going to be the last before lunch. It will take around 25 minutes, then we'll go for lunch. So we are going to hear from regulators who have taken steps to hold big tech accountable on competition issues, as well as those who have put a mark on best practices on regulation of these platforms. Ladies and gentlemen, allow me call upon Mr. Edmond Babalanda from ENS to lead this session, which will be leading us to lunch. So before, as Mr. Edmond comes, allow me, attendees of the BTS Summit, the first of its kind, to warmly welcome Mr. Babatunde. He's a very important guest. He's coming in from Nigeria. Please welcome him. Yes, he's a very important guest. Later, when he's going to do his opening remarks, I'm going to introduce him fully, but I wanted to recognize his presence, to thank him. Thank you for what you're doing for us. Thank you for what you've done for Adligo. We appreciate you. We honor you, sir. It's a privilege to associate.
Good afternoon, ladies and gentlemen. I am the weapon formed against you and your lunch, but it is not going to be so long, so I'm going to make it brief. My name is Edmond Babalanda. I work with ALP East Africa, and I have the honor to moderate this panel. With me, all my panelists are online. That's why I'm standing, because it would look weird for me to sit when all my panelists are online. So just allow me to stand. So with me, I have two panelists, and yes, the first one online is Florence Abib from the Nigeria FCCP, and she has, just to confirm, are you online? Yes, she is, okay. Florence Abib is the head of Anti-Corruption Competitive Practices Department at the Federal Competition and Consumer Protection Commission of Nigeria, and she has played a leading role in some of Africa's most consequential digital competition investigations, including the landmark Meta and WhatsApp investigation that has just been mentioned in the previous panel. So, ladies and gentlemen, let's welcome Florence. Florence, are you there?
I am. Thank you very much.
Perfect. So, the next panelist is Ninette K. Marania. She's the manager for planning, policy, and research at the Competition Authority of Kenya, where she leads the authority's work in strengthening policy, research, and institutional preparedness for emerging digital markets. Let's welcome Ninette.
Thank you very much. Good afternoon, everyone.
Good afternoon. Thank you. I'll dive straight to our discussion, and if you could just allow me lead and start with Florence. Florence, we've seen Nigeria emerging as one of Africa's leading jurisdictions in digital competition enforcement. And we've seen the Commission has demonstrated, which is a bit different from other commissions or countries that do not have commissions. And we've seen your capacity ensuring that you investigate and involve some of the big tech companies, especially Meta and WhatsApp. Meta and WhatsApp are more or less the same. So you had an investigation, and we want you to share your experiences. What concerns first prompted the FCCPC to investigate Meta, and what were the key competition issues the Commission sought to address? The floor is yours, Florence.
Thank you very much, Edmund, and thanks to the AdLegal and BTA team for having me. The investigation began sometime in 2021, and it was triggered by the updated privacy policy by Meta to Nigerian consumers at a time when Nigerian consumers had become heavily dependent on the WhatsApp platform. However, the privacy policy was a take it or leave it. They had informed Nigerian data subjects that, you had to update this privacy policy or you could no longer continue to use the service, making any meaningful ability to decline updating that privacy policy and using the service impossible. And it's important, that I'm quite precise about the investigation with respect to competition. And that's because a lot of people describe it as, just a privacy case, making it appear more of a consumer protection issue. However, where consumers pay no money or price, as it were, where the market is considered zero priced, as most multi-sided platforms in the digital market, it's important that we know that price is not the only parameter on which firms compete. In the digital market, we look at other things like quality, terms of use, and just generally how consumer data is treated. And so when an undertaking holds a dominant position and has the ability to degrade these parameters unilaterally, the correct question becomes, would you be able to do this if the market was competitive? And the Commission found no. The Commission took a position that the conduct was only sustainable because the target of investigation was dominant. And I mean, if you think about it, Nigerians didn't have an alternative. This particular platform owned about 90% and above of the market, making the network effect substantial. And in that case, any switching cost was extremely high because of also the lock-in effect. And so there were three competition issues mainly that we were looking at. One is around exploitation, where we were able to analyze and find that the contract terms were unfair, and especially because it gave Nigerian consumers no genuine opportunity for giving consent. The second issue was the accumulation of what we considered excessive data, and combining that data with data from their other affiliated services and indeed third parties, just to reinforce or strengthen their market dominance. Finally, and the one that really touched at the heart of the commission was the issue around discrimination. When we did a comparative analysis of privacy policies across even more mature jurisdictions, even with the same or mirrored regulatory environment in terms of the instruments like the General Data Protection Regulation in Europe, and when compared with the Nigerian Data Protection Regulation, they sort of mirrored each other. Yet, the data subjects in Europe were better protected because they were able to withdraw their consent once given. However, in Nigeria, there was no justification for why Nigerian citizens could not withdraw, their consent once given, right? And remember that this was already a pre-tick box. You accept it or you can't use the service, And so sometime in July 2024, the Commission imposed an administrative penalty of over $200 million and additional behavioral remedies. There has been a judicial pronouncement on that sometime in April 2025. I believe it was my birthday, with overwhelming resolution by the judiciary that supported and affirmed the position that the Commission took. The matter is currently on appeal. And I can't speak much to the appeal since it's a live matter in court.
Thank you, Florence. Thank you. What I get from your discussion, and I'm glad Nigeria has moved. Many African countries are still lagging behind when it comes to aligning competition laws with the data protection laws in place, which is very important for us because we see in the digital age, these two move together. So the fact that you've moved, that is a plus for Nigeria. I'll move to Ninette. She's my neighbor, not at home where I stay, but in Kenya, Nairobi, East Africa. And Kenya has long been recognized as one of East and Central Africa's leading competition authorities. And as the digital markets become increasingly complex, competition authorities are expected not only to enforce existing laws, but also anticipate future risks arising from digital platforms. Now, my question to Ninette, how is the competition authority in Kenya preparing for the unique challenges posed by digital platforms and rapidly evolving technology? Over to you.
Thank you very much, Edmund. And yes, we are neighbors, and I'm happy to be here. I thank PTA also for giving me an opportunity to weigh in on this discussion. So yes, you said correctly that Kenya is leading in the digital area, in digital platforms. And as has been discussed by my panelists who came before us, of course, this is the defining characteristic for digital market is, and even Florence has just pointed it out, it goes beyond price alone. There's data, there's innovation, there's network effects that are involved. So one of the things that Kenya has done is that we have invested and we continue to invest in analytical capability that enables us to understand platform economics, algorithmic decision-making, and the strategic role of data in competition. So we are also strengthening our capacity, the staff capacity or the case officers' capacity in data analytics, in digital market assessment, and so that we're able to catch up with the world, so that we're able to identify new harms in the digital platform. And specifically, we have invested in a forensic lab. We've equipped it with the state-of-art equipment to enable us to extract, analyze, and finalize investigations in a shorter time, while also saving costs. Our previous investigation that we had to outsource, a forensic support cost us a lot of money, and it also took very long. So the authority made a decision to invest in its own lab which is now operational. And in fact, a dawn raid that we conducted a while back, I think 2 months ago, we are now being able to extract the data and evidence, and we're in the process of coming up with a decision. So we have also prepared ourselves in terms of the quality of evidence and also the skills for the staff by partnering with other competition agencies who have more experience to build our capacity in digital investigations. Then secondly, the other thing that Kenya has done is being one of the world's most advanced mobile money ecosystems, we are assessing transactions that go beyond the normal decisions or merger decisions that would have been that are made by competition agencies. So through economic analysis, which is central in determining these transactions, we're able to preserve incentives for innovation while maintaining competitive markets. I'll give an example of a merger that came through in 2025. So there's an organization that, so the merger was between Kenya Commercial Bank and a solution provider that was providing a platform for money transfer. So the acquirer, who is the Kenya Commercial Bank, of course operates in Kenya, and the entity that was being acquired was is involved in the development and supply of technology platforms and hardware components for the purpose of financing transactions across multiple industries, including banking, microfinance, manufacturing, etc. So, of course, the transaction was analyzed to ensure that it doesn't cause any competition issues. And because it's KCB is a mainstream bank, while the institution that was being acquired is a platform provider, the decisions that were taken, or the merger decision was not the conventional one. So the authority determined that the acquirer, who is now KCB, should ensure that the third-party transactional customer or merchant data collected or processed through the target, this platform provider, are not used, are not shared or accessed or used for any other purpose apart from the operations for which they were acquired. So this brings us to the idea of data. So of course, the acquired institution, being a platform, had a lot of data, and the acquiring institution could have decided to take advantage of that. The second decision was that the merging party should ensure that the target undertaking honors its contract. So this was also going beyond just the normal decisions, but that contracts with customers were to be honored within the contractual agreed period. And lastly, the other thing we are doing is that we have prioritized market inquiries in order to understand what barriers to entry are there in the economy, and also to help identify the risks before they become entrenched within and cause market failures. Thank you very much.
Thank you, Ninette, for sharing a light on what Kenya is doing. The question is, what is Uganda doing? That question you can ask your regulator if we have one in the room. But it's a good question to think about. What is our country doing as Uganda? What is Rwanda doing? What is Burundi doing? What is South Sudan doing? Well, South Sudan is another interesting country. But thank you very much. You're doing a lot. And before I hand over the microphone back to Florence, Ninette, I want you to answer this one last question. And we see that digital economy presents regulators with so many competing priorities. We have artificial intelligence, we have digital marketplaces, app stores, digital advertising, and platform ecosystem. So when these come your way, or when we see them in the economy today, what do you see when it comes to competition in Kenya? What are some of these emerging competition issues concerning the authority mostly today?
Thank you, Edmund. So, of course, there's the risk of increasing concentration of economic power through data and digital ecosystems. I think Florence talked to that when she was giving her example. And while artificial intelligence has enormous potential and it has helped to make our lives easier, it has improved consumer outcomes, it also raises important competition questions. For example, in terms of access to computing infrastructure, there could be barriers to entry that may arise, and therefore they reduce competitive pressure. The other thing is that digital platforms operate integrated ecosystems, combining payment, e-commerce, communication, and I'll give an example that's going on in Kenya. So, for example, we have a dominant MNO, I think a mobile network operator, I think everybody knows who that is. They are offering platform, they also have, they have gateway consumers and businesses, and they're also offering other products and services on that platform, and therefore it becomes very hard to be able to maintain open and fair access, and it's critical, that is critical to preserving market contestability. The other risk I see is that when there's a lot of accumulation of consumer data, then the entity or the undertaking that has this data is able to reinforce their market power. And while it would be a good thing, they may be able to develop products that are good for the consumer or improve the consumer welfare, they could also abuse it and cause a lot of harm to the market and foreclose other players. So what the authority is doing is that we are monitoring the market. We have constantly done market studies, as I mentioned earlier, and to check out and ensure that these dominant players or the players with a lot of market do not cause any harm. And lastly, we are also working collaboratively with our regional agencies. We have a COMESA Competition and Consumer Commission that we work together with. We have IACA, East Africa Community Competition Authority, as well as now we have we are ensuring that our regulations are in line with the AFCFTA digital regulations, as well as the COMESA regulations that were launched last year. Thank you very much.
Thank you very much, Ninette. And I'll pose the last question to Florence. Florence, you've already demonstrated how Nigeria conducts the investigations against Meta, and now you're moving towards AI platforms that are releasing unauthorized local news content. So Nigeria is doing a lot. But my question for you is, having led one of Africa's landmark big tech investigations, how do you view the current state of digital competition enforcement across the continent? Thank you. Over to you.
Yeah, thank you. I mean, I would describe it as bright and promising. You've heard from Lynette in Kenya. I would also, on the other hand, describe it as, under-resourced, and I say it's promising because, you've seen what Nigeria did. There are other countries that have looked into it. Kenya, you've just heard, Egypt and COMESA. And so what it is Africa is waking up. We're no longer just an extraction point. And we've made our points. We're no longer going to be treated as, we just come, do business, and we exit. So with respect to under-resourced, which is where the challenge is usually the digital market by its very nature, and we've heard it here today, is quite fast-paced, and it requires intensive economic analysis. and it's data intensive. I mean, look at the Nigerian experience. We started in 2021 and didn't issue orders until 2024. And till date, we're still in court on appeal. So you would see that most competition authorities have to deal with these long investigations. There are limited capacity. We have few or zero economists or data scientists. We are learning on the job. And, you know, most of these big tech are more resourced than we. They also understand their business models far more than the regulators. And so by the time the remedies become implementable, the market has most likely tipped to a point where any reasonable remedy may be unenforceable. And so for me, I would say developing our technical capacity is very important. And it's not just a legal capacity, as I've said. You know, there are other key capacities that we have to develop. Our economic capacity. We need more economists and data specialists to assist in analyzing the information that we're getting. We also need our tribunals and our courts to build their own expertise. For instance, you can imagine going through such a rigorous investigation only to get a judicial pronouncement that defeats the entire process. So it's important. We've heard from other regional regulators today, and it goes without saying, coordination is key. The regional regulators and the continental regulators have provided the framework for that coordination. We don't need to reinvent the wheels. Information exchanges are important. Joint investigations is something that we can consider. Secondments, just to develop our capacity as we go. So for me, it is promising and bright. We demonstrated a willingness and a desire, but we need to develop our capacity. And I believe that we are in the right place, and conversations and platforms like this help us to develop that capacity. Thank you.
Thank you. Before I ask you to take to give us your parting shots, you've reminded us that capacity is important, and you've mentioned the fact that our judges should be empowered. And I remember one of the panels in the morning, it was Patricia from CIPESA, and they're doing some work on building the capacity of judges. I, for one, am a lawyer, and I do a lot of litigation and public interest litigation. I represented a client in a case where the judge misinterpreted what the word digital ID means. The case was basically on digital IDs, the Ugandan national ID being a digital ID system. But when you read that judgment, you will see the need for us to empower our judges. So thank you very much. And I just want to ask you to leave with us your final thought about the future, your experience, what can we learn from Nigeria? Thank you. Over to you.
Thank you very much. I would say that, I mean, I've said it before, the learning from Nigeria is we may have be a young competition authority, but there's keen interest, there's a will and a determination, and we have prioritized the digital market. We've prioritized regional collaboration. And so we expect that, you know, that relationship that we have established over the years, 6 years now, that it would continue to develop and tighten our regulatory process so that there's regulatory certainty on the side of the undertakings, but also to develop ourselves as a region and as a continent. You can expect a lot more from the Nigerian market. Thank you.
Thank you. And I'll come to Annette, if you're still there. I will just ask you to share with us your last, final thoughts, basing on your experience you've shared with us, where you see the future of East Africa and other countries. So what needs to be done? So over to you.
Thank you, Edmund. I have two things I'd like to say. So the first would be that as regulators, we must strengthen regional cooperation. I think this has been said throughout this conversation, because the digital markets cut across regions, and therefore enforcement cannot be seen to be national. We have to work together with our regional competition agencies. We have to work together with the continental competition agency that's being formed. The second thing is about really the objective of competition is to support economic development. So well-functioning digital markets will attract investment, will encourage entrepreneurship, and will expand consumer choice. So as Africa's digital economy grows, competition authorities, Kenya, Nigeria, South Africa, and all of them have an opportunity to ensure that innovation remains broad-based rather than concentrated among few dominant players. Thank you.
Thank you, Ninette. So as we close, I want to leave these questions to the audience, the regulators, public interest litigation lawyers, or any decision maker in this room. Are our existing competition laws in Africa still fit for purpose in the digital age? How should regulators address the growing market power of digital platforms which continue to encourage innovation and investment? The third question you should ask yourself, beyond competition law, what role should data protection, consumer protection, and AI governance play in ensuring fair digital markets? And lastly, how can African regulators develop effective and predictable enforcement frameworks that protect consumers while supporting the growth of Africa's digital economy? Thank you very much, the audience, for listening. I have been a good steward. I made sure I am not the weapon formed against your lunch. And join me in thanking our panelists, and have a great day. Since I'm alone, do I get an opportunity to take a picture?
Thank you so much, Edmond. It's unfortunate you're the only one who had to moderate while standing. I think you've all gotten coupons, lunch coupons. So we are going for lunch. Yesterday we faced a problem. People went for lunch and they spent longer than we had anticipated, and it affected the program. Please, lunch is strictly 1 hour. The lines are not there, so if you rush down now, you'll not face lines. So that we have 1 hour, we have our lunch, then come back here so that we can proceed with our program and finish in time. Thank you so much. If you don't have a coupon, you come to me. Thank you. Hope you all had lunch. We shall proceed for our next session, our very last session. For this session, we have a keynote address from a very, very crucial person in this summit. His name is Mr. Babatunde, and he's a respected legal and regulatory expert with over 30 years of experience driving institutional reform and market regulation in Nigeria and across the African continent. He is the immediate past executive vice chairman of the Federal Competition and Consumer Protection Commission, where he spearheaded a transformative shift in Nigeria's consumer protection and competition landscape, including the operationalization of the country's first comprehensive competition law regime. Under his leadership, the FCCPC initiated Africa's first major big tech accountability case by investigating Meta and WhatsApp over alleged uncompetitive conduct and data privacy violation. This landmark action caused 220 million USD ban, administrative penalty, the first of its kind on this continent. The case later created a powerful precedent for enforcement across the continent. He also oversaw the imposition of 110 million USD penalty against the British American Tobacco for breaches of Nigeria's competition laws, further reinforcing regulatory accountability and strengthening market discipline. He has advised and represented the federal and state governments, regulatory agencies, and international organizations in complex, high-impact matters, including major aviation accident claims and multi-jurisdiction consumer and competition cases. We thank you so much, sir, for being here, for giving us an opportunity. As I said earlier, it's a privilege to associate with you. We thank you for flying all the way to come here to speak to us. And interestingly, he's a pilot by profession. You should be clapping. How many of you are pilots? You should be clapping for our speaker. You're most welcome, Mr. Babatunde.
Good afternoon. And I must say that you're very resilient people to come back after lunch. I'm not sure our host's threats were sufficient to make you come back. First, let me thank the folks at AdLegal and the BTA organizing team. I also want to extend my respects to the very kind and warm hospitality I have received from respected people here and those who have joined you virtually. When I first received the invitation to speak at this event, what caught my eyes more than anything else was the fact that it was an accountability summit. And whether it's regulating big tech or consequence management for inappropriate conduct, whether in government or in the private sector or in schools, accountability continues to be a point where, as a continent, we score a very low grade. And accountability and consequence management are by far the greatest modifier of human behavior all over the world. There is nowhere where people are materially different. It is accountability frameworks and consequence management systems that operate on people's minds and makes them act in certain ways. I remember once that a very large corporation in the United States was very interested in doing business in Nigeria, and I know, like, very interested in doing business in Nigeria. Very keen, actually. They were so keen. They had done the numbers. They felt it was going to be really good. But they were jumping through all kinds of hoops and trying to get on ground. And some of it seemed to lack transparency as the story went. And so at a meeting in the General Counsel's office in a very high floor of a fancy high-rise in a major city of the United States, the General Counsel goes and stands at a window during a meeting. And then he calls other people at the meeting in his office and says, come to this window. And then they look outside the window and he shows them another high rise. But that was empty. That high rise was empty and just had a big E in front of it. And that company, that high rise used to belong to Enron. Enron was a massive energy company in the United States. At the time, Ken Lay, who was Enron's chief executive, is late now, was in jail. And most of the company had been scattered. People were in jail because they were investigated under the Foreign Corrupt Practices Act. And so this gentleman said, we really would love to be in Nigeria. Everything shows that it will be excellent for us. But the risk and going to jail is not worth it. And so that's real and raw. I want to be there. I like this business. I want this margin. I want the returns. But in the event that we go about it the wrong way, the consequences are such that they're so dire. And so anything that has an accountability system, that is, that holds people to account, that exposes inappropriate conduct, whether it's intentional or unintentional, is something to be embraced. As a matter of fact, when I counsel companies, especially after being a regulator, I say to them, an accountability system is your best friend. It's your best friend. Something that holds you accountable, something that makes you think through before you do anything. Look at it as your compliance framework. If you don't want to get caught with your hand in the cookie jar, make sure you have something reminding you about how small the neck of the cookie jar is. And so that's why, for me, supporting this, including coming, was a no-brainer. And I'm grateful I did. I mean, I've enjoyed my time here. I know that a few months ago, global news about COVID could have discouraged people from being seated here, but I'm grateful that it didn't. Certainly didn't discourage me from getting on a plane and coming here. Having said that, big tech and market power in Africa, why competition law has become inevitable. Competition law has become inevitable because, in reality, that's the last bastion. That's the last man standing from an accountability standpoint. And so it's a privilege to join you all here at the Big Tech Accountability Summit to discuss the issue that will shape not only the future of competition law, but even the future of trade and economy on our continent. We're living through one of the most significant economic transformations since the first industrial revolution. Today, the most valuable companies with the greatest market caps are no longer those that produce steel, oil, or automobiles. Recently, I saw something that I think shows that Amazon is valued at what? About $1 trillion, isn't that the case? And that is the case also with SpaceX. And these are technology companies. And by the way, if you take the time to look at the logo on the cars on the street, the sheer number of Toyotas you would count globally, everywhere in the world. But Toyota as a company, with all those cars, with all these assets and everything, it's not even $500 billion market cap. And so we know that big tech has arrived. And so today, most valuable companies in the world are no longer those that produce steel, oil, or automobiles. They're companies that connect people, collect data, facilitate transactions, and increasingly influence how we communicate, how we trade, how we work, how we think, even how we live. Across Africa, millions of people begin and end their day on digital platforms. We communicate on it, we follow through our work, we do our work on it, we're communicating with the office, communicating with home, communicating with family. And so we start our days, during the day we're on it, we end our days with it, put our phones down, and then wake up to it again. And so, even for businesses, small businesses rely on Facebook and Instagram to advertise. Families communicate through WhatsApp. Consumers search for products online before making purchasing decisions. And even those purchasing decisions are made and done online. Ride-hailing applications determine how people move around our cities, while digital lending applications increasingly influence access to finance. You know, it's interesting to know that Airbnb has a market cap that is far more than any hotel chain. More than Sheraton, more than Marriott, more than the Ritz-Carlton. Think about the sheer number of properties, Marriott, Hilton, and all these hotels, the chain across the world. And you've got an Airbnb that doesn't have a single property, having a larger market cap. Or an Uber that doesn't have a single taxi. So there's no doubt that big tech has transformed our lives for the better, no question about it. These platforms have reduced barriers to doing business, connected entrepreneurs to customers across borders, and expanded financial inclusion and accelerated innovation across our continent. Especially on a continent like ours, where the vast majority of people are young, creative, energetic, and very driven. Technology is the path to the future. But with all these benefits also comes some uncomfortable truth. We can run away from it as much as we like, but the reality stares us in the face. As digital markets have expanded, so too has the concentration of economic power. A handful of global technology companies now exercise extraordinary influence over digital infrastructure, online advertising, consumer data, digital payments, and access to markets. And not just that. They exercise influence over states, non-state actors that have more power than state actors. They exercise influence over governments. And it's not just the small, developing, emerging, or poor countries where they can come in and exercise influence. They exercise influence over even the White House. This is power. Not soft power. Not hidden power. Raw power. When a small number of firms become gatekeepers of digital commerce, the concern is no longer simply about size. It's about whether the market remains open to innovation, whether businesses can compete on the merit, and whether consumers retain genuine choice. The Nigerian Constitution, for instance, has what we call it Chapter 4, the Directive Principles of State Policy. In that chapter is actually the fundamental about the state, what the country is about, what the national priorities and aspirations are about. And it directs that every arm of government must exercise its powers looking through the lenses of those provisions. And right there in that chapter 4, the Constitution says that all the arms of government will exercise their powers, and the government will ensure that wealth or the means of production, again, wealth or the means of production is not concentrated in the hands of a few or a group. Taken away from law and put differently and simply, essentially, you've got a constitution that the people have created for themselves, saying that what we are about and what we are for is shared prosperity. I don't know the language in the constitutions of many of the other states on the continent, but I have absolutely no doubts in my mind that the supreme law, the supreme principle, and the underlying purpose of our states across the continent is to promote shared prosperity. And so I have always said that the ground norm, or the most fundamental driving piece of law for competition regulation in Nigeria is the Nigerian Constitution. When the Constitution specifically says that government will exercise its powers to ensure that wealth and means of production, meaning business, is not concentrated. And what is competition really about? Regulating concentration, correct? And this isn't a provision of law that is talking about cartel. It's not talking about who's doing predatory pricing or not. It just says that we are against concentration. So it's not about whether you've committed a crime or not. It's just that it says that concentration is not in the best interest of the society. And this is a very important nuance for regulators and for business also. So businesses should know that when a regulator is seeking to address issues of concentration, it's not so much as picking on a business, it's not so much as finding that this business is violating the law. Essentially, the regulator is trying to ensure that the purpose of the state that makes it absolutely possible for everyone's inalienable right to participate in the economy is not foreclosed. Not only is it not foreclosed, there are no barriers to it. And one of my favorite sayings as a competition regulator is, I always say that the markets are open for exploration, but not to exploitation. And for me, the market is not operating well if some are unable to enter. But you know what? If all are only able to enter, the market is still not optimal. It isn't a good market when some thrive and others barely survive. We must have a compliance or market regulatory structure that allows everybody to thrive one way or the other. And so when a small number of firms become gatekeepers of digital commerce, which is the future of business, the concern is no longer simply about size. It is about whether markets remain open to innovation, whether businesses can compete or not. This is why competition law and regulation is inevitable. Not because governments wish to regulate successful businesses, not because governments want to punish success. As a matter of fact, success that is a product of innovation is worthy of reward. But because every successful market economy depends upon rules that prevent power or dominance from being abused and preventing one or a few from controlling the market. Traditionally, competition law focused primarily on prices. If prices are low, regulators often assume that markets were functioning well. But we all know that that theory of competition regulation has been disproved. Digital markets have challenged this assumption. Many of the services we use every day appear to be free, but they're not necessarily or truly free. Consumers increasingly pay with their data, their personal data. The law is very clear, both statute, principles, and case law, that personal data is interest, and that citizens have a proprietary interest in their data. It is their property, it has value, and they can exercise control over what they do with it, who they give it to, and what that person does with it. And so your personal data is worth something. Consumers increasingly pay with their personal data, their attention, their behavioral information, and in many cases, the waiver of their rights to control their data or the consent to disclose or share their data. Essentially, data has become one of the world's most valuable economic assets. I have sometimes heard the cliche that data is the new oil. I'm sure some of us have heard that before. The more users a platform attracts, the more data it collects. It's that simple. The more data it collects, the better its algorithms become. And you know what? Better algorithms attract even more users. So that's the cycle. This creates powerful network effects and makes it increasingly difficult for new entrants or smaller businesses to compete. The result is that competition is no longer simply about price, it's also about data, it's about the digital ecosystems, interoperability, self-preferencing, access to markets, and consumer choice. So think of a young girl in Kampala or Kenya or Lagos or Johannesburg or Egypt or in the Central Africa, Malawi, Ethiopia, who has perfected her small trade, whether it's wig, hair, or garments, and wants to sell online. Her competitor is Amazon. Even though that's also her platform. And so, the reality that we have now is that Africa must not remain on the sidelines while these changes unfold. And gratefully, Africa has not remained on the sidelines. Across the continent, competition authorities have recognized that digital markets require fresh thinking, new enforcement approaches, confidence, boldness, and courage. South Africa has arguably led some of these conversations. Its Competition Commission conducted the Online Intermediation Platforms Market Inquiry, a game changer for the market, because it examined whether dominant digital platforms treat local businesses fairly, whether search rankings disadvantage smaller firms, and whether commissions and platform rules undermine competition. The inquiry recognized that digital platforms can become essential gateways between businesses and consumers, creating responsibilities that traditionally businesses may never even contemplate. In Kenya, the Competition Authority has become increasingly active in examining digital commerce, fintech, and online marketplaces. As one of Africa's leading digital economies, Kenya appreciates that promoting innovation must go hand in hand with ensuring that dominant digital firms do not foreclose opportunities for local enterprise. Egypt has similarly strengthened its focus on digital markets by investing in specialized expertise on algorithmic pricing, digital platforms, and emerging technologies. It recognizes that competition authorities must understand not only the legal principles, but also the technology that increasingly shapes modern markets. In Morocco, the Competition Council has emphasized the importance of digital market competition as part of the country's broader digital transformation agenda. This growing convergence is actually very important. It demonstrates that Africa is developing its own competition jurisprudence rather than just merely watching and following what is happening in the rest of the world. Nigeria's experience is notable. Nigeria had or has done one of the most robust enforcements with respect to digital lending. And recently, that has culminated into a large, broad regulation for digital lending that protects consumers, that creates inclusion, that ensures that data is democratized, and that puts guardrails on even how interest is calculated. Nigeria's experience with Meta also represents one of the clearest examples of this Imagine African approach. The investigation into Meta and WhatsApp was never simply about imposing a penalty. I can tell you that much, because that was my investigation. It wasn't a recommendation to me, it was an original initiation by me. It was about asking a fundamental question. Can dominant digital platforms impose terms on African consumers that they would not impose elsewhere simply because they believe they can? And like the operative from Nigeria said, the question was, why? Why can you say to people, take it or leave it? The only reason is they don't have a choice. And choice, as we know, is a very important competition principle. The question lies at the heart of competition policy. Why? Why can you? The investigation examined concerns relating to unfair privacy practices, discriminatory treatment of Nigerian users, limitations on consumer choice, and the extensive collection and use of personal data. WhatsApp competitors were analyzed. They were taking most of their data from about 4 data points: Signal, Telegram. But WhatsApp was taking data from 44 data points for providing the same service. So what were the rules of data minimization? Take only what you need. But because WhatsApp was able to use it to feed other platforms within its family. One of the most significant issues was whether Nigerian consumers were receiving a lower standard of protection than others in other jurisdictions, despite contributing equally to Meta's global business model. For instance, I'm going to skip all of that because it's been discussed. The rules under Europe, the GDPR was similar to the NDPR, which was the Nigerian data protection regulation at the time. Yet, users in Europe had choice. They could say yes or no, and even after they said yes, they had the prerogative to withdraw their consent. And that wasn't the case in Nigeria. The question is why? Why would you be able to do that here and not elsewhere? It will come down to 2 things: your hold on the market and people's lack of choice, and possibly a weakness in the regulatory framework. Competition law has long recognized that consumer harm is not limited to excessive pricing. Consumers may also suffer when they lose meaningful choice, when unfair contractual terms become unavoidable, when businesses exploit information asymmetries, or when dominant firms leverage market power to strengthen their position across multiple markets. The outcome demonstrated that African regulators are prepared to engage seriously, and I mean the outcome of the WhatsApp and the Meta investigation, show that African regulators are prepared to engage seriously and robustly with these critical questions. It also reinforced an important message to global technological companies. For me, and what I've considered a very strong thing, is that Africa as a continent, from the time of slavery, has always been an extraction point. Extracted people, and then after a while, we go to the mineral rights, we extract. Then agriculture, almost everything we produce is raw material somewhere else. The wood comes from here, furnitures are sold back, cocoa goes from here, chocolates are sold back. And in the 4th industrial revolution, we actually must add value. Or else, so long as we remain an extraction point, the likelihood of our economies leaping to their full potential remains very diminished. And so here we are on the cusp of the 4th industrial revolution, where on your marks, at the same marks, Africa has the talents, the professionals, the knowledge, and the courage, and the energy. We shouldn't have to be an extraction point for data. Data shouldn't just be gathered across the continent and taken away, not stored, not processed, not anything. And so Africa must stop being a market merely to be served and taken. It is a jurisdiction with laws, and those laws deserve compliance, and the institutions must be recognized. And this evolution is actually taking place against the broader international backdrop. Such a good time. The European Union has introduced the Digital Markets Act. The United Kingdom has established a specialized digital market regime. The United States continues to pursue major antitrust actions involving several technological companies. In the news today is the fact that the United States Department of Justice Antitrust Division has appealed the decision where the penalty was insufficient against Google. These developments reflect an emerging international consensus that competition law must evolve alongside technological change. Competition law must evolve alongside technological change, and competition law must be versatile enough to understand and see how and the broad scope of its applicability. One of the things that became very apparent in the Nigerian investigation is the intersection of competition law and constitutional guarantees to citizens' privacy. 1. 2, the intersection of competition law and consumer protection law with respect to people's prerogative to have a choice. 3, the intersection of competition law and data protection and privacy laws and consent. And so here you have competition law literally intersecting almost all these facets, which is where I started by saying that competition regulation perhaps is the last man standing and the inevitable honest broker or intervener. Africa should certainly learn from the experiences of others, but Africa need not replicate them. Africa should use them to define Africa's own objectives and develop Africa's own solutions. One thing that is most important is that Africa must not see itself as different from the rest of the world. Africa must not see itself as inferior or less deserving, whether it's with respect to non-monetary remedies or even monetary remedies when it comes to valuing people. Our digital economy is different, our markets are different, our developmental priorities and national priorities are different. Our competition policy must therefore reflect Africa's realities while remaining consistent with the internationally accepted principles. And again, I'll use Nigeria as an example. Currently on the books, Nigeria has somewhere in the region of about 34 to 38 million MSMEs, as medium and small scale businesses. That's the population of some countries. The vast majority of Nigerian young people are entrepreneurs. So doing their small business, doing their small things and all of that. And so they deserve protection. And I think this is the case across the continent. That landscape, based on our demographics, requires specific attention in how we develop what our solutions and policies would be. The platform operating in Lagos today serves consumers in Nairobi, Kigali, Accra, Johannesburg, Cairo, and Kampala simultaneously. I've only been in Kampala a few hours. The gentleman who helped me with my bag this morning was asking me about Pete Edochie, some other Patience Ozokwo, meaning that he's watching Nigerian movies here. Before we ended our conversation, he spoke about Nigerian football, and then he spoke about Egusi. And then he said, look, he buys kaftans from Nigeria. I said, how? He says, on Instagram. His sister buys hair from Ghana on Instagram. That's the market. And that's how Africa is today. Africa has the highest unemployment numbers in the world. Just imagine how compounded that problem would be if we didn't have an energetic demography of young people who are finding their way and doing their things one way or the other by themselves. And so a market framework a market landscape that captures and encourages that or protects it at a minimum. It's the duty of the state. It's not even an option. It's a fundamental obligation the state owes to the citizens. No single authority can effectively regulate these markets in isolation. That we know already. If there was ever a place where that is the case, it is Africa. Africa is not the largest continent by landmass, but it has the most number of states, many of them small. And with these companies being bigger than states, having so much more influence and power, even the threat of withdrawing services from a state can cripple the state. So it's very clear that if we stand alone or by ourselves, we can't win. And so the only way is to eschew isolation and pursue collaboration. The future therefore lies in cooperation, information sharing, joint investigations, capacity development, technical assistance, and consistent legal standards. Mutual trust among African competition authorities is non-negotiable. I remember when we were going to start the WhatsApp investigation, one of the first things I did, once we saw that the way the digital markets were going, we were going to need muscle. I reached out to colleagues in Cairo, Nairobi, Johannesburg, and I think one other country, I forget, and spoke to my colleagues there and said, we should have a meeting as heads of competition authorities. And that's how we started what you call the Heads of Competition Authorities Dialogue on the Digital Markets. Because I realized that if you go it alone, your weakest point is not whether your national courts would agree with your ultimate findings, but whether your neighbor can disprove the theory, when in actual fact is exactly the same thing that happens next door. And so because of that, it became very clear that we must be one for all and all for one. Collectively, Africa represents one of the world's fastest growing digital markets. Acting together, our institutions can ensure that digital markets remain open, competitive, and fair while continuing to encourage investment and innovation. Ultimately, our objective is not to punish success. Successful businesses create value and innovation should always be rewarded. But competition law reminds us that markets function best when success is earned through innovation, efficiency, consumer value, not through exclusionary conduct, not through erecting barriers or unfair practices, or the accumulation of unchallengeable market power. The market must remain contestable. Any market that is not contested, there is only one victim. It's the people. I remember I said once to senior government officials in Nigeria that monopolies are not good. Naturally, they occur, but it doesn't make them good. They may not be unlawful, but they are not good. And this was about selling a government-owned enterprise to the private sector. I said, the only one thing I know that is worse than a public monopoly is a private monopoly. Because a public monopoly doesn't care about profit, right? It's government. And it's not efficient. It doesn't feel the need to innovate or change. It's not competing with anybody, but it still doesn't care about making money. And so prices may not change, everything might be okay. But a private monopoly has exactly the same incentives. No need to innovate, no need to be efficient, but it's keen on the bottom line. So that's why I say private monopoly is the only thing worse than a public monopoly. And unchallengeable market power is one of the greater problems we have in Africa. History teaches us that every generation must adapt its institutions to new forms of economic power. Yesterday it was railways, then it became oil, then telecommunications. Today it's data, it's the digital platforms, and it's artificial intelligence. It's upon us. The challenge before Africa is not whether these technologies will shape our future. They already are. The challenge is whether we will ensure that this future remains competitive, innovative, inclusive, and accountable. The challenge is whether, as it has always been, we will be playing catch-up or we will be running at the pace the rest of the world is. I'm confident that Africa possesses the legal institutions, the regulatory talent, the talents in this room, the energy, the desire and the passion, and above all, the collective determination to meet the challenges of the digital market, making it successful, finding the right balance, and regulating it correctly. If we succeed, we will not simply participate in the global digital economy. We will help shape it. And that way we would have earned our seat at the table. But make no mistake about it. If we're not sitting at that table, then we're on the menu on that table. Once again, I want to thank you so much for inviting me, and I wish you a very good time for the rest of the summit. Thank you very much.
I thought I was tall, but I have to adjust the mic. Yes, I always pride myself, but today I've been challenged. Thank you, Mr. Babatunde. We celebrate your principled leadership, legal excellence, and a vision of governance founded on fairness, accountability, and service to the public. Your legacy has continued to inspire us and so many other people who believe that lasting change begins with courage, leadership, and unwavering commitment to justice. So, I told some of you we are going to be awarding. You people left because we started registering at 2. People were not here. So we have a special honor for people who were around. For you who left, I told you. So please welcome the executive partner, Kalikumutima Advocates, Mr. Deo Kalikumutima. He's going to give an honorary gift to someone here who followed my instructions and was here. So you're most welcome, Mr. Kalikumutima. It's a privilege to have you.
Thank you so much. Good afternoon, distinguished ladies and gentlemen. Good afternoon. After that very insightful discourse, I will humbly request, I would request for a standing ovation for Oga, but he seems a very humble man. I humbly request that we clap for him in a more deserving and befitting manner. Thank you so much, and allow me to call you Oga. Because you all look tired, I'll be very brief, very brief. On behalf of Kalikumutima and Company Advocates, a corporate commercial practice that I have the humbling privilege of leading, I'm sure someone spoke on behalf of the Uganda Law Society earlier, so I'm not here to speak on behalf of the Uganda Law Society. Allow me extend a very humble token of appreciation to you, sir, for the very insightful discourse. The world is moving. The question is, for how long are we going to keep playing catch up? We are living in a global age. We are talking digital economy. You have shared the global perspective. You have shared the African perspective, and indeed, the Nigerian perspective. For Uganda, if I may, I'll say, we are in the formative stages, and that is my humble opinion. But we cannot play catch up for long. For the legal practitioners here present, I salute you. I wish it was a full room, because in this day and age, one of the many things that are going to set you apart is not just your style, but your ability to be agile. You need to be dynamic thinkers. Competition law looks at abuse of success. Healthy competition. That is how I summarize it. Now, I will humbly request you, Oga, to please come forward kindly. If you're tired, I'll walk towards you and hand over. In Uganda, we have to declare whatever we are giving, so I'm going to open what I have for you. Fortunately, I don't work with government, so there's an exception to that. But allow me. Oga, this award is presented to you in recognition of your outstanding leadership and lasting contributions to competition law, consumer protection, and regulatory excellence across Africa. We salute you, sir. I'm 6 feet tall. I thought I was tall until today. So because I don't work with government, I will not open this. But also allow me to hand this over to you. Thank you so much. Have yourselves a very blessed afternoon. Oh, for a moment.
The executive partner will have a photo moment with Mr. Babatunde. Our executive director can join shortly, and other directors. Can you give him a minute? Let the man shine, then you can join.
No, I'm not shy.
Is Nico around? So we shall, Mr. Babatunde, the ad legal team would also want to have a picture moment with you. It's not ours, but the entire ad legal team can come. The others are coming. I'm giving them in bits, so don't worry. So we are going in for our next session, but you look so tired. Is there a problem? You people look so tired. Which exercise did you do? These people look so tired. You guys, let's stand up. You people look so tired. Hello? Hello, I can't hear you. Okay, wait. Lawyers, counsel, technical experts, please be active. Yeah, now I can see the back. So this is to see if you are a good listener, and this is to see how fast you are, right? When I say clap 6 times. You're going to do it very well. I say clap 6 times. Raise your hand, shoulder. The loser want to see the winner. Usually we do have that, but no one sees the winner. I don't know if it will be our guest or assistant. Clap. Very big clap. Clap. Raise. Shoulder. Clap. Shoulder. Okay. Clap. Raise. Shoulder. Clap. Raise. Shoulder. Clap. Shoulder. Raise. Clap. Shoulder. Raise. Clap. Raise. Shoulder. Clap. Raise. Shoulder. Clap. Thank you so much. Now you're more active. The next, this next session, I would say, is one of the hot topics around the world: the issue of AI overviews and compensation for content creators. As Mr. Babatunda has been explaining, we have the highest rates of unemployment on the African continent, but our young people have decided to use the digital world to create opportunities for themselves, to create job opportunities for themselves. So this is where the question of content creation comes in. Please welcome with me our moderator, Mr. Tony Galandi, who is the founding partner of Diamond Advocates. He is a digital competition lawyer who was recently part of the fresh cohort of the Oxford University's digital competition delegation. Join me welcome this very important guest. I had not yet met him. You know, he's from Oxford, so I want to hold his hand to get English air. Welcome back from Oxford. I want to touch you. The blessing of Oxford. Wow.
The MC has decided to leave me in the middle of the sea. Nonetheless, I'll find a way to wiggle the waves. Ladies and gentlemen, my name is Tony Kire Galandi, and I lead a team at Diamond Advocates. We are really very passionate about technology, about competition law. And granted permission, I think I will be holding the next session. Who pays for the news in the age of AI? I would want the tech team to create. First of all, I'm going to be privileged to moderate this very, very exceptional team of experts. I would want to take the singular honor of welcoming them in no particular order per se. And I will start with Rosa Carling, Director Foxglove. I am confident she's joining us online. You're welcome, Rosa.
Thank you. Lovely to be here.
Thank you. And let me also take the honor to invite Mr. Deo Gracious Wamala, one of the celebrated award-winning journalists this country has. Please kindly take your seat. Let's just give them hand claps, you know. I would also want to take the pleasure to invite Jeremy Andy, founder Angitech. And I would also love to invite Professor Dr. Somath Hopner. I'm sure he's joining us online.
Yes, thank you for the invitation.
Great. Here. And I think if it's a football team, the 11 is complete. Thank you. Ladies and gentlemen, good evening, and you are welcome to the Big Tech Accountability Summit here in Uganda, Kampala. And the conversation today is who pays for the news in the age of AI? Quite a controversial topic. And we are blessed with people who have done a lot in this area. Like I said, many of these people require no introduction because their names speak for themselves. This session is going to take 1 hour, and I'm going to ensure that I utilize the time to the later. We'll have an average of 10 minutes to each of the speakers, just for purposes of context. Now, when we speak about the news in the age of AI, many of you realize today that you will go to the website of that favorite publisher and you can't get information because he requires you to subscribe, he requires you to pay. But then when you use your gadget, so for example you Google search, you are able to get that information without necessarily going to the site of the publisher. And the question is, who is now benefiting out of that hard work of the publisher? Number two, how can that publisher be compensated? Number three, what should be done? Number four, what has been done so far? Now, ladies and gentlemen, you are going to realize that there have been baby steps and efforts to resolve this impasse. For example, you realize that in the recent past, countries like Australia are enforcing bargaining. You are also going to realize that countries like Nigeria, from the African perspective, have gone an extra mile and pushed this discussion further That is through their Competition and Consumer Protection Authority. But also, the EU Commission has gone an extra mile to say, wait a minute, we need to investigate whether there is fair competition. And today is why we are here, to expand that conversation from that perspective. And right there, I want to pick it from the award-winning journalist, Mr. Wamala Deogratius, from the Daily Monitor and the Nation Group. One of the leading,
Nation Media Group.
Nation Media Group, one of the leading media firms in this country, and you know, in depth. And I think I'll pick it right from there, Deo. Deo, you have been at the forefront of original works. You get down into the tunnels, into the farthest of this country. You generate information in its original form. You get us those pictures right at the source. But then, we no longer need to subscribe to your site to access some of your information. And from the position of a forefront journalist, I want you to give us your perspective. Number one, how do you think this affects the works of the publisher in all angles? And I'm going to give you a big latitude so that you can be able to speak from the experience point of view. So you have 10 minutes to take us through so that we feel the justification. Maybe we are just worrying for nothing. It's not necessary.
Right.
Over to you, Deo.
All right, thank you. I'm Deogratius Wamala. I do journalism in business, mainly business, economy, finance. I also do energy and technology. So I'm going to provide a perspective from the media business, especially from creation, the business model, how this becomes reinforcing, like it's a loop that you can't just escape. And then I'll also shed a light on why it's hard for even us to negotiate a better deal in that sense against the big tech. And then I'll also delve into what I think should happen next in terms of solutions. Now, starting off from the perspective of the media business, because now the way the media business happens is that you go and create work that can be print. So the company goes and employs journalists and reporters and editors and fact checkers, and bears a legal risk at some point, because we are going to maybe investigate a case about policy, a case about corruption, a case about energy. So you find that that is a very big investment at that point. But then at the back of it, you aim to attract masses. You aim to do a very good job so that masses come to read your content or to watch your content. But then when that happens, you also hope that they are going to be either inspired, they are going to learn, or they are going to benchmark to the point that they are going to pay and also share that content to other people. Now, it happens that you go and do all that investment. That is a very big upfront investment. You hope to recoup it at the downstream when the demand side, when the people come and pay for that content. Now, what happens is that when you do that content and then you put it behind the paywall, you expect that whoever is going to reach that content is going to pay some subscription at some point. But now, the big tech like Meta and Google, they somehow have models that go behind that paywall. I don't know how that works. Maybe the tech people will tell us. So, and that kills it somehow distorts the business model. So the supply side is that we shall be producing content. But then on the demand side, now there is someone in the pipe between the payment, someone who's going to pay, and the content. So the model is going to fetch that data and then give you a summary of whatever happened. And then now you find that the very essence of that business, of you doing that work and then locking it behind the paywall, doesn't make sense to you. Now the problem is that it is very hard to escape. How? Because the more this website gets this content behind the paywall, the more it becomes better. And the more it becomes better, the more it becomes larger. And the more it becomes larger, the more leverage it has over you. And the more that happens is that even people will trust it to get info from that site than you, because they know that you're going to charge them at a certain point, but it's going to get the same content for free on maybe Google. Now the problem that brings is that you can't go to Google and say that this is what happened. I paid a lot of money to these people to get me this content. I invested a lot of this, but now people are taking my content for free. Google, as you know it, the big companies in the world are tech companies. So it means you have no that leverage. So now we find a scenario where, of course, they are going to argue that we are going to attribute this information like it comes from Daily Monitor. So people are going to know that this information is coming from you. But now, this distorts the whole business, because you don't, yes, of course you want the reputation, you want people to know that you did that work, it's an original work, but you also want the money part of it, because that's the whole idea as to why you went into business. Now you find that you can't even escape that loop. And the other thing is, when you try to escape, the search engine is going to say that we are also going to lose visibility of this whole content. And that means you're going to lose the gateway that allows people to read your content. Now, as far as it goes, you find that it is not really a game where you can sit on the table with some people and then you bargain and then you get a fair deal. Now, what we've noticed is that, first of all, we don't know how much content is being fetched from the website. So you find that you don't know how much content. And even if you knew, how would you put a price to that content? Because let's say that this guy is now disclosed and tell you that this is what we got from this mark. Now you have that data, but how are you going to put a price to that work? Now the problem is that even if you knew the price, now you know the content and you also know the pricing. How are you going to negotiate with them? Now you find that most of the producers of information of content, they are fragmented in a way that you find that you have Next Media, you have Daily Monitor, you have Independent, CEO Magazine, so many of them here to say. So you find that you have no leverage, you have no bargaining power. The best thing that you can do maybe is either pray to God or you collect this. The music industry has something that they call collecting licenses, where they amalgamate, they make a group, they approach a company that is going to protect this work. Somehow the royalties are paid to that company, and then that it distributes those payments to the creators. Now that's something that is not happening in the media business. And then when you do that, like you rightly said, in Australia, the law says that if these guys fail to negotiate, then government will come in to force a deal. So it's actually, you don't even need to enforce it, because a threat, like for instance, Meta using info from Daily Monitor, and knowing that the law in Uganda says that if you guys fail to make a deal to disclose info that you've taken and how much you're going to pay them, then after maybe 30 days, we are going to force that deal to happen. We are going to bring an arbitrator, and it can go against you. So that threat alone can be very helpful without you enforcing it. Now that is not happening as well, but I think these are some of the things that the regulator can start looking at, where you're looking at the transparency, you're also looking at the collective licensing, and you're also looking at the mandatory fines that come with that. I think that is what I can say at the moment.
Thank you very much. Thank you very much, Dale Gracious. And I think listeners, both who are listening to us world over and right here, I think Dale Gracious grafts one very key important thing. Look here, I go out in the field, data in the boats, and then collect all this data, and then at the end of it all, there's somebody who's just waiting for it online because the search engine can be able to access this and is curating this data and creating this information. And then, wait a minute, I have rent to pay, I have workers to pay, and then, there must be something that's to be done. And those who have been asking the question, should publishers be compensated in situations like this one? I think you check where the narrative is actually taking us. And I think, thank you very, very much, Deo Gracious, you position from the knowledge point of view, but also from the expert point of view. Thank you very much. Ladies and gentlemen, this takes us to the next school of thought, and this is going to be coming from none other than Rosa Carling. Now, Rosa Carling is one person you'd want to listen to if you want the perspective of competition law from the European perspective. Rosa Carling is a director at Foxglove, and they've done a lot of work. They have put big techs to the wall to adhere to basic standards. Rosa, you're welcome.
Thank you so much. I do hope my audio is working okay.
No, your audio is loud and clear. And just right there, Rosa, you were director at Foxglove, and not long ago, you filed a complaint at the European competition regulatory body. And if I can recall, you were challenging, the overreaching hand of Google, curating this information and taking cognizance of the publishers. And you pushed the regulator into starting, an investigation, and the antitrust investigation. From where you sit is where I really want to pick up. Number one, what prompted you? What prompted you? But also, to give you a latitude of this conversation, I would want you to share with the world what are those areas, so that we learn, these are tech enthusiasts, these are competition lawyer enthusiasts, these are activists. They're saying, we look up to Rosa. She has taken the big step. So I would also want you to take us through on those areas you think they are the ones that were able to move the EU, the European competition to start an investigation on the antitrust. Why is that important? Is because the audience listening to you knows that there's so many complaints go to the commission, but the responses are not, to every complaint. So that would be very, very important, Rosa. And lastly, this is the Big Tech Accountability Summit in Africa. And we have legislators from COMESA and also other entities, Nigeria among others. From where you sit, what lessons would you want the African legislators to pick from your experience on how they should be able to deal with some of these AI-related competition issues? Over to you, Rosa.
Thank you very, very much, and thank you for those incredibly kind words. So maybe just to explain a little bit about Foxglove, we're a non-profit. We're registered in the UK, but we work globally. Our name, which is a name of a flower, the Latin name of which is digitalis, is both medicinal and poisonous. And that's how we see technology. It can be a wonderful thing, but it can also cause real mischief and harm. And Foxglove works to try and stand up to big tech and to governments, and we try and work for a future where technology is used to benefit everybody, not just the rich and the powerful. It's very clear to all of us, I suspect, in this room that the digital world is now not a space apart from us. It's the medium through which we seek work, friendship, love, homes, everything. And of course, it tells us what the news is. And as a result of that, it really is a battlefield on which I think our societies can be won or lost. And the tech corporations and very powerful states, in our view, are not going to build a fair tech future without us all demanding it. And that demand can obviously take many forms. Foxglove chooses to use the law. We sue companies to try and highlight and hopefully change the behavior of companies and government and their use of technology. And we very much try to build teams and partnerships and hold hands with litigators, campaigners, communicators across borders and across disciplines. Because from our perspective, nearly every social harm that big tech causes, whether it's worker abuse, misinformation, surveillance, it's massively exacerbated by their size. And this gets worse as you radiate from the center of power of those big companies in the US. Because people in Myanmar or Ethiopia don't have the same political levers to rein the companies in as those in the US themselves. And it's within that framework that we started to challenge Google AIO and Google Mode, very much in the public interest, and it wasn't about seeking compensation for damages in the past. There's wonderful work happening there. But our work was very much in the public interest to try and protect the public conversations and protect, which feels so important, the plurality of voices that we all need in our public squares and democracies, and the need for an independent, sustainable news industry. And our concern is, particularly with generative AI, that if generative AI is left untouched by the regulators, untouched by our governments, untouched by the courts, then AI really will be the final nail in the coffin for independent press. And so the states must intervene, and they must do so quickly. Now, South Africa was the regulator that was well ahead of anything that anyone was doing in Europe or the UK. They opened an investigation into big tech and the media some time ago. And they did highlight, one of the key highlights that they raised in their interim report was the impact of generative AI products, including ChatGPT, Google AIO, Google Mode, on the South African constitutional right to freedom of press. And in the interim report, it called for a data opt-out. And that is really, really crucial, because what the state can do to intervene and protect our freedom of press is to request an opt-out. And let me just explain why that matters. At the moment with Google, in lots of nation states, there are going to be some exceptions to that, which I will come on to. If you, as a news outlet, elect to opt out of your data being crawled, I would then say stolen and used as part of Google's AI generative summaries, so the AI mode and AI overview. You as a news outlet are then kicked out of Google Index. Now, Google has a 90% dominance of the search market. So if you are kicked out of the Google Index, you're basically kicked off the internet. And so a meaningful opt-out that allows the news industry and others and other publishers, other content creators to opt out of the generative AI products and remain on the search result page is completely crucial. It's crucial because it would mean there's an immediate halt to Google's stealing of everyone's work without consent or compensation. It would also mean, and this is what we very much hope will happen, is that the negotiations which my colleague just mentioned could be much more meaningful. At the moment, when you as a news outlet turn up to negotiate with Google, Google is already stealing all your work while you're at the negotiation table. As one of the Google ex-lawyers said to me, it's like turning up at a gunfight with a knife. It's hopeless. Very sadly for us, the South African final report was not quite as robust as its interim in relation to the opt-out. And one of the questions that I've always had, and maybe others in the room will have a much better answer to this than I do, but I do wonder if the outcome of the South African report might have been different if lots of other regulators were also looking at the issue and trying to find solutions. Like our learned friend from the keynote speaker mentioned, the need for regulators to hold hands and work jointly seems completely crucial in terms of trying to regulate these global companies. But very much inspired by the South African Commission, we then, exactly like you've described, started to file complaints in other places. We filed complaints at DG Comp, the European regulator, at the Italian regulator, at the UK regulator, the CMA, and the Brazilian regulator, CADE. And I saw from your agenda that our wonderful Brazilian comrade Vittoria is on the panel next, and she's been a completely crucial lawyer in terms of the CADE investigation with us. With all of those complaints, the legal arguments of course mattered, but actually what I think was completely crucial was the evidence. So we basically commissioned independent evidence about the impact of the generative AI summaries on news outlets in each of those jurisdictions. And there was an organization called Authoritas that we worked with, and they showed that the generative AI summaries and the changes that Google was making to its search services were completely devastating the click-through rate. There was about 50 to 70% decrease in terms of the click-through rate, which obviously leads to an immediate impact on the ability of the news outlets to generate income from advertising, because people are no longer going to their websites, exactly like my fellow panelist described. I'm delighted to say, as our moderator mentioned, both the DG Comp and the CMA, and also the Brazilian regulator CADE, all agreed to open investigations. They recognised there was a serious problem here. There was an abuse of dominance by the company, and they needed to investigate further. The DG Comp investigation is still going, and CADE's investigation is still going. But I'm delighted to say that the UK's competition authority has now in fact come out with a whole series of conduct requirements from Google. And included within those conduct requirements is Google has to let publishers opt out of their content being used to train, fine-tune and ground AI products. And that has to be done on a page-by-page basis. They have to allow that opt-out without punishing publishers in terms of search rankings for opting to use and exercise that opt-out. So that's an incredibly important intervention by the state in the UK. The state in the UK, the CMA, also made clear that these requirements that they've asked for will also apply to the future AI products of Google. And I wanted to mention this in this audience because it feels very important, I think, for us all to think about the agentic AI products that Google has announced it's going to bring in, that will go beyond AI overviews and AI mode. And I was delighted that the CMA said that their conduct requirements would apply to those. And one of the pieces of work we're doing at the moment is to think through how to make sure DG Comp and CADE similarly are thinking about the agentic AI products that Google has announced will come in, which will again completely change search again, and will have even more, we think, of a decrease in terms of click-through. So there absolutely is a requirement for all of those investigations and state regulators to act very quickly, in our view, in relation to the opt-out. One of the things I would say that we have been trying to unsuccessfully obtain in relation to all of these investigations is an interim order. I think, as everyone in this room knows, regulation can be quite slow, and it is clear to us that Google has always taken advantage of the slowness with which regulators act, And so one of the interim requests we've been making to all the regulators is that an interim audit is put in place that allows for the opt-out of generative AI without being kicked out of the Google Index while the investigations happen. As I said, sadly, no regulator has taken this up yet, but we live in hope, and maybe COMESA or other regulators in your region will do that. The other point I really wanted to make, which is again really just to reflect on what our keynote speaker said, is the need for the regulators to think globally and joined up. I have no doubt that Google's lawyers are all talking to one another across borders in all of these jurisdictions. And we've noticed through our work in these different regulatory spaces that there are definitely different arguments and evidence being put in by Google to different regulators. So ensuring that regulators are talking to each other and are thinking in a joined up way in relation to this issue seems completely crucial. And as I said, given that the evidence is so clear about the impact of what we would call an abuse of dominance by Google from a competition perspective, there really is a need to act quickly. And the regulators, we very, very much hope in Brazil and Europe, and indeed the UK will continue to work on the agentic aspects of Google search, and that these steps by the state to intervene will continue and will indeed expand in relation to other regulators globally. Thank you so much for letting me
Well, thank you. Thank you very much, Rosa, for that very, very in-depth highway. I think Rosa deserves a mighty hand clap, ladies and gentlemen. Over to you, Rosa. And Jeremy, Andy, just I intended to have Professor Thomas Hopnut, but there's something burning my end. When Deogracius was winding up his conversation, he alluded to something which I felt can't wait. He said, how does this even happen? How does it work? So this conversation is for a journalist, a policymaker, a regulator, who is here. And now that we have Andy here, who would want to know, when we talk about this curation, when we talk about AI picking up my work on my website, how does it work from the lawman perspective? So Jeremy Ande is the founder of Angitech, and in the next 10 minutes is going to, first of all, for starters, give us a brief about Angitech.
Yes, so I think I will start with 2 questions. Raise your hand if you know what is RAG, meaning like Retrieval Augmented Generation. Okay, another one. Raise your hand if you know what means training cutoff date. Cool. Okay. So it's 2 different things. The RAG, Retrieval Augmented System generation, is in fact when you go to fetch information and that you add it to the reply. So it can be information about your database. It can be like a restaurant menu, and of course it can be a news article. And why is it so important? Because on my side, I must say that I'm on the agentic side, meaning that I happen to scrap website, and like it's not like you have a button or a way to pay. But to go back on the second question, what is cutoff date? Cutoff date is the day where the AI stops learning. So let's say you are training a model, maybe you will finish the training of the model, let's say in April 2025. So if you use this model so if something crazy, like let's say some COVID 2027 happened a few months ago, your LLM will not be able to know it because it hasn't been trained with this data. So that's why it's very important to retrieve recent news and stuff. And here there is 2 distinct things. So the first one is about retrieving data to train the model. So it's really like, it's one use case. And the other one is when you retrieve data on the fly, meaning like you ask your chatbot what is the last news about Parliament or something, and it goes to the Herald Tribune and goes to fetch the information. Because now the fact is that we have to. I mean, we are already in a kind of new world where the user is no more the human. The user is often the agent. So we have this. We all know what is user experience, meaning like you have to have a nice website. It has to be ergonomics and stuff. But now we have to have this agent experience, meaning on one case you want to have the information that is easily accessible by the agent in some case, and in some other case you want to avoid that the agent can like just pick up what it needs on your web page and then reuse it. Because I'm quite you know, like for me, I mean, if you go to a website with news, usually, yes, you might have to pay, you might have to be like under tons of advertising and stuff. So I understand that it can bring some value to like kind of steal this information and just give it to your agent, and then you will use it. But of course, it's not fair. It's not fair because the content creator have been working a lot. And in the case of Google, it's even worse, I would say, because it's like there is a kind of, I would say, moral contract with Google, which has been there since 25 years. It's, I open you my website, you can scrap it, and then you rank me in your search listings, and people go to my website. This has been the deal since the beginning. I mean, like Google is acting as a platform, and people don't stay on Google. Usually, they just go to the website. And now this mental model is completely broken because, yeah, Google is just displaying the information. And like in Europe, especially in France, we have this AI overview since just a few weeks. And of course, I was very shocked the first time that I've tried it, because to be honest, it's completely short breaking. I mean, like you don't need to go to the website anymore. Yeah. And I was really surprised that this move from Google would be like allowed in the EU. But like, to be fair, we must say that a good bunch of people today use AI for the opposite thing. Many people use ChatGPT to do searches. Yeah. So it's kind of like Google has seen, like many people were saying, okay, Google is dead. Nobody's gonna use Google anymore. Yeah. So on that side, you have now when you do a real search, you get rebased to some AI, and when you do some AI search, then you get to, like, I think for a publisher, they get more people coming from ChatGPT than they will get from AI overviews. Yeah. Because on ChatGPT, you will click on the link, and on Google, it's really made for you to not have even to click on the link. But yeah, so basically on a technical point of view, when you do an Google AI overview search, Google will split your main search in small search, just like you're having 20% going one way or another and digging, and then like putting together the results. I think that now probably the publishing and the content creation will need to adapt to this new way of consumption. So, you know, maybe like a kind of pay-per-view, but for agents. I don't know yet how it can exist, because it's complicated, and the fact is that it can only be based on trust, because as long as the information is available, you can have some robot.txt that will prevent Google or like some people from scrapping, but you have to understand that it's just a declaration. Like, I mean, it's just, okay, I see that I cannot scrap this website, that I shall not, so either I don't do it, or either I don't care and I do it. Like, it's like this case also that happened with Anthropic, that for some reason has been buying like tens of thousands of books, and to not be guilty of copying, has decided to destroy the books after scanning them. So, I mean, it's getting a bit nonsense, you know, like we buy books to scan them, then to destroy them. People write articles on websites, but it's not a user that read it, but it's agents that read it. So for me, my take on this one would be that in the next years, there will probably be a kind of way, you know, it kind of reminds me also of music, like of the MP3. At some point, everybody was like downloading illegally, and then at some point we made some like package and stuff. People paid $20 per month, and then they could use it without limit.
The rentals then.
Yeah, exactly.
Yeah.
And and in the meanwhile, you have the rental, or you go on Saturday with your friend at the rental shop.
Yeah.
And like this doesn't exist anymore. But Netflix usually like started to be like you know, where you go to rent your DVD.
For some period, and then
exactly. And basically, I think we are kind of in this transition situation where maybe today publishing is this kind of rental, you know, where like I will buy an article, I will buy newspapers, and I will read it, and I will dump it or somewhere. And I kind of believe that in the next year, the business model will change, and maybe like you will pay 20, 30, depending on your usage, and then you will get like easy access for your agent to website, because still, if a publisher today doesn't want you to scrap, there is some, let's say, like mitigation way to reduce the visibility of your website. But as Rosa said, it's a terrible decision, because you have to decide either to be stolen or to disappear.
Yeah.
So it's not an easy choice, and really I think it's complicated. So what I really hope is like in the next year there will be some way to make this information readily available to agents, but with a price, maybe not a pay-per-view, because it's so complicated, you know, like I don't know what shape it will take, but it's a change of business model, as we've seen with video, as we've seen with music.
Yeah.
And so that's my take on that.
Well, thank you very, very much. And ladies and gentlemen, Andy of Angetech has been taking us through what it looks like from an ordinary perspective. And he speaks big terms, LLM, large language models, and talks about scrapping of websites. And I think, in summary, what Andy is saying says, wait a minute, what's happening is a transformation. It's a transformation journey. Just like not so many years ago, if you wanted to have music, you had your MP3, and then you'd go and buy music and download it there, play it, and stuff like that. So it's a transformation journey. And then in between there, we had rentals. Those of you who in that age, you do either rent a movie. Actually, Netflix had those rentals and shops thereby. So I think for me, you put up a very, very important call. And it's good the legislators are here. And you're wondering how can this happen? Because not long ago, if I went to Google and I'm searching about something like AdLego, yeah, it would simply take me to the website of AdLego.
Yeah.
There was no AI tool. Now today, if I'm searching about AdLego, the AI tool scraps the website and is able to give me the information.
Yeah.
So I no longer need, if what I need is quite brief, I no longer need to go down to AdLego to find out what's in there. And I think you push a very important critical call, and that is, should we allow this to continue? Because then will AdLego's website be useful anymore? If he wants me to pay, would I need to go there when I have a third-party scraping for me? So I think you really put a very key discussion. And over to you, our listeners across Africa and those with us in this conversation. And Professor Somath Hopner, I'm a partner with Gladin Partners. First of all, I want to thank you, Prof, for the great work you're doing in competition law. I have had the opportunity to attend a number of your sessions, some at Oxford with some of your partners. And we want to applaud you for the work you are greatly doing. But before I call you on, Somath, I just want to pick up something from the very, very rich submissions of Rosa. And Rosa points to what the legislator in the UK has done, where we have moved an extra step, and the legislator is saying, wait a minute, can we have an option to opt out? That we are able to balance and we are able to respond to the question of which Andy puts forward. He says, it's a hard choice. You are telling a publisher, you either stay with me and I take your information for free, your original work for free and publish it to my site, or you lose visibility. Because one, I'm a big dominant partner. I hold all these sites. Yeah. So I think we want to thank Rosa and the group for starters for pushing, for some of these changes where we are actually seeing that the regulator is saying, wait, let there be an option that if Theo Gracious does not want you to keep scraping and popping with this information, he can opt out. Yeah, so that there is a balance between sharing the visibility, which is your platform, vis-a-vis my information, which is my original content. Ladies and gentlemen, I would want first of all us to give a hand clap to the great submissions by Jeremy Andy. That was so powerful of you, Jeremy. And I think that takes me to Prof. Prof, you're welcome.
Yes, thank you.
Good, you are loud and clear. Prof, you have been at the forefront of addressing the relationship between big techs and news publishers. We would want you to wind up this conversation today from your perspective. How has it been like before I can be able to pose my question,
What do you mean, what it has been like?
For example, you have been at the forefront of this discussion, and from where we sit and the conversation we are having today, who should pay for the news? I want now to structure the question in such a way that should these AI companies pay publishers for starters?
Okay, if that's your question, I will try to, follow up on what has been said earlier on. So obviously, I think, yes, there's only one answer. There needs to be a compensation mechanism for the reasons you pointed out. Let me maybe go through what we already know about it and where we stand. Obviously, Europe has its own path. We first try to solve this issue with copyright, because historically it was thought that fair compensation can be achieved through copyright. So we saw first proposals for a press publisher's right that leads to a payment or should have led to a payment back in 2010. Then a few years later, we saw a European-wide press publishers' right being enacted through a European copyright directive in 2019. But despite these efforts to solve this compensation, back then it was purely about snippets in search results, snippets in Google News, snippets on social media that already have a value, and somehow it was seen that there was a value gap because the platforms monetized third-party content without then automatically leading the users to the sources of that content. Despite these legislative efforts in Europe, that hasn't led to significant compensations or payments in Europe. So in a way, the European system so far has failed. There's a bit of an exception in France where we've seen some significant payments, but still below what is proportionate. There are several reasons why the system has failed, and earlier on, Australia was already mentioned as an alternative approach that was more successful. One key element was that European copyright legislation was kind of watered down in the last minutes. For instance, it was said that pure hyperlinks or short extracts, very short extracts, shall not fall under the protection. But more importantly, the copyright solution basically wasn't capable of dealing with the imbalances in bargaining powers. And we've just seen that digital platforms were capable to totally avoid this legislation by more or less blackmailing the content providers with what you just described, their biggest threat of visibility. So in basic terms, they were saying, look, you press publisher, if you insist on any payment above 0, I will no longer display you in the search results, or only without a snippet. And if you don't have a snippet, people will not click at your result, and they will click at your rival's results. So they will get all the traffic, you will get nothing. So in effect, you will become invisible. So that threat, either invisible or no compensation for the use of my content, led press publishers to rather choose the evil of no compensation, but at least I'm findable in search results pages, which meant that this basically pressure on them to waive their copyrights worked out wonderfully. Another very similar scheme to that blackmailing, you can even call it, is ultimately the Google News Showcase initiative, which has always also been rolled out in across Africa. There again, it's a scheme where basically Google selects a few on the condition that they don't expect a certain payment elsewhere. And the whole scheme is very sophisticated to basically bring down the market price that would otherwise develop for the use of press content. So in short, the dominance of these large platforms allowed them to circumvent copyright, and copyright itself was not capable of dealing with it because it's a horizontal legislation that shall apply to everyone equally and is not, suitable for this situation of imbalance. So over the years in Europe, we've tried to counter this by taking competition law aside and help enforcement in copyright regimes through competition law. And the main player here was really the French competition authority, which, unlike, for instance, Germany, really took this head on. And they really used the abilities of saying, look, if a platform isn't providing the information required to really negotiate, the platform is threatening with invisibility, if the platform is not negotiating in fair terms, then this can be an abuse of dominance. And they used this lever of competition law to basically increase the bargaining power of press publishers. And to an extent, this worked. So we see more payments or higher payments in France, but it's still kind of imperfect. And France first started with actions against Google, but the most recent action, which I wanted to highlight, because if you are really interested in this topic, I think this is a great decision to start off with. On the 8th of July, so only a couple of days ago, France really issued an important interim measure decision against Meta based on competition law, where they basically summed up the whole issue that we talk about today in 5 points. So the first point is so why it is an abuse of dominance, infringement of competition law, to not really pay press publishers in an adequate manner. First, they highlighted, well, digital platforms, Meta, Google, really profit of the use of press content because that content contributes to the appeal of the platform. Users like that they also find press content on that platform so that they have a kind of one-stop shop service for all their information needs based on trustworthy sources. Second point is, when these platforms do that and use that third-party content, they boost their own advertising revenue because the more users get to their platforms, the more advertising is spent on those platforms. And that in turn then kind of appropriates the third-party content for the platform's own revenue. And this is not just problematic because they make money, but it is problematic because the downside is also that by more consumption on the platform, less people click through and consume the content on the sources' websites, and obviously they then are deprived of traffic. So they are penalized twice. First, their rivals on the advertising sector take their content for free to make their own platforms more attractive for users and then for advertising. And secondly, by doing so, they keep the attention on their own platforms, and those that they took the content from for free don't get any users anymore and can't monetize it to advertise. So the third point then obviously was for the French authority to say this is unfair, it's an unequal distribution of the value created by content providers, and there needs to be some rebalancing. And then the last step was basically say, well, and Meta in particular, but previously Google was the same, you are not helping the press publishers being able to really defend themselves and negotiate the value of their content because you are not even providing any information regarding how valuable is this content for you, how much money do you make with it, how often do you actually use it, basically full intransparency. So there is such a huge intransparency and information asymmetry between the platforms and the content providers that this as such can be seen as an abuse of dominance. So then the authority concluded that by preventing press publishers from properly monetizing their ancillary copyright for press publishers, Google and Meta inevitably exacerbated the financial difficulties of the press sector. So they ultimately use competition law in an effective manner, I believe, to strengthen the bargaining position to make the most of copyright law. Nonetheless, these are good attempts to kind of come over this weakness of copyright law, but I think it's still not ideal because the problem is that neither copyright law nor competition law is really primarily concerned about what is at stake here. And at stake here is media plurality, sustainability, and diversity, and also the independence of media. We don't want systems where just, big platforms cooperate with the biggest media outlets, and if they make an agreement, everything is fine. We want that also small players, local players, that have no chance otherwise to negotiate with these platforms, continue to be visible, continue to exist, continue to be able to finance their outlets. And therefore, what we need is, in addition to competition law backing up of copyright, there needs to be this element of we also need to protect media plurality. So this leads me to then kind of the learnings maybe for Africa, because I think that is something you want to take out of this session. Firstly, I believe South Africa Competition Authority in particular has already done great work. Their preliminary or provisional summaries on the online intermediation platforms inquiry and on the media and digital platforms market inquiries, they were great. Not the final outcomes, but the analysis were really good. And but what are the learnings? I think the learnings would be, if we look at Australia, why is it working there? Well, there we've got a fully fledged legislation that combines the power of competition law with media plurality aspects and copyright law through a distinct legal regime. And this legal regime is so fine-tuned and really takes all the aspects into consideration, avoiding prisoner's dilemma, ensuring sufficient information, avoiding any blackmailing situation and stuff like that, that it works. And I think that is a learning rather than trying to kind of get a bit better copyright, get a bit better competition law, really look at it holistically, what is required, fair compensation, collective bargaining, an open access to the platforms, non-discriminatory dissemination, every publisher having the same opportunity to appear and to be distributed, no penalty for those that insist that they should be paid. And last point, because it was made up earlier or came up early on, of course, this call for a separate opt-out is essential, because in a way it's, it's currently a bundling. You either have to accept that I also take your content for AI overviews or I throw you out of search. It's apparent that this is an abuse of dominance. But I would warn to assume that this solves the issue. I would really warn against it, because an opt-out opportunity still doesn't ensure you any payment, right? There is no compensation automatically following from that. In theory, you may then say, I don't want to appear in AI overviews anymore. But the moment Google, for instance, includes some links in AI overviews and pushes organic results to nowhere to be seen, every focus will be on AI overviews, and all of a sudden, the publishers will realize, well, okay, my only chance left to ever be clicked is somehow be in the links in the AI overview, so I need to be back in there. And all of a sudden, they fall over backwards and all opt in again. And that is a prisoner's dilemma that will not be solved by the pure option to opt out. We need more. We need a mechanism that ensures full compensation for such uses of content by platforms, and that obviously needs to expand not just to AI overviews. There are also, bad actors elsewhere. If you think about a Perplexity or so that steals just as much, and then Google takes that as an example for a threat of disruption. In a way, they are helping each other, justifying bad conduct. We need sophisticated solutions that really make sure there is a working payment scheme in place. In Europe, we've got a new proposal, a legislative proposal that goes into that direction. In March this year, it was adopted a report for copyright in the generative area. I hope this will be fine-tuned, and then we can learn something from that. But apart from that, I think South Africa is on a good path, really analyzing the issues and then making their fine-tuned, sophisticated solutions that cater to the particular situation in the continent.
Thank you very much. Ladies and gentlemen, those are the kind and very, very rich words of none other than Somath, a partner with Geraldine Partners. And I think for me, my take-home from Somath, Prof, is that, wait a minute, do we just look on? And if we do look on as legislators, then what's going to be the fate of the independence of the media houses? Because if a media house has to choose between visibility and between visibility and letting go of the original works without pay, then where is going to be sustainability? Doesn't that patch holes in the independence of some of these independent media houses? But also, I think, Thomas, you rake in a very, very key thing, and that is, won't this be creating the abuse of dominance? Is that if I am, a big tech, I have this platform, and you need me, does it mean that now,
you are using my work to do your advertisement, to access my data, and I get nothing. So I think that is really very, very key. Prof, we still have some minutes, thanks to the great utilization of time of the panelists. And therefore, I will pose in one question, which was not part of the conversation. You have been at the forefront of this conversation. And this being the Big Tech Accountability Summit, the inaugural one in Africa. And I'm looking forward to the AdLego team. I hope we have the second next year. So being the inaugural, and we are blessed with a number of legislators in different areas. I want to pick it from where you stand, because these lessons are very, very important. In your view, in your opinion, based on your experience in these conversations, if you would speak to a room of legislators from Africa, what would be the advice on how this should be approached in terms of regulation from the African perspective, from the African legislator? Over to you. Thank you very much, Prof. Somath.
Thank you. Yes. As I said, I think you should look at it holistically and really find this trade-off between protecting visibility, the open access to the web. We can't afford solutions where the first major gateway is so closed off that no one gets through, and there is a zero-click scenario where then basically no visibility takes place and people are kind of either dependent on apps and subscription models, or else to sell offline. That can't be the solution. We need really that these key gateways to the open web remain an open place that fulfill the function of leading users through to the sources, not blocking them off, not becoming the final destination. And secondly, we need to really think about the compensation that those players that do summarize, rewrite, ground results on the basis of third-party content really pay their fair share for the sources, because ultimately they bear the costs. And if we want to have continuing high-quality content online, somehow these costs must be covered. But to frame a legal solution that caters for these both interests, continued visibility and compensation where their content is used, is something that really requires kind of a holistic, sophisticated view on the mechanisms, how these gatekeepers work, how the streams of user engagement is, but also conversely the stream of the use of content and the advertising following with that. But I can only encourage the authorities to be bold, not believe that we need AI overviews for survival of our society. I think we should rather focus on the survival of democracy through pluralistic media landscape, and really understand that this needs a solution soon, because currently many media companies are basically starving, and it's a damage that at some point is irreversible.
Well, thank you very much, Professor Thomas of Gradient Partners. I think I just want to wind up this conversation with an African proverb which says that he who spices the already nice soup spoils the taste. And surely I will not have anything useful to add to this very rich submissions from you, Professor. And I want to thank you and the panelists. Thank you for joining in. And this session was asking that big question: who pays for news in the age of AI? And you'll agree with me that, you'll agree with me that the panelists have been very, very, very key in their submissions. But before I close out, there's something itching with my panelists here. They are gracious. And a parting shot.
Yeah, so there are a couple of things. One of them is opting out. I find opting out quite tricky. I'll give an example. You see the autosave that is with NSSF, where you can easily move your money from your mobile money to the account. So it somehow happens that that product was brought on by some other company. Because for me, I first saw it with Zeno Technologies. But then you find that it was dealing with a very big company, MTN. And it couldn't afford to protect that because it was like innovation. Because in this business, you're trying to pull so many people to your product and service. So it couldn't convince MTN that we only want this solution for us. So that means if another company comes up with an app, it is going to use the same thing. It is going to be recurring. For a company like MTN, that is a business model because you plug into their API and you're distributing that service to everyone. Now, opting out is very tricky. How? Because I would imagine that no media house has fully locked content behind. Because even if you went to Daily Monitor website today, there are some articles that are free, some are paid for. So if you opt out, because one thing to sell something that the world knows, and it's another to sell something that the world doesn't know. So that means how will the world know that you have this content? So maybe you have to strike a balance and say that maybe the big tech can access the free content, and then you negotiate for the protected content. Now there is the other point is on the transformation that my colleague said, transformation of the business model. Yes, you can argue that there is transformation, but okay, let us try to say right now the biggest companies in the world, they are tech companies, and their biggest resource is data and information. And some of the legacy institutions like we have, like maybe Nation Media and others across the world, they have that resource. And now these guys are personalizing that information. For instance, you can have an Apple Watch that watches how your movements, so they can create products of that information for yourself and also for enterprises. Now, you see, there are so many queries about the bubble, the tech bubble, and we are seeing very high valuations in that space that almost every economist is worrying about. Now, one of the reasons that we're seeing that they are struggling to create a business case for these models. So you find that they're having information, but then, and they are also getting out of financing, but they are finding problems with monetizing the data that they have. Now, this is something that at least they have the resource that they are using. But what if they paid for that resource? I understand that if Google maybe went out and said that we are going to pay for the content that we access behind the paywall, its shareholders will feel bad. Why? Because it is now going to have another expense on its balance sheet. But now, because if there are worries about the tech bubble, and now you're saying that you're going to pay content creators a lot of money in copyright for their content, that means you're going to be incurring a very big expense. That means your profits are going to go down. Now that will confirm to the world that your valuations were so high. So the thing is, like you strike a balance, you maybe access the free content, and then you go into a bargaining war with content creators for the protected one. Because right now what I see is, if you try to say that you want your content out there, for instance, you're doing research on flowers and stuff, for you to convince Google that you want everyone to be seeing your website as the best in that, you have to pay for it. So that means you're going to go into a bidding war for that again, which you can't pull off through. So I think there needs to be a really good research about it, and maybe our regulators have to do something about it. And maybe the last one is on the protection of media rights. Yeah, you can argue that, but you see, there are some countries where you can't. It is very subjective. So you can't say that. There are some countries that don't believe in free speech. That means it will be even very hard for them to push for things like that. So it's really tricky, but if it is given thought and time, you can really pull it through. Yeah.
Wow, thank you very much, my friend Deogratius Wamala. Like I told you, Deogratius Wamala is a man on the boots, is a man on the ground, is an award-winning journalist. And I think it speaks from the practical point of view, and I think it drives the narrative that we are between a hard rock, as for them as journalists, they're between a hard rock and the water-infested crocodile-infested waters. And it calls for a balance from the regulators. They need to be a balance, between the two, because they need, the dominant partner. But they are saying, wait a minute, the dominant partner should also not just make us really. Yeah. So, ladies and gentlemen, I am lucky to have saved some 5 minutes. And I'm going to give each of these panelists 1 minute for a parting shot. And I will start right with you, Andy, Jeremy. Over to you.
Yeah, so I think what you are saying is very interesting. And I was thinking about, the YouTube business model, where right now, and also on X, on Twitter, where people actually get paid based on the view of their article. So I mean, it's for Google, it's just a larger scale. It just maybe needs some adaptation, maybe some. The difference is that Google now index any website, but maybe tomorrow you will be able to, I don't know, enter a creator program like in YouTube, but to appear on Google, and Google may pay some amount depending on the number of time where your article is a source for AI overview, and potentially this will be a good solution. But of course, I'm not a stakeholder in this case, so I will let others think about it. But to have this way, to have Google directly paying the companies and the people that are creating the content that has made Google what it is today. So it's possible.
Wow, thank you very, very much. I don't know if Rosa Culling, are you there? Can you hear us?
Yes, I can hear you well. I was going to end with a quote, given I have 1 minute, which is in terms of trying to think about what we would very much like the regulators to do kind of globally. We've begun to do some work about the climate catastrophe and the way in which big tech is playing a role in that. And there was a really wonderful quote I read recently about what we need from regulators in this space. And they described how rewilding a built environment isn't just sitting back and seeing what tender living things can force their way through the concrete. It's raising to the ground the structures that block out light for everyone not rich enough to live on the top floor. And I think that's what we need the regulators to do here in relation to the big tech companies, whether it's to do with our press and our independent press, or to do with our economies or our public conversations. So I would really just encourage this conference to think as creatively and as proactively as they can about how regulators should be acting in this space. It seems to me like there is much, much more work for the public and us all to do to encourage regulators to do much more in this space.
Thank you very, very much. And this brings us to the end of our conversation. Ladies and gentlemen, it's exactly 5. And for listeners listening to us all over the globe, thank you very much. And for those who have been here with us, my name is Tony Kire Galande. I work with Diamond Advocates. And I want to thank you for contributing. And to the panelists, thank you for the time and this very, very immense knowledge. Thank you, and may you enjoy the after session, which is coming next. Thank you very much. Let's just give this way my hand clap. Oh, we have a picture.
Is it still a good afternoon? Good afternoon. I think I have both good and bad news, but since you're all tired, I'll begin with the good news. We have a cocktail moment. Cocktails we are giving you time to take something while interacting with people, building connections. So please don't go. After the award ceremony, we are going to have a cocktail. It's down there. They're actually preparing it. Isn't that good news? It's a Friday. So the cocktail and the awards are a courtesy of the African Center for Law and Public Interest Technology. We thank them for supporting us, for giving us that offer of the cocktails. So we are going to our last panel session. This one is short, don't worry. It's going to take a short time. Allow me introduce to you the next panel. It's going to address one simple question. How can civil societies and public interest litigation drive big tech competition accountability in Africa? You have to understand that for us to hold big tech accountable, we need a lot of civil societies and public interest litigation cases. A case in point is AdLegal. AdLegal has been doing a lot of this advocacy work. So we recognize the importance of having these people on board. We recognize the importance of having other civil societies joining us to support us in our work. So allow me invite the moderator for this panel, Miss Joy Amanda, the Secretary General, Internet Society Uganda Chapter. Is she around? Yes. Please clap for her. She's going to moderate a very hard session, because I imagine moderating a session when you're thinking about cocktails. But hang in there. Yes, hang in there as we do our last session. You're most welcome, Joy. Okay, thank you. Thank you so much.
Okay. Well, I have been told that I just have to make this 30 minutes. So pray for me as I deliberate for just 30 minutes. But I know you are tired. It has been a long day, but let's get into it. My name is Joy Amanda. And the session that we are going to go into is how we can address the role of civil society and how we play a pivotal role in this accountability space. Around the world, we have seen that digital markets have shaped the way we work as ordinary people. It has rather grown at a faster speed. From Washington to Beijing, the major powers have been facing and setting rules on how we work in this tech space. One would mention that there is a lot of engagement happening on tech platforms that is run by the big techs like Google, Meta, and Apple. This competition is just not high level anymore. It is happening even elsewhere where we are. What would I say today is that this conversation cannot be only managed by the civil society or only government. We can't leave the government in this conversation. That's where today we're going to talk about how the civil society can enter this conversation. Today we are going to look at how ordinary people and public interest groups, researchers and lawyers, and just academia can demand for big tech accountability. And how do we request the big tech firms and corporations to play fair in Africa? With me today, I have amazing speakers from the academia, lawyers, and the civil society. I would like to call to the panel Dr. Preeti Tega Edema, who is a competitive law expert. Dr. Preeti, I don't know if we would have our online system. Dr. Edema, if you can hear me, I'm looking at your jurisdiction. What are some of the instances where the civil society, consumer groups and public interest advocacy can trigger investigations and influence enforcement on these big tech companies? What are some of the lessons and experiences you can offer us today in this room right now to strengthen this competition accountability? How can a lay person demand for accountability from the big tech? Dr. Preeti, you can introduce yourself and just dive right into it. You're muted.
I didn't hear you mentioning my name.
Sorry. Sorry, Dr. Preeti Tega Edema. Please, I hope you had the question that I asked. Is this clear? Can you hear us?
I'm saying I'm not Edema, I'm Dr. Kigwiru.
Oh, okay. So is Dr. Preeti online? Oh, okay, then maybe I will just dive into your session, Dr. Vela. Well, as we wait for Dr. Preeti, I will just direct this question to Dr. Vela. Dr. Vela, as a PhD research fellow, there's been competition in the big tech space, which has been increasingly dominated by the superpowers. And in this case, I'm talking about Europe, the USA, and China, that have totally taken space of this digital space. And that has really affected our geopolitical dynamics. It's against this that I want to know, and the people in this room would love to know, how can African civil society ensure that the needs of Africans, like affordable access, local innovation, digital inclusion, and regional integration, cannot be sidelined or will not be sidelined by the foreign agenda? What are some of the strategies that civil society can use to hold big tech accountable?
Okay, thank you so much for that question, and thank you so much Adlegal for inviting me to this session. Adlegal is really doing an amazing work, and I was very excited when they shared the information that they're going to organize this summit. So, first of all, we need to get things right. And getting things right starts from understanding key definitions, key concepts, key priorities that Africa is pushing for. So one will wonder, what do we mean by geopolitics? Is it just a word or a phrase that is just going around? What exactly is geopolitics? So geopolitics occurs when national states use, especially in the technology era, they use technology not as a neutral infrastructure that is supposed to enhance efficiency or consumer welfare, but they use it as a strategic tool to influence their foreign policy. So for instance, the United States of America using its tech companies to be able to influence global developments, or another state using its regulations to be able to influence technology regulation or technology governance. And you understand that technology governance is not just about regulation. It's about the infrastructure, access to semiconductors, the cloud infrastructure, data centers, energy, water, everything that is used to be able to develop technology. So it's not just about regulation. So having regulation is one step, but also being able to develop our own African infrastructure is also another step. So before I answer the question on how the civil society can support African governments and competition agencies in the regulation of technology and accountability of the big tech, we have to understand that Africa, just as colonialism, when countries or the Berlin Conference, when countries were trying to battle and have a share of the African continent, this is exactly what is also happening in the technology regulation. Africa has become a hotbed of contestation with big powers, the United States, the European Union, China, and other regions trying as much as they can to capitalize on the African market and African data. That because of the data protection laws that we have that are not effectively implemented, these tech companies are able to access data without so much limitation. So for these three powers, they have very competing regulatory approaches. The European Union is pushing for stricter accountability through the Digital Markets Act, the AI Act, the Digital Services Act, Data Act, now the CHIPS Act, and all the regulations that are coming from Europe. On the other hand, the US is pushing for deregulation and arguing that competition law is sufficient to regulate competition in digital markets. China, on the other side, because of its state-centric kind of governance, is also pushing for digital sovereignty and access to data in order to be able to also support its own tech companies. And therefore, Africa becomes a place whereby, as the former speakers, especially Dr. Simeon Kofi and our own Mr. Babatunde Irukera have indicated, we are not supposed to copy or replicate laws, but we are supposed to adapt these laws. And why is it that geopolitics has become very important for Africa? If you are following the developments of technology regulation keenly, you will understand that the implications are diverse and are also adverse. In the sense that, for example, South Korea had adopted a legislation to regulate competition in digital markets. But because of the pushback from the United States, from business coalitions such as the American Chamber of Commerce, from their own big tech, their tech companies, because we also have domestic tech companies that are also big within the domestic markets, like what the South African Competition Commission showed us in regards to take a lot in e-commerce in South Africa. They really pushed against Korea adopting this ex-ante regulation. So another thing we need to note that when Professor Bradford was talking about the Brussels effects, one of the conditions she talked about is that, EU is able to externalize its regulations and other countries are able to adopt regulations from the EU as global standards because the EU has the market, and also because of the invisibility of regulation or standards that businesses or MNEs are able to lobby other countries to adopt regulations that look like the EU so that they can reduce on compliance cost. That is not what is happening now in technology regulation. Most of the technology companies are lobbying against EU standards or other strict standards being adopted. So with all these dynamics, then we require various and several actors to come together and drive change, depending on their capabilities and the resources they have. So the civil society becomes one of the independent watchdogs. Governments may be afraid to adopt specific regulations because they would want to maintain relationship with specific actors. And because of that, you might find that some government officials might take a step not to adopt strict regulation that may make the other party mad. For instance, when you look at Brazil, and I think Victoria will look at it, they adopted their first regulation to regulate digital markets in 2022 that was pushed by Parliament. And then it was argued that it was really replicating the EU DMA. And then in 2025, their competition agency, CADE, also supported the adoption of another legislation. And even despite the kind of amendments that have been removed from the 2022 legislation to the 2025, the US is still making a lot of pushback. And on 23rd July, they wrote a letter to the government of Brazil that if you go on with a regulation that looks like the DMA or is pushing for this kind of transparency, then you'll have consequences. And we also have heard from the US when the EU Commission made a decision whereby it has fined Google almost $1 billion US. The US has clearly indicated that there will be consequences. So where does Africa come in? The other speakers have already noted the issue of Africa having a weaker bargaining power. And I tend to agree with Mr. Irukera. Africa does not have a weak bargaining power because Africa has the data. And the last panel that has just talked about generative AI, overviews, advertising, and so on, Africa has the data that is not regulated. Cross-border data flows is going on. And if you've been following the World Trade Organization e-commerce moratorium that just lapsed in May because African countries, Brazil and India, argued against having such kind of an instrument which prevents the WTO members from imposing custom duties on e-commerce transmission. So African countries have a different narrative. They have a different priorities, and this is now where, because of the independence that the civil society can push in regard to technology regulation. So that's the first one. They have to set the agenda, set the narrative, push for that narrative from African centrism. And second is the issue of research, evidence-based research. I know civil societies now have a problem with funding. We all know what really happened with the issue of funding for non-governmental organizations. But even irrespective of that, if civil societies can undertake the specific market studies in African digital market regulation, that would really be important for our competition agencies that might be limited when it comes to resources. Third, civil society can lobby under legislative processes that that the region is doing. For instance, the recently discussion at the Kenyan Parliament on the amendments of the Kenyan Competition Act. This is some of the avenues that the civil society can use through submissions of the memorandum to be able to influence some of this legislation. So in addition to research, and in addition to pushing for African narrative, civil society can undertake research that focuses on specific harms in African digital markets. As we have seen, one of the biggest African problem in digital markets is inclusivity and participation of SMEs that are economically dependent on these platforms without any specific alternatives. And also other issues that we've seen, if you've read, and one problem we have in Africa is that we rarely read some of these inquiries that are coming from our own competition agencies. So when you go through all the digital market competition inquiries that South Africa has produced, you realize that the way African businesses are treated is not the same way EU businesses are treated because of the different kind of power dynamics. And that is why I keep on saying, as Mr. Irukera has said, or Kofi has said, we cannot copy rules that are in other regions without adapting them to the specific problems that the region is facing. For instance, as Nigeria Federal Competition Commission showed in their investigation against Meta, whereby although the European users were given a right to withdraw of consent, the Nigerian users were not given the same right to withdraw of consent. Because of this kind of anti-competitive conduct, it means that the civil society should be able to identify the harm, the specific harm that African businesses are facing. And I'm very happy when I was listening from the guy who was talking about him as one of the news producers and the kind of challenges that they're facing. That is the kind of conversation we need to have. So for instance, it's shown that in Africa, there's a lot of discriminatory treatment against SMEs, against African businesses, against African users. Price parity is happening on these platforms. There's lack of interoperability. There's algorithmic biasness just because this information of the actors that are participating in this market. So I know I don't want to talk a lot because this is my topic, but the last one I will talk about is there should be the watchdog for accountability, advocacy, and finally, we have our own FCFTA competition agency. Because of the power dynamic, the FCFTA competition authority will be established to be the voice for African continent. So there's a need to ensure that when we are regulating competition in digital markets at the national level, regional level, and the continental level, there's some sort of alignment that civil society can push for. Thank you so much.
Thank you so much, Dr. Vela, for that. My key take really is if we are to adopt the measures as Africa, we need to look at customizing them for ourselves, not to impose or just adopt as is, but what works with us in our framework as Africans and what works within, like develop new policies, just not copy and paste, but as civil society look into deep research on how we can work around the policies that we develop, but for the African person. Thank you so much, Doctor. My next speaker is Victoria Oliveira, who is a senior consultant. Victoria, if you can hear me, just to confirm that you can hear me. Okay, I guess, all right. Yeah, so Victoria, tell us, Brazil has seen a strong civil society engagement in shaping our digital platforms and regulations globally. What are some of the lessons that Africans and the viewers who are here in their originality, in their own different capacities, can use to learn from the Brazil experience in influencing competition against the big tech and regulation and policy?
Thank you so much. First, let me take one step back to introduce myself. My background is as a competition lawyer and academic, but I've been working for some time now with civil society, bringing my competition expertise into that space. I'm here representing Article 19, who is an organization that is dedicated to protecting freedom of expression, press freedom, and freedom of thought. It was founded in London in 1987, and it has since expanded across the globe, including Brazil, the jurisdiction I work with, as well as 2 African offices in Eastern and Western Africa. Also, on a personal note and for full disclosure, I've been also working with other organizations such as Foxglove, so well represented in the earlier panel by Rosa Curling, Digital Action, Sleeping Giants Brazil, and the Institute for Consumers Defense. So back to the question, I think the first caveat that I want to highlight is that I can only speak about the Brazilian experience, and I think we can definitely share our lessons learned and share what we have done here, but I think that there's already important stuff going on in Africa by the African civil society, and I would love to hear more on that as well. So this is just me sharing what we have done in Brazil. And I don't think there's a straightforward answer, since this depends on so many aspects aligning together to work, but I try to walk through some of the building blocks that have helped us create this dynamic in Brazil. And I think the first aspect worth highlighting is that Brazil has a strong foundation to build on, because Brazil is a young democracy. We went through a dictatorship that was only dismantled through extensive civil society engagement, from progressive religious groups to labor unions to housewives fighting for the cost of living. when we draft our constitution to restore democracy in the late 80s, it was within this landscape of social movements, and many safeguards and rights were established to guarantee civil society had a voice in protecting democracy, such as public interest litigation mechanisms with no adverse costs. Sorry, apologies. So where was I? So we have public interest litigation mechanisms with no adverse costs, and we have broad obligations for regulatory agencies to include social participation in their decision making. So Brazilian civil society is very well used to pushing institutions to stay open to the public. And within digital rights civil society, specifically, we saw important mobilizations since the beginning of this movement, such as the drafting and support of a Brazilian Digital Bill of Rights, which involved intense civil society engagement at every step of the process. And the second aspect I believe has been crucial to this involvement is that the Brazilian Competition Authority is very transparent. All case records are public and easy to access. Judgment sessions are live streamed on YouTube, and any citizen or entity has the right to request meetings with the competition authorities. This makes it much easier for civil society to be present in those spaces, but that doesn't mean that regulators are automatically open to receiving civil society. Mostly it takes political will from regulators to break the cycle of competition law that competition law is used to, where they interact only with businesses, associations, and their councils. Competition law, in my opinion, carries so much jargon, both in economics and law, that even lawyers and economists from other fields can struggle to keep pace, let alone civil society organizations with human rights backgrounds. Regulators need to recognize this gap, treat it as a problem, and meet civil society halfway. Happily, fortunately, in Brazil, we've had a few public servants who've had made that effort and created important opportunities as a result. We can't say this is the status quo at the Brazilian Competition Authority, but I believe civil society is willing to keep pushing those boundaries so that affected communities, users, and small businesses have a continuous channel for dialogue with the Competition Authority. And the final aspect I want to highlight is how courageous and bold I believe civil society organizations in Brazil have been in taking up space in this very closed antitrust community. And it's not just courage, it's very visible to me how the civil society organizations have grown their capacity to speak the language of competition law, and how much more empowered they now feel to occupy that space. This takes a lot of internal and external capacity building, resources, and a very close collaboration within civil society ecosystem. Article 19, that is a freedom of expression focused organization, has come to understand that we need to go beyond digital regulation that is only focused on content moderation. We need to challenge the business models instead, and competition law seems like the right tool for it. So much interesting work has come out of this effort, both from our London office, which has published a very interesting policy document called Taming the Big Tech, which proposes structural separation between hosting and curation of content, and from our regional offices as well. To close, I just want to highlight two major things happening right now in Brazil that Article 19 and other civil society organizations have been very active on. The first one you already heard on our previous panel, and that is the Google News case that has been investigated by the Competition Authority and since 2019, and it was initially focused on snippets, but happily, as the market has changed so much, we were able to show to the Competition Authority that the investigation needed to be expanded. So now it is currently a formal proceeding, administrative proceeding, and we just have received the Google defense on this case, so we should see further developments on this very soon. And just one thing that was extremely important in the Google News case is that the one specific commissioner first appealed to previous decision from the investigative body to guarantee the expansion on this. Just a second. So it guaranteed that the investigation would go to the tribunal, and a second commissioner asked for a broader review and a broader market test, and it issued letters for news associations. And something that was very innovative was this. It was a public letter asking for any organization that feels they have a say on this to present their contributions, and we had more than 10 organizations, national, international, interacting with the competition law authority on this, and this for sure helped the competition authority to be bolder on this. And the second thing that is happening right now in Brazil is that we are aiming to establish an ex-ante regulation regime that is tailored to our reality. So although we take inspiration, of course, from previous initiatives of ex-ante regulation of digital markets, I believe we have been very careful to do things in the way that would work for the Brazilian society. And it's very innovative as well because it encompasses so many civil society, so many instruments for public participation. And civil society has been such an important voice in guaranteeing that we will have watchdogs for any kind of proceeding that is undertaken in case this proposal passes. And I just want to close here saying that there's so much to learn from Africa as well. So the South African Media and Digital Platforms Market Inquirer and the mobilization of civil society organizations and publishers around it have been a big inspiration for me, especially after traveling there and learning firsthand from human rights defenders how they engaged in that fight. And I want also to salute and to say that I have been very happy to be a part of the discussions in this initiative led by AdLegal for big tech accountability in Africa. And I'm also very curious to learn more and to collaborate further with African organizations. And I believe this is the essential battle ahead, and the way forward for tech sovereignty in the global south is to join forces and combine efforts. So even though we can see that there are some political forces that have more strength to negotiate with big techs or to establish the terms of the relationship with big tech, I believe that we have huge markets in Latin America, in Africa, and in Asia. And if we combine those forces, we can also have a say on how digital platform regulation and competition can happen. So thank you so much.
Thank you so much, Victoria, for that. I think my understanding is what I heard most in your discussion was collaboration. And I feel like for the people in this room who are in the civil society space, collaboration is one of the things that will help us win if we have to demand for accountability. And the other that I felt very strongly engaged in is that we need to build with courage and boldness, which is a hard ask for us, but I know that we can think through on ways on how to do that. Okay. Our time is fast spent, and I will be bringing this to a close. So looking ahead, this is for both Dr. Vela and Victoria. Looking ahead, how do you think that civil society and public interest litigation can move from just raising awareness to becoming consistent in demanding for accountability from big tech corporations across the African globe? Just need 2 minutes. You give us your parting shots, then we will be closing this. Olivia, you want to go first?
Of course. I think that the way ahead on this is to guarantee that there are more mechanisms for civil society participation. This could be included in competition law frameworks or with direct efforts by competition authorities, because, and this is not only because we want to defend human rights or for specific interests in the human rights language. I think this is important because civil society organizations as independent actors, they can even bring complaints and speak for small businesses, medium businesses that are not able to publicly manifest their discontent with with big tech companies. So I think that if we make sure that civil society has the channels, has the feels that they're empowered to that conversation, and that they will be taken seriously, I think that's a great way to guarantee that the competition enforcement will be aligned with our best interests and not be only dominated by corporate interests. Thank you so much.
Thank you. Not to be dominated by corporate interests. Thank you. Doctor?
Yeah, from my side, I think one of the best way to push for accountability from the big tech companies outside Africa or the big domestic tech companies within our own boundaries is for civil society to follow on global developments and the enforcement decisions that are emanating from the other regions, especially from Europe, US, and Latin America, and to ask for accountability and the same treatment that these big tech companies are also doing in other regions. For example, if there's an enforcement decision from Europe, we've seen in the case of interoperability or anti-steering provisions or refusal to deal, all these kind of anti-competitive conduct that are rising from other regions that are facing the same big tech companies that are operating in Africa, when they are complying with those decisions from the other regions, they should also be able to comply and apply the same compliance within this region. And then lastly, we need a lot of training and capacity building. Diamond Advocates have started doing this, and we had a very good session on fintech and competition law. Everything that is coming that relates to regulation of competition in digital markets is extremely complex, and it's evolving, and we need to train our people on these issues, especially on how to interpret the legal concepts and the kind of defenses that also come from the tech companies and how to maneuver all this. So finally, we've seen cases whereby a big tech company engages in uncompetitive conduct
and then they engage in settlements with African regulatory agencies, I think that they will never do it on the other side. So this is the kind of accountability and transparency that we are talking about when it comes to enforcement of decisions across the globe when the same tech companies are involved. And the civil society can really push for this kind of discussion. Thank you.
Thank you. I think you have had it. Thank you so much, Dr. Vela and Olivier. A clap for them, please. I know we are at the end and you might be lost of energy, but just help us clap for them. So big tech companies are powerful, yes, and they shouldn't be allowed to be on the playground without any accountability. And my call for you, if you're in this room and online, is that you will collaborate, stay alert, and demand for fair rules once they are pushed. Thank you so much. I remained yours, Joy Amanda, the Secretary General of the Internet Society, which is a member-based organization here in Uganda. We advocate for a fair, accessible, and affordable internet, which is very safe. So you can deliberate with us online and you will meet me around during the cocktail hour. Thank you so much.
Finally, I see people are 2 days. We thank you so much for your time, for being here. Those who are online, thank you for logging in. Thank you for supporting us. This is the first of its kind, and getting such massive support from you means a lot to us. Thank you for being here, for staying through it all. So we have an award ceremony, as I said earlier. Then from that ceremony, we are going to have the cocktail hour. Allow me thank before the awards come in, allow me thank one of the most important groups of people in the room. Those are the gentlemen in the sound system. Thank you so much for what you do. We appreciate your work. They had to put in long hours for us to have such a beautiful event. I always appreciate them because I know how much it takes to be there. Thank you so much. We appreciate your great work. During cocktail hour, please ensure when you meet any of those gentlemen, thank them. They have been very, very pivotal for the success of this function. I would like to thank the ladies behind, the staff. There is Winfred and your colleagues. Thank you so much. We appreciate you. Every time you people went for lunch, they stayed behind to take care of our things. Winnie and your friends, thank you so much. Thank you for taking care of us these 2 days. We appreciate you. Thank you so much. I also want to thank the organizers for this event. They put in a lot of time, a lot of effort, a lot of brain power, a lot of physical power to make sure that this event is a success. Allow me, I think we should give him a standing ovation, but he will not allow. Please clap for Luke, a director at AdLegal. Thank you so much, Luke, for the effort, for taking care of us. He was done making sure that everything is in its place, everyone is comfortable. Thank you so much, Luke. I don't know where Nick has gone. I think he's also not around. Even our director has left briefly. But I want to thank them because many times when you have an event, there are people who you take for granted. But imagine if you had come back and your things were lost. It would spoil your day. So that's why I thank those ladies, these gentlemen. Imagine I'm speaking and you can't hear me, or the systems have a problem. So we need to thank people who make the events happen in the background. Thank you so much, these gentlemen and the ladies and the organizers. So I'm waiting for Luke to come so that we can officially begin the award ceremony. Then from the award ceremony, we are going to open the European chapter. You will understand what that is. in case you want to do research work for them, in case you want to support them. Jeremy is the president, so he can help us. After that, we shall have cocktails. Winfred and her friend and her team, they will help us. They will show you where you're supposed to go. It's down there by the pool. So during that cocktail hour, you can please talk to each other, find out more about each other, what you do, how you can support each other. Okay? Please don't leave when you don't know around 10 new people, because you never know who will help you with what and how. Yes. I'm speaking so that the person comes. I don't want to bore you. Or they play some music and do we have dancers? So you people only did law and policy work and take gurus. None of you is a dancer. Today is Friday. The event is done. Just we're waiting for that. Or I ask Council to show us how the English dance. Brand new from Oxford. Please, ladies and gentlemen, I want you to recognize Mr. Garandi. You have to recognize Senior Counsel, Managing Partner, fresh from Oxford. May I watch Oxford in movies? The oldest, isn't it the oldest university, Council? You see? Welcome back from Oxford. How was the weather, sir? Very well. He's an expert in competition law, newly from Oxford University. Then we also have Mr. Watasa. Oh, the person I was waiting for has come. Allow me introduce a very important person, our executive director, the vision bearer of Ad Legal International, Mr. Chitakazis, to give us the closing remarks. You people have not clapped. I've told you vision bearer.
Thank you so much, Patience. I'm going to be brief in my remarks and strategic in one way or another. Well, the members online, let me start with you. We thank you so much for registering for the summit. We received a total number of 763 registrations of members attending across the continent, and together with those who have been available, who have been present at the summit. And we thank you all for honoring this summit and for believing in the mandate that we are trying to push forward in regards to big tech accountability. I won't delve much into the things that have been said, but all I want to say is to thank you all for coming for the summit. And let me take this opportunity to thank the wings behind this summit, and I'm going to call them by name so that they can come for recognition. Let me start with the chairperson of the organizing committee, Mr. Kamoga Luke, to come for recognition. This has been the man behind the organization of the summit. And let me also call upon Mr. Murere Nicholas. I don't know if he's present. Patience ISCJ. She has been the MC for the day, but she also plays a major role in our advocacy litigation together with Mr. Kamoga. So for most of the legal battles that we've had so far with the big tech, these two have been the members behind the drafting of pleadings, the litigation strategies, as well as organizing the different things which have led us to most of the successes which successes informed this summit and convening that we've been having for the past 2 days. Let me let Mr. Kamoga speak for the first time ever since the summit was opened. Come and say a little words to the audience. Thank you so much.
Thank you so much, Mr. Chitaka. Our distinguished guests in your respective capacities, I take this moment to welcome you. I know it's at the close, but it's a moment I've got to welcome you all to this 2 days event. I know it's been a little exhausting, but yes, we had to do it. It's the first of its kind. It's a first ever organized Africa Big Tech Accountability Summit. And from our panelists and our speakers from the different areas of the world, you've heard that what is critical at this moment is accountability and a forward-looking approach to adoption of internet and social media platforms. Accountability is key. Otherwise, if we expose ourselves to exploitation by big tech companies, we are doomed. As the keynote speaker said, Mr. Babatunde, that we are not pushing for openness just. We want a market that is not exploitative, not one that is a way said, we don't only need exploration, okay? But we also need to reduce the danger of exploitation. When we do some of this litigation or some of this advocacy, some entities see it as attacking them. And you heard from Dr. Babalola that when some of these big companies, big tech companies hear that he's going to speak somewhere, some of them decline to fund some of these events because they perceive our actions as fights against their operations. This is not the case. Our actions and our advocacy agenda is aimed at creating free and competitive digital markets. Markets that are fair to everyone. You've heard that when it comes to AI-generated news on the Google platform, the people in there, the people in the news sector, and the people who create original content don't have the solutions. That means they must lean to a side end for solutions. And who are those? The civil society advocates. That's AdLegal, that's Article 19, that's everyone. I was talking to someone and they said we could not have done this summit alone. Most of our speakers have been online, but that support alone cannot go unrecognized. So at this very moment, I want to thank our partners, our sponsors, and our general participants. We cannot, and you forgive me, I know we are bad by time, but allow me mention some of them. These partners have not only helped us financially, but they have also looked at their logistical and the technical support. You've heard about the different speakers. AdLegal, we're not a big team, so we couldn't have afforded providing all the insights that have been shared since yesterday. That means we could only afford this by collaborating and partnering with other stakeholders. We want to thank very much DM Events. Without you guys, our events are cannot normally go on as we wish them to. We want to thank very much the Ministry of Justice and Constitutional Affairs. Yesterday, our opening address was delivered by the Deputy Solicitor General. And when we reached out to the Office of the Attorney General, we were unfortunate that Honorable Chiriowa Chiwanuka left the ministry before the event, but he delegated, and we had a representative from there. We want to thank the Ministry of ICT, and you saw the Data Protection Office, together with the representatives from NITA, around yesterday and even today. We want to thank very much our partners in the practice, Kumutima and Company Advocates, who has contributed greatly to this event. We want to thank Kentaro and Company Advocates. Those have been also big sponsors. We want to thank Sierra Manya Advocates and Solicitors. Those have already supported our events. We want to thank Diamond Advocates. These ones have also financed and sponsored the award ceremony. We want to thank PM Digital Hub, ENS Africa, you saw the moderator and the support. We want to thank AF Mpanga Advocates. We want to thank MTN Uganda. These we didn't have a representative physically, but they have been online, and they provided support in other avenues. We want to thank very much Cavern Bridge Advocates. These have been available right from the start, providing insights, technical support, and we can't thank you enough. Thank you so much, Cavern Bridge Advocates. We want to thank our international partners, the Digitalize Hub, based in Ghana. Thank you so much. I know you're online. We've been in engagements and coordinations, and they have really helped us so much. We want to thank Diplan. Diplan was honorably represented by Dr. Babalola and Amara, who has been one of the speakers in the last panels. Thank you so much, Diplan. When we initiated the idea of the Big Tech Accountability Summit, and we reached out to Diplan, Diplan said, this is what we've been waiting for. Let us push it together. And it was the first memorandum of understanding we signed when we got the idea. So thank you so much, Dr. Babalola, and thank you so much for making it all the way from wherever you were to Uganda. We want to thank Foxgrove. Foxgrove has been represented by Rosa. Foxgrove has also supported us in various ways. We want to thank Article 19. Victoria was there. We want to thank the Federation of Data Protection and Privacy Practitioners Uganda, Chirunda and Company Advocates. We also want to thank Safe Border. For some of you who didn't know, Safe Border provided a discount of 40% to all the trips that were coming to the summit. So if you ordered for a ride or a safe car drive, and you were coming to the Big Tech Accountability Summit, you had to get a 40% discount. So if you didn't, please, you can ask for a refund. We want to thank ALP East Africa. They have supported us in various ways. Kagwa and Kagwa Advocates. We want to... Yes. Last but not least, we want to thank these following members and entities. We want to thank very much the leadership of the Uganda Consumer Protection Association, that is led by Senior Sam Watasa Kurowa. We cannot thank enough Senior Watasa. We've had long nights discussing concepts that have led to the success of this summit. So thank you so much, Mr. Watasa, and the Uganda Consumer Protection Association for the support, both technical and logistical. We want to thank in a special way Dr. Vera Kedogo. He was one of the last panelists. Dr. Vera has made sure that each and every connection we wanted outside Africa was secured. Thank you so much. Thank you so much, Dr. Vera. We want to thank our speakers from Geraldine Partners. This is a French-based law firm. And as busy as they are, they had to create time for the African conversation. Whereas they have done well at the European continent, they also wanted to provide their insights to the African conversation and how Africa can also go forward. Because as we've all heard, we can no longer afford to sit back and wait for consequences and then provide solutions after we've had challenges. We need to adopt a forward-looking approach to the digital challenges that Africa is facing. We want to thank our moderators, the moderators who have moderated all the panels. When we reached out, your acceptance was fuel to drive us forward. Our speakers who have spared time since yesterday, I know there have been so many panels, but none of them has complained about time. None of them has complained about non-availability. And we didn't get any challenges in securing any of them. So we want to thank you so much. Then, whereas I've been recognized as the organizing chair and the person as the organizing chair and the fuel behind the success of this summit, I want to thank my members of AdLegal who have been part of this journey. We started driving this from January. So we've been at the course for 7 months doing this and that. So thank you so much, the team led by our ED, Mr. Chitakazis, for this resilience and commitment to ensure that this is brought home successfully. And the work we do, you may think that AdLegal is loaded. One time, Victoria made a joke with us that we needed not to make deal breakers, but the work we do is more of advocacy work. So you need to be as resilient and patient as you can. So thank you so much, the team. Thank you so much, all our participants, for your time, your patience, and your support. We couldn't have done it alone. Thank you so much. As introduced, I remain Luke Kamoga, Director, Legal Compliance and Regulatory Compliance and Litigation at Legal International. Thank you so much.
Thank you, Luke. If maybe, did you mention DPO East Africa? Yes, in a special way, let me thank the members from DPO East Africa. They can stand up for recognition. This is a young team like us who are making impact in the field of data privacy. Thank you so much, dear members. Now, to close it off, let me also thank the Data Protection Office of Uganda. I can see a representative is here, Mr. Gilbert Setuma. Thank you so much for the engagements and the different kinds of coordination that we've had with your office. Now, let me end with a special kind of honor to the man who traveled all the way from France to come for this summit, and he also happens to be the chairperson of the European chapter for the Africa Digital Competition Forum, Mr. Jeremy Andre. Now, Mr. Jeremy Andre, like he was introduced earlier on, please come. He has been at the forefront of fighting for digital competition related matters, and he has gathered a huge number of different digital platforms across the European continent who are all in one pool called the Africa Digital Competition Forum, which he leads. Now, we were also so much privileged that we were selected as the custodians for this forum, whereby we shall be supporting the forum and the different digital kinds of platforms. And we hope to have a huge number of them, even the big tech themselves, to come and be members. I'm not going to say much about it, but this is the last section of the program. Let me let him come talk about the forum itself, and he officially launches it. Thank you so much.
And thank you so much, Kitaka, Patience, and Luc for their hospitality and their kindness. Voilà. I've been really taken care of, and thank you so much. Ladies and gentlemen, since this morning we've heard many insightful talks, but I believe a few points have resonated with all of us. First, the urgent need for a broader interjurisdictional communication. We face global big tech, we need a global understanding of competition law. Second, a tremendous opportunity. African companies accessing European users, and European companies reaching African users. But bottlenecks remain, not just legislatives, but practical business challenges. How does a European company set up mobile payments in Africa? How does an African firm open a bank account in Europe and reach a new market? How do you get legal support, business development, and truly grow? To tackle these issues, I am proud to introduce the African Digital Competition Forum, the ADCF, an initiative of AdLegal. An applause for them. So why now? Why now? Two reasons converge. Big tech extract value through tying, gatekeeping, banning, and overpricing competitors. And also, we are at a historical turning point. Partnerships that lasted 50, 100 years, like Europe and the USA, are no longer the sole leaders. It is time to define new partnership. So why now and why here? Why here in Uganda? Uganda has such a strong legislative framework, a vibrant communities of lawyers and regulators that are mostly here, and a deep sense of fairness. So what will this ADCF forum bring you? Regulatory support, business partnership, advice on market integration. We will help you turn potential into real strength. I am deeply honored to serve as a chairman, and my role will be twofold: guiding European startups into African markets and helping African startups navigate European markets. Thank you, and enjoy the aperitif.
Finally, we are going to do the awards. We are going to give out some awards to people who have been influential on the continent in the fight against anti-competition law practices, who have caused considerable change and impact, especially since, as you've already heard from majority of the speakers, this is a very tricky, it's not a new area because it has existed, but for Africa, we are grappling with so many issues that are arising. So we want to recognize the efforts of those who have put in work, who have tried to create considerable impact, even amidst so many challenges that come with public interest law or advocacy or being part of a civil society. So as they bring the awards, the people in the IT team play music. I want to say people, we have talented people here. You all can't be talentless. They're pointing at someone that, Shiba, can you dance? By the way, there is an award. That's why you people, is there a dancer here? Someone who can dance. So you people only did law and legal tech and only, you people didn't do anything else? Okay, is there a musician? Someone who can sing? Okay, what can you do? You can clap. But even you have not been clapping. Is there anyone with talent here? We recognize you as the most talented person. Is someone coming? The musician has come, the dancer. Please welcome the most talented person in the room for the for the Big Tech Accountability Summit. The most talented person has come. The IT team, you are discouraging my talented person. Please play for music. She's in my ear, but she has to do something because we have chosen her. Another one has come, ladies and gentlemen, most talented people. Both are ladies. I don't know what the men are doing. Talented people, please come here. So, my talented people. Okay. Ladies and gentlemen, our talent, now we are doing a talent show. We want to make sure that you people here don't only know the law. So, our talented, and after the talent show, you are going to tell me your experience. How has been this summit? Have you gotten something? Has it been an enriching experience? At least that one you can do. That one you can do. Okay. So they are going to bring the microphone and you people give us your, let her first sing for us.
Okay. Hi, everyone. Hey, you guys. Seriously? Some of you didn't eat the chicken here, right? That's the issue. Okay, we are all going to stand up. It's a Friday, but we are like very old people. It's like we are sad. You guys, I need vibe. Everyone up.
We have senior in the building, senior Mr. Sam Watasa. Please go.
Young people, stand up. Joel, please. Up, up, up. Guys, let's be active. DJ, we need a song. Give me some. Okay, let's first shake, you guys. Is it a Friday? Sad here. Okay. Okay, let me just, I know everyone is expecting me to sing. and I know I really have the best voice in Uganda, but I
Oh,
won't
yes.
overdo it.
Please.
I just want all of us to sing together because the mood is very dark. And
Oh.
it's a Friday. All the knowledge we have amassed today, we need to be very active. DJ, you're delaying me. My people will sit down.
Denise, do you have a suggestion? Do you want them to just play any song?
Yeah, any song. Then we all dance together.
Nansanga. Ay, ay, ay.
Ay, ay, ay. DJ.
Nansanga. Ay, ay, ay. Denise is going to preach the word of God to us and pray now that we can't dance. Is that okay? Can you give us a stroke maybe? Can you give us a stroke maybe? Yes. Yeah, follow the leader. Oh yeah. Yes, yes. Come on. This is our stage. Let's enjoy the moment. Who is joining us? No, you need to be at the front. Rhoda, come and join us. Vera, before I mention names, I don't have to mention names, please. Proceed. Chitaka. I believe we can all dance Kachumbali, right? If no, we can try how to dance. Senior was saying something.
No, I was trying to tell you that Teresa is not the best person to train people in dancing, because the last time I saw her try to dance, she didn't do the footwork well. So I was trying to advise that you start with the footwork, I'll do the marking.
Okay. So who would be the best? Denise.
To do what?
I said footwork.
Yes, you demonstrate. You lead, then I show you that you are doing the right thing or the wrong one.
Okay, guys, Senior has said. But now, I don't believe you. For you, can you dance? No. You just...
The reason I'm not attempting to dance is because I don't want you people to get embarrassed with your absence of skill.
Okay.
Try to do for me footwork of 45 degrees for 3 minutes. Don't go to 90, 45.
I can't go beyond that.
If you can't do 45, then you can't dance. That's the beginning. It's the nursery school of dancing.
Wow. Kachumbali. Very much. Thank you very much, DJ. I think let's convene back. And a round of applause to Denise and Liz. You did an amazing job. And the rest that tried to stand. And to everyone, thank you for shaking up and loosening up. But in the meantime, I am going to go table per table to ask everyone. Would really want to hear from you what you learned from this 2 days event, what you benefited from, and how you're going to use this knowledge. What are you going to do about the knowledge that was learned, that you have learned from today's and yesterday's? And above all, what are you going to tune in your life? Or what are you going to improve in what you have been doing? I don't know where to start from. Should I start from the back? Yeah, let me start from him. You tell us what your name is, you tell us your name, and what you have learned. And any other thing that you'd want us to know about you.
Good evening, everyone. My name is Semogabi Gerald Kusima. I am in my 3rd year at Makerere Law School. This is my first day in this event, and I can say it has been very informative. I have gained entry-level knowledge about comparative law and digital protection, which I'm going to use in my writing because I do some legal writing and some research. And I guess something that I want you to know about me is that I am the president of the Rule of Law Club at Makerere. I am also a public speaker at the Gavo Club, among other things. So thank you very much. I've had a good time today.
Thank you, Gavelian, and I am the Vice President of Toastmasters. So after Gavelian, come to Toastmasters.
Good evening, everyone. My name is Nagawa Penina Norin. I'm a former student of IUIU, Kampala campus. I'm done with my IAFO. I'm waiting for LDC, and I'm passionate about data protection. I didn't know we could come yesterday, so we came today. But it has really been nice to learn and to catch up with you, to make new friends in the same field, and to be motivated, and also see people who I want to be like in the next 5 years. So I hope you keep calling us for such sessions so that we can keep learning from you, and it has really been nice. Thank you so much.
Thank you very much. Let me move to the back again. Let me start with the two amazing gentlemen from DPO. Would love to hear from you. How has the 2-day event been?
Thank you very much. My name is Chitio Martin. I am a lawyer and I work with DPO Privacy Center East Africa. Over the past 2 days, I've been privileged to be exposed to how the intersection of data privacy and competition law is very significant beyond what you might see on the face of it. Next, one of my biggest learnings during the summit is also the fact that holding big tech companies accountable is not about fighting them or reducing their profits, but it is about bringing them to the table to understand how best to serve the consumers who are ultimately their clients. The learnings have also been exposed to noticing the power patterns in how these big tech companies operate their businesses. We've just had a panel where the panelists talked about the Google AI overviews. Google is the owner of this platform, and its overviews are also ranking over other publishers. So that somehow unfairly disadvantages other publishers on the World Wide Web. Then also the fact that regardless of all these, whatever we have learned, we need to take action in one way or another through advocacy, strategic litigation, research, among others. And this has also been very common through the 2 days, the fact that the speakers, the panelists all have engaged in these actions towards holding big tech accountability in one way or another. And lastly, one thing that has stood out is the fact that this fight cannot be won solely or alone. It is a work of partnerships. When you look around this room, we can see various partners who have worked together with AdLegal to make this possible. So that shows you the power of partnership in this journey of holding big tech accountable and mostly protecting the Africans on the continent. Thank you very much. I remain Chitio Martin.
Thank you very much, Martin. What I have learned from Martin is you cannot do anything and achieve everything if you're going to do it alone. It's Ubuntu. Do it with a team of people. Share your vision so that you can maneuver around through the world. How about you? We would love to hear from you.
Thank you very much. My name is Namgira Joel Peter. I'm a lawyer. I work with DPO Private Center East Africa as the team lead. Most of the things have been said by Martin, most of the key takeaways, but for me, I would mostly commend AdLegal for hosting such big events here. You may, if you're very keen, you realize that most of the big discussions are across the region here. Most go to Nairobi. It's either Nairobi or Kigali. So we haven't had a chance to attend similar discussions in Kampala, and yet we are very interested in the discussions going on, and maybe majority of us may not have the capability to board and move to the other countries, unless if you push hard. So I commend them to that regard, and we hope to see similar discussions still here, and we'll be attending actively. Yes, thank you.
Let's also hear something from Denise. She says she has something.
Hello, everyone. Well, for me, I just want to thank the young brains behind AdLegal. They're very, very innovative, and honestly, I don't even think the sky is the limit. So keep it up and well done. I'm very proud of them. Thank you.
They say the sky is the limit, but always remember you are limitless. You have a lot of potential in everything you do. Any remarks? DJ, play us some soft music. Ladies and gentlemen, I don't want to see you on your phones. Your neighbor is somewhere at the other side. You don't know what she does, or you don't know what he does. Please talk to people. Connect, network. That is why we are here. Apart from learning, we're also here to network. So it's good to network, right? I see people on their phones. Please. Please network with people at the back. Meet a friend, make a friend. I don't know if everyone here knows who Drake is, what Drake does. So move to him and ask him. It would be better because that's why we are here, right? Your network is your net worth. DJ? I'm now going to give people fines who are seated alone. Yes, you need to sit with someone, talk to someone, get to know what everyone does. End the day at least with a business card. I see Martin. Thank you, Martin. Oh, I see Martin. I see Denise standing up. Thank you, Denise. The CEO of Journey to the Boardroom always says one thing: be the first person to take the first initiative. So meet someone, talk to someone. Yeah, meet me and talk to me. Tuogere. Njagala kwogera naye. I think this is a beautiful spirit I'm seeing.
Thank you so much, ladies and gentlemen, our distinguished guests, for the patience and time you've rendered unto now. As communicated earlier on, we were honored to partner with the Africa Center for Law and Public Interest Technology and organize an awards ceremony to honor some of the individuals we believe have created impact through their respective works, and these are in different categories, as we shall hear. So yes, so on that very note, because we've kept you waiting and there is something waiting for us down, allow me welcome and invite the Executive Director of the Africa Center for Law and Public Interest Technology, Ms. Vera Kabasita Nakatumba, to preside over this event, the awarding ceremony. Round of applause to the Eid.
Thank you, Mr. Kamoga. All protocol observed. Good evening. And I'm Vera Kabasita Nakatumba, the ED of African Center for Law and Public Interest Technology, and I would like to thank AdLegal for convening this Big Tech Accountability for Africa, the summit. Just weeks ago, the COMESA Competition and Consumer Protection Commission found a prima facie case against Meta, AdLegal as well, and that tells us something very important, that in Africa, we actually have the laws. Yes, they have been enacted. And with the right force, we shall be able to hold all these big tech companies accountable. Yes, because where we are going right now, it's technology everywhere where we are going. The future is technology. So when we have the right laws, the right forces, then we are headed in the right direction. And at SCPIT, some of our objectives include, to conduct independent, high-quality research on the legal, regulatory, and ethical dimension of emerging technologies, including artificial intelligence, blockchain, digital identity, and data protection. We intend to advise governments, regulators, and public institutions on developing and strengthening legal policies. And we also intend to support justice by promoting the responsible use of legal technology, digital justice initiatives, and innovations. I'll be very brief because of time. You've been very patient and I don't want to keep you here any longer. And on that note, I would like to invite the Vice Chairperson of COMESA, Mr. Watasa, to come and hand over the awards to their recipients. In the future, we shall pay you, yeah, very handsomely. So the first award is the Lifetime Achievement Award, presented to Babatunde Irukera in recognition of your exceptional lifetime of leadership, public service, and commitment to advancing competition law, consumer protection, and fair digital markets across Africa. You're welcome. The second award, it's for outstanding contribution to digital competition law reform in Africa award, presented to Leonard Otuonye Ugbaja in recognition of your outstanding leadership and invaluable contribution to the development of digital competition law and regulatory reform across Africa. The next award is for excellence in data protection and privacy litigation. Private Litigation Award for Impact in Africa, presented to Dr. Olumide Babalola in recognition of your outstanding contribution to data protection and privacy litigation in Africa, and for inspiring a generation of African data protection and privacy practitioners. The next is the International Partner Award for advancing digital competition enforcement in COMESA region, presented to Jeremy Andre in recognition of your international partnership and contributor to advancing digital competition enforcement in the COMESA region through provision of technical expertise, practical knowledge, and strategic resources to regulators and legal practitioners. The next is an Excellence in Digital Competition Scholarship and Publications Award, presented to Dr. Vela Kigwiru in recognition of your exceptional scholarship and influential publications that have advanced the understanding and development of digital competition law in Africa. Okay, maybe Aziz will get it for me. And the last award, Excellence in Competition Law and Economics Research Award, presented to Professor Simon Roberts in recognition of your outstanding contribution to competition law and economics research and your pioneering role in building a strong culture of competition scholarships across Africa. It will not break. Yes, that's it. Thank you very much. Thank you very much, Adligo, for partnering with us, and we look forward to working with you in the future. I'll now hand over to Mr. Kamoga Luke, Chairperson of the Organizing Committee for this summit. Thank you.
Thank you so much, the African Center for Law and Public Interest Technology, for taking us through this amazing part of the summit. You know, sometimes we do things, but sometimes we don't do sometimes we ourselves don't see the impact we do. We create, but then the people outside the circle normally recognize these impacts. Now, thank you so much, and these awards have been presented in partnership, and they have been heartfelt awards, which we think resonate to the impact that the individuals awarded have created on the African continent. So thank you so much, Vera. Thank you so much, Mr. Tony Galandi. Thank you so much, Mr. Sam Watasa. So without wasting any time, the ED already closed the summit. I think I now wish to invite every one of us at the cocktail down, network, let us reflect upon the insights that have been shared throughout the summit. I know there is a lot, but Mr. Sam Watasa normally encourages us to always focus and look forward to where competition law practice in East Africa and the commercial region is heading to. And that route is already inevitable. So there is so much we can think about, there is so much we can do as the young generation in the practice. Thank you so much, and have a lovely evening.
Thank you.